2025 was a masterclass in legal incompetence, and there was no way to pare this list down to just the top 10. So let's go with the top 15 most incompetent lawyering of 2025. And we start with that time that Trump's incompetent lawyer leading the Comey prosecution started texting our very own Anna Bauer. And no, Lindsay, this is not off the record.
Lindsay Halligan reportedly spent some 33 hours texting with a reporter.
A 33-hour signal text exchange with one of their reporters.
Anna Bauer
posted
the entire text chain. Anna Bauer is my source here tonight.
Yep, that's me. You're probably wondering how I ended up in this situation. It all started at 1:20 p.m. on a Saturday in October. I was lounging in my pajamas, scrolling Netflix. It was a rare day off. Then my phone buzzed, and to my surprise, it wasn't a spam email or my editor or my DoorDash order. It was this woman, Lindsay Halligan, the top federal prosecutor in the Eastern District of Virginia and the person who is personally prosecuting one of the president's perceived political enemies, New York Attorney General Letitia James. And she was texting me about that very case. So began my 2-day text marathon with the most high-profile prosecutor in the country. Over the next 33 hours, Halligan texted me again, and again, and again, and again. But before we get to the weirdness of it all, let's rewind a little bit, because this story really began a few weeks before Halligan even texted me. As with many Trump world stories, this one starts with someone getting sacked. And that someone in this story was Eric Seibert, who until last month was the U.S. Attorney in the Eastern District of Virginia. As Liz Dye explained on a different video on this channel, Seibert reportedly raised doubts that there was enough evidence to bring criminal charges against 2 of President Trump's perceived foes. The first being New York Attorney General Letitia James, who won a $450 million civil fraud verdict against the Trump Organization, and the second being former FBI Director James Comey, the guy Trump blames for initiating the so-called Russiagate investigation. For years, Trump has publicly said that Comey and James should be punished for something.
Hey, what about Comey? You watch him on the interviews? Comey's a liar and a leaker.
But Seibert did not think there was enough evidence that James and Comey did anything criminal, so he pieced out. But then things got weird. Trump wrote a direct message to his Attorney General, Pam Bondi, directing that she prosecute his enemies. But Trump hit post instead of send, blasting the message to all 9 million followers on Truth Social. Trump then installed a new top prosecutor in the Eastern District, Halligan, his former personal attorney, who until now had never prosecuted a case. And despite her lack of prosecutorial experience, Halligan made good on Trump's demands to prosecute his adversaries. Within days of her arrival, she secured an indictment against Comey, and then 2 weeks after that, she persuaded a separate grand jury to indict Tish James for mortgage fraud. This is around the time that I entered the picture, on Saturday, October 11th. I'd spent much of that morning catching up on news stories about the case Halligan brought against James, which had just been handed up a few days earlier. The indictment accuses the New York Attorney General of misrepresenting how she intended to use a Norfolk, Virginia property when she applied for a loan to purchase it back in 2020. Prosecutors say that James told lenders the property would be used as a second home when, in reality, she used it as a rental investment property, renting the property to a family of 3. The indictment further alleges that James did this to obtain more favorable mortgage rates. Now, when the James indictment dropped, I was decidedly among the skeptics, not just because of the apparently retaliatory nature of the charges, but also because it just wasn't clear to me that the facts alleged amounted to a crime at all. To understand why, let's look at the mortgage agreement James signed. The agreement used standard Fannie Mae language, and it required James to treat the property as a second home. That means that she had to keep the house, quote, available for personal use, but importantly, the contract permitted James to rent the home after 1 year of ownership, and it allowed occasional renting within the first year. That is really key because one of the main claims in the indictment is that James declared, quote, thousands of dollars in rent on, quote, tax forms. But the details are really vague. What were the circumstances of the supposed rental agreement? When exactly did James allegedly rent the home, and for how long? How much rent money did she collect? Without knowing those details, I found it really difficult to determine whether Tish James had violated the mortgage contract, much less whether she committed fraud. All of which is why, on Saturday, October 11th, I took particular interest in a New York Times story about the Virginia home at the center of the Tish James case. According to the report, the house is occupied by James's grandniece, a woman named Nakia Thompson, who has lived there with her children since James purchased the home back in 2020. The report goes on to present 3 key pieces of information. First, that Thompson appeared before a grand jury in Norfolk, not Alexandria, where James was indicted. 2, that Thompson testified, quote, she had lived in the house for years and that she did not pay rent. And 3, Thompson was not asked to testify again. All of which means that it's not clear if the grand jury in Alexandria, the one that indicted Tish James, even heard that testimony at all. So if you know that the supposed tenant says that she's not paying rent, you probably should tell the grand jurors that. But did Halligan do that? Well, we don't know since grand jury proceedings are secret. If the New York Times report is true, Thompson's grand jury testimony seems to undercut the prosecution's theory that James used the home as a rental investment property. And as I saw it, the evidence would be exculpatory in that it tends to show that James did not primarily use the property as a means to collect rent. And a big part of my job as a legal journalist involves sharing these kinds of observations online. So, of course, I decided to share the New York Times article on Twitter. Shortly after noon on October 11th, I tapped out a post linking to the Times article and summarizing it as follows. New York Times reports that Letitia James's great-niece lives in the home that is the subject of the indictment. The niece reportedly testified before a different grand jury, telling them that she had lived there for many years without paying rent. James visits regularly. A few minutes later, I followed up with a second observation about the exculpatory nature of the evidence. This is important exculpatory evidence because the indictment accuses James of seeking a second home mortgage when in reality, she intended to use it as an investment home by renting it. I didn't think much of the tweets at the time. Sharing other journalist reporting is a very routine part of how I try to keep people apprised of the cases I follow. But Lindsay Halligan, the prosecutor who personally presented James's case to the grand jury, apparently saw my tweets very differently.
Hey, Anna, sorry to interrupt. Nice desk you got there. But the steps that you had to take to actually verify you were speaking with the real Lindsay Halligan is a good reminder of just how easy it is to be tricked by imposters, hackers, and scammers. Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. Incogni also just launched a new feature called custom removals for subscribers to their unlimited plan that I think is really great. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. And also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years. In that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take weeks. So thank you, Incogni, for saving me the time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. But Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click over here for more LegalEagle, or I'll see you in court.
So this brings me back to 1:20 p.m. that Saturday when my phone buzzed and I looked down and saw that I had a connection request on Signal, which is an encrypted messaging service that many journalists use to communicate with their sources. The first message read, "Anna, Lindsay Halligan here. You are reporting things that are simply not true. Thought you should have a heads up." The user on the other end had selected a setting to make all the messages in the chat disappear after 8 hours. So naturally, being a journalist, I started taking screenshots. Even so, I assumed that this was some kind of weird hoax, maybe a troll or a disinformation campaign. Because why would the most scrutinized federal prosecutor in the country reach out to me about a tweet that summarized another reporter's coverage of grand jury testimony? It just didn't make sense. But I knew there was an easy way to test whether this could really be Lindsay Halligan. Because I'd met Halligan once before, a few years ago in a restaurant at the Breakers Hotel in West Palm Beach, Florida. At the time, the Justice Department was investigating Trump's handling of classified documents, and Halligan was one of the lawyers. I ran into her and another Trump attorney, this guy named James Trusty, after covering a hearing before Judge Eileen Cannon. I had not talked to Halligan in 3 years since that meeting, but I did suspect that the real Halligan would remember me. So, to verify her identity on Signal, I asked her where we first met and who she was with. The person purporting to be Lindsay Halligan responded just 1 minute later. "Breakers, Trusty, got your name from your ex account," she said. This changed things. I'd never publicly mentioned that encounter with Halligan and Trusty. And as improbable as it had seemed a minute before, I concluded that the actual Lindsay Halligan probably was texting me. The Justice Department later confirmed that I really was texting with Halligan. But at the time, I was pretty confident that it was her. So I did what any reporter would do. I started asking questions. "Okay, I'm all ears," I said after thanking her. "What am I getting wrong?" "Honestly, so much," Halligan replied. "I can't tell you everything, but your reporting in particular is just way off." She then said it was clear to her that I jumped to, quote, "biased conclusions" based on what I read rather than truly looking into the evidence. I felt confident that Halligan was alluding to one of the tweets I'd posted earlier that afternoon, because other than the tweets, I had not published anything of substance about the James case. But to confirm, I sent Halligan a link to my tweet summarizing Thompson's grand jury testimony as reported by the New York Times. So I asked her, "Are you saying that something I said in this post is inaccurate? And if so, what?" Halligan replied, "You're assuming exculpatory evidence without knowing what you're talking about. It's just bizarre to me. If you have any questions before you report, feel free to reach out to me. But jumping to conclusions does your credibility no good." Halligan's real beef seemed to be with the Times, not with me. But she wasn't saying what was wrong with the Times' reporting either. Now, my post explicitly credited the Times story, not my own reporting. So I asked, did they get something wrong? "Yes, they did, but you went with it," she said, without even fact-checking anything. Then she added this, "and they are disclosing grand jury info, which is also not a full representation of what happened. I guess I expect them to do that, but I was surprised by you running with it." Now, note that there is nothing improper about the New York Times disclosing grand jury information. The rules of grand jury secrecy are codified in Rule 6E of the Federal Rules of Criminal Procedure, and they don't apply to the press. And they don't bind defense lawyers or witnesses either. So if, say, Thompson or her lawyers had dished to the New York Times about her testimony and the Times had then reported her account, nobody would be violating any rule. On the other hand, it is generally improper for prosecutors to disclose matters that took place before a grand jury. Rule 6E very explicitly covers an attorney for the government, and it very specifically prohibits government attorneys from disclosing a matter occurring before the grand jury. Now, internal Justice Department policies also place detailed restrictions on prosecutors' disclosure of matters before the grand jury. So, this is why my dialogue with Halligan struck me as so unusual. The strict rules around grand jury secrecy are one of many reasons why Justice Department officials usually just say no comment whenever asked about ongoing prosecutions or cases. It's standard practice for the department to instead say that it will speak through its court filings. Yet here was Halligan reaching out to a reporter to complain about tweets concerning another publication's coverage of grand jury testimony. It all seemed out of character for a federal prosecutor. Still, I wanted to know what Halligan thought I got wrong. And I told her that I'd be happy to retract or correct anything I tweeted that was untrue. I asked, "Can you be more specific?" Halligan pointed me to the indictment. It says she received thousands of dollars in rent. Presumably, she refers to Letitia James here. Then Halligan added, "I can't tell you grand jury stuff." Now, at this point, I broadly understood Halligan to be conveying a few things. The first is that the New York Times story did indeed disclose grand jury information, but that she believed some part of its account was inaccurate or didn't capture the whole picture or something. The second point is that Halligan seemed to be focused on the paper's account of Thompson's testimony, which I had summarized in my tweet. As I understood it, she was responding in some way to the substance of that testimony, specifically that James's grandniece did not pay rent, by directing me to the indictment, which alleged that James reported thousands of dollars in rental income on tax forms. But here's the thing. The indictment itself doesn't necessarily contradict Thompson's reported testimony. I had interpreted the Times to be saying that Thompson was not currently paying rent and that she had gone for years without doing so, not that she had never paid any rent at any point. Meanwhile, the indictment's wording on this point is pretty odd and ambiguous. As we've discussed, it doesn't specify the timing or the amount of money and rental income that Tish James supposedly reported on her tax forms. And look, it's true that the tax forms mentioned in the indictment aren't publicly available, but Tish James's state ethics disclosures are publicly available. And if you look at those disclosures, they show that Tish James reported rental income on the Norfolk property only once. And that was way back in 2020 for a relatively small sum, like between $1,000 and $5,000. So the idea that James might have collected a relatively small amount of money in rental income at some point half a decade ago didn't, to me, contradict the idea that Thompson has lived there for years without paying rent. It also doesn't show that James violated her mortgage agreement, given that the contract allowed occasional rentals, even during the first year. Look, don't get me wrong, it's totally possible the evidence at trial will show otherwise. But Halligan had approached me to say that I got something wrong. And what she pointed me to in the indictment just didn't on its face contradict the testimony I had summarized in my tweet. So I still wasn't sure what Halligan was trying to tell me. Was she suggesting that Thompson had lied to the grand jury, or that the Times had mischaracterized Thompson's testimony, or something else entirely? I tried to explain all of this in my next text. I'm still not sure I understand what's incorrect about the New York Times account or my summary of it. Halligan replied, "Anna, you're biased. Your reporting isn't accurate. I'm the one handling the case and I'm telling you that. If you want to twist and torture the facts to fit your narrative, there's nothing I can do. Waste to even give you a heads up." In response, I reminded Halligan that it was she who had approached me to tell me that I'd compounded or repeated something inaccurate in the New York Times' account of Thompson's testimony. I am happy to correct it, but I can't do that without a sense of what I supposedly got wrong. Halligan replied, "Continue to do what you have been, and you'll be completely discredited when the evidence comes out." I still wasn't sure what I'd supposedly gotten wrong, or why she'd contacted me, or really what to make of it all. And for what it's worth, the New York Times doesn't know either. In a statement provided to me during the course of my reporting on this story, the paper said that the Justice Department had raised no issue with the Times about its story. We're confident in the accuracy of our reporting. The DOJ declined to comment before publication and has not raised any concerns with us since the story was published more than a week ago. So, just to be clear, the United States Attorney did not reach out to the New York Times about its reporting, but she reached out to me about my summary of the Times' reporting. And to me, it was clear that we'd reached the point of diminishing returns. So we left it there, at least for a few hours. Later that evening on Saturday, I followed up with Halligan. She had told me that I could feel free to reach out to her if I had any questions, and I wanted to find out if she was serious about that. Saturday night, I wrote, "I'm curious for your thoughts more broadly. What are you most frustrated that reporters aren't focusing on or writing about with respect to this case?" She replied, "No frustration generally. You're the only reporter I reached out to." The next day, I tried again. I asked if I should expect additional charges against Tish James because the Wall Street Journal had reported over the weekend that Halligan might bring additional charges. Halligan replied, "You don't report fairly." Then she added, "I can't discuss any potential charges with reporters. If evidence arises that warrants further charges, I'll look into it." I was genuinely confused by this because only the previous day she'd essentially invited me to fact-check other outlets' reporting before tweeting about them. Now she was refusing to engage with me when I did exactly that. "I thought you said I was welcome to reach out to you about what other outlets are reporting." She wrote back, "Why do you report on what other outlets are reporting? If I was you, I'd develop sources myself and outcompete them all. I expressed my confusion in my next message, asking if she had reached out just to insult my reporting. She replied, "No, it was for you to correct it, which you refused to do." And I know, it's so wild. And with that, we'd come full circle, back to my tweet summarizing the New York Times article. Something about it had seemed to really strike a nerve with Halligan, but I still couldn't figure out exactly what or why. "I am more than happy to correct it, but you still haven't told me what's incorrect," I said. "What precisely is wrong with the tweet?" Halligan didn't respond. Over the next several days, I followed up twice more, asking Halligan for her perspective on a variety of questions I had about the Tish James case. My texts went unanswered, and by the end of the week, this much was clear. United States Attorney Lindsay Halligan was ghosting me. I can't believe I got ghosted by Lindsay Halligan. What? Now, to be clear, it's not uncommon for federal prosecutors to communicate with the press, but my exchange with Halligan was highly unusual for a number of reasons. So let's step back for a minute and talk about why all of this is just so bizarre in the world of federal prosecutions. The list of eyebrow-raising elements in all of this is long. 1, the communication was unsolicited. 2, she reached out to me, a reporter she barely knew, to complain about a tweet that merely summarized someone else's reporting. 3, the conversation concerned an ongoing prosecution that she is personally handling. 4, several of her messages alluded to grand jury matters, which are protected from disclosure under federal law. 5, the whole exchange took place on Signal with disappearing messages, which raises questions about compliance with the Federal Records Act. And look, as a legal journalist covering the Justice Department, I had never encountered anything quite like my exchange with Halligan. Neither had my editor. I spoke with multiple former federal officials and legal journalists. No one could recall a similar instance in which a sitting United States attorney communicated with a journalist like this. Even more bizarre is the fact that this exchange happened in the context of Halligan being the most scrutinized prosecutor in the country, widely seen as handpicked to prosecute her boss's political enemies. She should know as well as anyone that even her slightest misstep or error is bound to be seized on and picked apart by defense counsel representing Tish James. The irony of all this is hard to ignore too. Just days after she texted me, Halligan reportedly fired 2 senior career prosecutors for supposedly leaking unauthorized information to the press. And that same week, she released a statement in response to an MSNBC story about a separate case against a Democratic state lawmaker. EDVA enforces a strict zero-tolerance policy on unauthorized disclosure of information concerning ongoing investigations or cases, she said. And in that same story, Justice Department spokesman Chad Gilmartin is quoted as saying, "While we do not confirm the existence of nor comment on specific investigations outside of our public filings, any department employee who leaks deliberative or investigative developments only jeopardizes the integrity of investigations and the incredible work of federal law enforcement." For someone so attuned to the risks of speaking out of turn and so willing to punish others for allegedly doing so, Halligan's decision to reach out to me over text about an ongoing case was honestly just baffling. She knew that I was a journalist. She approached me. She invited my questions. She even encouraged me to stop chasing other reporters' stories and focus on my own. For some reason, she didn't seem to realize that I already had a story. And that story was our text messages. All of this is why I decided to report on these texts. And the messages were clearly fair game for reporting because there was one important thing Halligan had not said during the entirety of our communications. Off the record or on background or anything whatsoever about the terms on which we were talking. This is a key journalistic point. The default assumption when a reporter speaks with a public official is that everything is on the record, meaning that anything the source says can be quoted and attributed to the source in the paper. If the source wishes to speak confidentially, she can negotiate how the information will be used. On background means that the information the source provides to the journalist can be published so long as the journalist doesn't reveal the source's name or identifying information. Meanwhile, off the record means the reporter can't print what the source tells them at all. There are other variations too, but with any condition, a fundamental premise is that the reporter must agree to speak with the person on that basis. This is a two-party consent situation. There are other variations too, but if a source, especially a public official, wants to speak off the record, they have to request to go off the record, and the reporter has to agree. And there's no takesy-backsies. A source can't just retroactively declare everything I just said is off the record. You have to establish the basis on which you're speaking in advance. In the course of my work as a journalist, I frequently agree to speak with sources on background or off the record. I take my duty of confidentiality seriously, and I have never burned a source by revealing confidential communications, and I never will. I certainly would have been willing to speak with Lindsay Halligan on background or off the record, but she never once raised the terms on which we were speaking at any point during the 2 days in which we exchanged texts. And it's not as if Lindsay Halligan didn't understand the rules of engagement with the press. She has an undergraduate degree in broadcast journalism. For years, she worked as a member of Trump's criminal defense team, which routinely courted media attention even as it accused prosecutors of improper leaks. And now, as a prosecutor herself, Halligan has accused former FBI Director Comey of lying about whether he authorized a colleague at the Bureau to serve as an anonymous source in news reports about an ongoing investigation. A central issue in that case, which Halligan reportedly presented to the grand jury herself, concerns the nature of interactions between reporters and federal law enforcement sources. This is why Halligan's response to my story added an additional layer of bizarro to an already really strange situation. Before I published my text with Halligan, I reached out to the Justice Department's Office of Public Affairs seeking comment on the story. That's basic journalistic practice. In addition to providing a transcript of my signal exchange with Halligan, I outlined some questions I had related to the whole thing. Were these authorized communications? Does the department take the position that the contents of the messages are consistent with its legal obligations and DOJ policy? Does Halligan deny that these texts were in fact her text? That kind of thing. I told the Justice Department that my deadline was 4:15 p.m. on Monday, October 20th. In response, the United States Justice Department sent me a statement that read as follows. You clearly didn't get the response you wanted, which was information handed over to you without having to dig into the facts of the case to craft a truthful story. So you thought you'd tattletale to Maine justice. Lindsay Halligan was attempting to point you to facts, not gossip, but when clarifying that you would adhere to the rule of law and not disclose grand jury information, you threatened to leak an entire conversation. Good luck ever getting anyone to talk to you when you publish their text. The statement misspelled Lindsay Halligan's name. It also accused me of being a tattletale and claimed that I was threatening to leak a conversation, which again, Halligan had never suggested was off the record. In addition, just a few minutes before the deadline, my dormant signal connection with Halligan suddenly came to life again. At 4:10 p.m., she texted me, "By the way, everything I ever sent you is off record. You're not a journalist, so it's weird saying that, but just letting you know." I responded, "I'm sorry, but that's not how this works. You don't get to say that in retrospect." Halligan was unpersuaded. "Yes, I do, off record." I replied, "I'm really sorry. I would have been happy to speak with you on an off-record basis had you asked. But you didn't ask, and I still haven't agreed to speak on that basis. Do you have any further comment for the story?" To my surprise, Halligan kept going. "It's obvious the whole convo is off record. There's disappearing messages and it's on Signal. What is your story? You never told me about a story." I didn't respond immediately. It was time to publish my story. So I did. And I sent it to her in a text. She left me on read.
Thanks, Anna. That is just completely insane. Now that's where Anna had to stop, because Anna and Lawfare find themselves actually in the middle of all this litigation now that they are percipient witnesses to what seems to me like misconduct. Because you might have been listening to the story and thought, hey, it seems like it should be illegal that the prosecuting U.S. attorney was discussing secret grand jury testimony and using an illegal disappearing text app to communicate with a legal journalist. And frankly, I think you are exactly correct. And that thought also occurred to Letitia James's attorney, Abby Lowell, who just filed a motion for the court to take action against Halligan for her actions, and he raises these exact points. So I will pick up where Anna left off and talk about the legality or lack thereof regarding Halligan's actions. And I think James's motion covers this really well. It starts by saying, quote, Rule 6E establishes a general rule of secrecy for grand jury matters that provides that certain persons, including government attorneys and investigators, shall not disclose matters occurring before the grand jury, except under limited and discrete exceptions. Given the immense power of the government to investigate the conduct of private citizens and public officials, Rule 6E creates clear, bright-line prohibitions to protect against the abuse of that power. To that end, it prohibits disclosure of, quote, anything that may reveal what has transpired before the grand jury to protect the freedom and integrity of the deliberative process. Ms. Halligan's commentary on evidence heard during grand jury proceedings, including whether grand jurors heard exculpatory evidence, violates this key protection. And James goes on to argue that the action violates federal regulations 28 CFR section 50.2. Quote, like the federal rules of criminal procedure, the Code of Federal Regulations also has clear rules prohibiting DOJ prosecutors from improperly releasing extrajudicial statements or information. For example, section 50.2b, titled Release of Information by Personnel of the Department of Justice relating to criminal and civil proceedings, provides that in criminal matters, at no time shall personnel of the Department of Justice furnish any statement or information for the purpose of influencing the outcome of a defendant's trial, nor shall personnel of the department furnish any statement or information which could reasonably be expected to be dismissed by means of public communication if such a statement or information may reasonably be expected to influence the outcome of a pending or future trial. Critically, it continues, quote, disclosure should include only incontrovertible factual matters and not include subjective observations. And James's motion goes on to explain why the acts also very likely violate the local rules for the Eastern District of Virginia, the rules of professional responsibility for lawyers, and the Department of Justice manual. And while it's not the focus of the motion, they also point out in a footnote that it's very likely Halligan violated the Federal Records Act by using Signal, which we covered when, Hegseth had his whole insane disclosure of war plans via Signal. But the motion goes on to say, in addition to apparently violating the rules addressed in the section, Ms. Halligan admitted in her exchanges with the journalist to a likely violation of the federal records laws and rules around using unapproved electronic messaging accounts. See 44 U.S.C. section 2911, restricting officer or employee of an executive agency from sending messages using a non-official electronic messaging account. Ms. Halligan acknowledged she was using an unofficial messaging application, Signal, with its disappearing messages feature enabled and set to automatically delete after 8 hours. Trying to delete the paper trail of improper communications does not mean they did not occur. For this reason, Attorney General James also asked the court to order government attorneys and agents involved in this case to follow relevant laws around records retention and to impose a litigation hold preventing the deletion or destruction of any records or communications having anything to do with the investigation and prosecution of this case. Attorney General James will pursue the apparent violation of the law with the appropriate offices. And yeah, I think that summarizes it nicely. I will only go on to point out that the Federal Records Act covers executive agencies. The FRA was amended in 2014 to restrict the use of non-official electronic messaging accounts like email, Signal, or WhatsApp for official business, unless the message is copied or forwarded within 20 days to an official account. And the U.S. Attorney's Office is a component of the Department of Justice, which is a covered agency for purposes of that law. And in some contexts, there could be criminal penalties. But of course, under current SCOTUS thinking, that requires an executive that actually cares about breaking the law to enforce those laws. So yeah, still, the judge is likely to take this seriously, even if the Department of Justice is not. But if you ever need a good lawyer, I know a guy. Well, if you put your money on the Trump-Musk friendship lasting fewer than 6 months, congratulations! You win, which you can do with today's sponsor, DraftKings. I'm just kidding. We are absolutely not sponsored by DraftKings, but I'm just saying. Now, we knew something was off when Musk showed up to his Oval Office going away party with a black eye. But the fight officially started when Musk called Trump's, I hate to say this, one big beautiful budget bill, quote, a pork-filled abomination. And by the end of the day, Musk claimed that Trump was in the Jeffrey Epstein files, which didn't everyone already know? But at any rate, Trump threatened to cancel all of Musk's government contracts, and then all hell broke loose. Now, setting aside how potentially dangerous this is for the world's most unstable superpower, I have to admit this day was actually pretty great. As Jay Willis said, quote, it was the most fun day we've had on the internet since Trump got COVID. Some said the spat was like illegal alien versus sex predator, and it left Kanye feeling bereft, saying, bros, no, we love you both so much. And of course, Kanye speaks for everyone. Some right-wing influencers suggested that Trump should be impeached, and Musk agreed, and Musk got trolled by the Polish foreign minister, quote, see, big man, politics is harder than you thought. Ukraine chimed in with a meme trolling Trump, quote, Zelensky has promised to bring peace peace between Musk and Trump within 24 hours. And the mother of one of Musk's children, Ashley St. Clair, tweeted, quote, "Hey, real Donald Trump, let me know if you need any breakup advice." But the best summary came from Anna Hughes. "This is like Drake and Kendrick, but they're both Drake." Now, I've just spent 5 months analyzing all of Donald Trump's unconstitutional acts, and oh, by the way, we still don't know who the administrator of Doge is, and Trump still has 3.5 years left on his second term. In general, I am pretty tired, so let me have this. And is this an excuse to engage in some much-needed schadenfreude? Yes, but I promise there is a legal angle to all of this. Now that Musk has burned Trump harder than a Tesla battery recall, Trump is poised to retaliate. So today we're going to break down the legal consequences of the Trump-Musk divorce. And spoiler alert, this may be the greatest leopards eating faces moment of all time. But first, we must engage in some schadenfreude. Now, although it may seem like a bromance written in the stars, it's worth remembering how short-lived the Trump-Musk relationship really was. Musk didn't endorse Trump until July of 2024. He then manipulated Twitter to promote the campaign and poured about $300 million into the presidential race in Trump's favor. And in fact, the Trump campaign outsourced its ground game to Musk. And instead of traditional outreach, he offered money to canvassers and then allegedly failed to pay them. He flirted with running illegal lotteries by paying voters $1 million to sign petitions and listen to him speak. And it seemed to have worked. Musk started Doge, and Trump let him take a wrecking ball to the civil service, terminating thousands of employees and illegally withholding billions of funds. He sat in on cabinet meetings, and the acting U.S. attorney for D.C. threatened to jail anyone who crossed Doge employees. The Attorney General and the FBI started a terrorism task force to prosecute people who vandalized Teslas, and the federal agencies that were investigating Musk's companies for breaking the law conveniently stopped investigating. And Trump even turned the White House lawn into a car lot and encouraged everyone to buy Teslas. So everything was going great, except for a couple of things. Trump's staff apparently hated Musk and the influence he had over the president, and Musk forgot the absolute #1 universal rule when dealing with Donald Trump, that there's basically no one Trump won't betray if it serves his personal interests, except for Vladimir Putin. So it seems that Musk's official downfall started in April, when he failed to deliver on his promise to buy Republicans a Wisconsin Supreme Court seat. The Democratic candidate won, and Musk started fading into the background. And of course, Musk completely 100% failed on his promise to remove $2 trillion from the federal budget. Musk apparently grew frustrated with Trump's tariffs, and when Musk announced that he was leaving Doge, Trump planned an Oval Office news conference to say farewell. But behind the scenes, hostilities seemed to be brewing. Musk was furious about Trump's decision to withdraw the nomination of Jared Isaacman, a Musk ally, to run NASA, and shortly before Musk's send-off, a Trump aide named Sergio Gore gave Trump a file showing that Isaacman made donations to Democrats. Insiders say Gore was angry that Musk criticized his management of the White House Personnel Office, and less than a week later, Musk went nuclear on Trump. The day started with a Trump news conference with German Chancellor Friedrich Merz. Trump kicked off the meeting with his typical flair, expressing sympathy for some of the worst people in history. When Trump mused about how D-Day was a sad day for the Germans, Merz cut in, quote,
"This was the liberation of my country from Nazi dictatorship."
But by the time Merz was finished explaining that Nazis were the bad guys, Trump's mind had moved on to other things, like Elon Musk taking credit for the election and not liking his big, beautiful bill. But Musk did not take this lying down. He tweeted, quote, "Without me, Trump would have lost the election, Dems would control the House, and the Republicans would be 51-59 in the Senate." And Musk accused Trump of, quote, "such ingratitude." Musk pointed out that the Congressional Budget Office said Trump's budget bill would increase the deficit. He started digging up Trump's old tweets about the deficit, some from as far back as 2012, when Trump said no member of Congress should be reelected if their federal budget isn't balanced. And Musk spent the rest of the day attacking the budget bill, calling it a disgusting and pork-filled abomination. He criticized the $2 to $5 trillion debt impact and cuts to electric vehicle incentives. He said, quote, "keep the EV solar incentive cuts in the bill, even though no oil and gas subsidies are touched. Very unfair. But ditch the mountain of disgusting pork in the bill. In the entire history of civilization, there has never been legislation that both big and beautiful." Everyone knows this. Either you get a big and ugly bill or a slim and beautiful bill. Slim and beautiful is the way. And Trump fired back on Truth Social, posting the quote, "Elon was wearing thin. I asked him to leave. I took away his EV mandate that forced everyone to buy electric cars that nobody else wanted, that he knew for months I was going to do, and he just went crazy." After Trump suggested that Elon was wearing thin, Musk tweeted that it was, quote, "such an obvious lie," but Musk would later delete that tweet after he cooled off. Trump said that Musk knew what was in the budget bill and was just bitter about the EV credit ending. He claimed that Musk now has Trump derangement syndrome.
I'll tell you, he's not the first. People leave my administration and they love us. And then at some point they miss it so badly, and some of them embrace it and some of them actually become hostile. I don't know what it is. It's sort of Trump derangement syndrome.
After the news conference, Musk started responding to Trump in real time on Twitter. First, he denied ever seeing the bill, quote, "False, this bill was never shown to me even once and was passed in the dead of night so fast that almost no one in Congress could ever read it. Also, why a bill would be shown to Elon is beyond me. It's sort of nuts that Musk, who is not a member of Congress or a member of Trump's cabinet, thought he was entitled to review the full bill, which is hundreds of pages long, and then presumably have a veto power over things that he doesn't like. But this underscores the danger of the world's richest person buying the presidency. And just to emphasize that Musk believes the Republican literally owes him, he polled his followers on whether he should start his own third party. Musk didn't let up. He tweeted that the budget bill should be called, quote, "the big ugly bill." So Musk tweeted that lawmakers should side with him in the budget bill fight because, quote, "Trump has 3.5 years left as president. I will be around for 40 plus years." And in response, Trump threatened to revoke federal contracts for Tesla, SpaceX, and Starlink. Quote, "The easiest way to save money in our budget, billions and billions of dollars, is to terminate Elon's governmental subsidies and contracts." I was always surprised that Biden didn't do it. Musk dared Trump to cancel SpaceX contract, quote, "Go ahead, make my day." Musk then threw down the gauntlet by claiming Trump was in the Jeffrey Epstein files, which didn't everyone already know already? Like, yeah, he's in there. But he said, quote, "Time to drop the really big bomb. Real Donald Trump is in the Epstein files. That is the real reason they have not been made public. Have a nice day, DJT." Again, this is sort of common knowledge. And of course, every time I point that out, people complain that I don't point out that other people are in the Epstein files. The Clintons, Bill Clinton is in the Epstein files too. But you know, Donald Trump is the current president, so it sort of makes it more newsworthy, I would think. But Trump responded by touting the so-called benefits of this bill. Quote, "I don't mind Elon turning against me, but he should have done this months ago. This is one of the greatest bills ever presented to Congress." Musk then threatened to decommission SpaceX Dragon spacecraft immediately. The Dragon shuttles astronauts to and from the International Space Station, but Musk deleted this tweet over the weekend. But Musk continued to attack Trump's economic policies. He added that Trump's tariffs would cause a recession. Now, this is not a new prediction. During the debate, Kamala Harris said, quote, 16 Nobel laureates have described his economic plan as something that would increase inflation and by the middle of next year would invite a recession. So there's nothing special about Musk's prognostications about the economic impact of Trump's policies. Of course, it doesn't make Musk look good that he ignored this information before the election. And in the same vein, he did not seem to care about Trump's association with Jeffrey Epstein until he was mad about his waning influence on the president. But Musk tweeted a video of Trump partying with Epstein. And as I said, this wasn't new information. However, Musk later removed the tweet. But things on the internet are forever, and the world knows that he tweeted it. But I guess by deleting it, the message to Trump is that he was backing down. And that's exactly what happened after a rando Twitter user told Musk to cool off. He responded, quote, "Good advice. Okay, we don't commission Dragon." But anyway, by then Musk was already working his way back into Trump's good graces. Billionaire Trump's Bill Ackman encouraged him to make up. And meanwhile, Trump was getting help from one of Epstein's lawyers. David Schoen, Epstein's defense attorney, said that he asked his client about Trump, and Epstein said, quote, "He had no information to hurt President Trump." And in fact, he said he specifically asked Epstein about that. Now, separately, there are some huge issues with Schoen's claim. First, he's asking people to rely on the statements of a disgraced sex offender to clear Trump. Second, his discourse may have violated the attorney-client privilege because the privilege generally protects confidential communications between a lawyer and their client, including after that client's death. So unless there is a clear waiver, that's a pretty clear violation of attorney-client privilege. But anyway, by Friday night, both men were backing down, and the White House tweeted a clip of the president saying he wishes Musk well, and Musk replied, quote, "Likewise." And on Saturday, Musk started deleting all of his personal criticisms of Trump, as well as the Epstein allegations. Now, Musk is not accustomed to being pushed around, but Trump has the entire federal government at his disposal, and he has already weaponized it in unprecedented and unconstitutional ways. So it really seems like he could make life incredibly miserable for Elon Musk. How? Well, let's start with the most dramatic action that Trump could take. He might just kick him out of the country. Now, in a pre-Trump world, that would be completely off the table. But we live in a post-Trump world. And Trump advisor Steve Bannon suggested that Trump investigate Musk's immigration status and deport him. Quote, "I am of the strong belief that Musk is an illegal alien and should be deported from the country immediately." Now, could Trump deport Musk to South Africa, send him to Sikot, or exile him to Corsica? Well, under the law, as it existed prior to January 21st, 2025, no, absolutely not. But Trump's attacks on the rule of law have really changed the game. Now, we've made several videos explaining how the Trump administration is deporting people without due process. The case against Colombian grad student Mahmoud Khalil is instructive. The administration claims that the Immigration and Nationality Act gives Trump the right to deport non-citizens and green card holders by labeling them as hostile to U.S. foreign policy interests. And Secretary of State Marco Rubio asserted that Khalil's pro-Palestinian activism harmed U.S. foreign policy. And he also claimed that Khalil hid his connections to groups like the United Nations Relief and Works Agency, or UNRWA, and that these omissions constituted fraud. Now, Now, as we've talked about, the evidence against Khalil is so thin that an immigration judge ruled that he was likely to win his case. The judge cited the only decision interpreting that section of the INA, which happened to be written by Trump's late sister, Judge Marianne Trump Barry. She had concluded that the law was unconstitutionally vague and that it violated the First Amendment. But guess what? That hasn't stopped Trump before, and it might not stop him in this case either. Now, as for Musk's legal status, all we know is that he became a U.S. citizen in 2002 through the naturalization process after holding permanent residency for several years. This means that somewhat unlike Mr. Khalil, Musk has full constitutional protections and cannot be deported under immigration law, except under some extremely rare circumstances. However, there are exceptions, and this administration is willing to stretch the truth to make them work. If someone obtains citizenship through fraud, the government might revoke their citizenship. This process is known as denaturalization. Fraud includes lying or concealing material facts during the naturalization process. And if the government denaturalized Musk, then he could be legally deported. So here's how that might play out. Trump would claim that Musk, like Khalil, misrepresented key facts on his green card application, potentially opening the door to similar accusations of immigration fraud. And Musk's immigration status before he was naturalized is unclear. In 2013, his brother Kimball said that when they came to the US, the brothers were illegal immigrants. Snopes looked into the claim but couldn't find enough evidence, and they concluded that his status remains an open question. And the brothers may have been on student visas, but at one point, both had dropped out of school and neither had a job. And if that was the situation under the law, maybe they could have been deported, but they would have had to have gone through the removal proceedings first, because of the rule of law and all that. But Trump could look at all this the way that Steve Bannon does and conclude that Musk committed fraud. I mean, consider how the Trump administration has already weaponized spurious allegations of anti-Semitism to justify other deportations. If Trump feels like using the same strategy on Musk, he probably has plenty of ammunition. Musk has promoted a conspiracy theory that Jewish people were engineered for a white genocide. He reinstated the Twitter accounts of many neo-Nazis. He threw up a Nazi salute during a Trump rally at the Capital One Arena. Musk criticized aid to Ukraine and indicated some support for pro-Palestinian protests. And of course, all of that is First Amendment protected activity, but that hasn't stopped this administration at all so far. And the Trump administration could argue that Musk's SpaceX and Starlink operations pose national security risks if Musk can't be trusted to align with American interests. Now, all of that is bad, but that's why you have a constitution and why you should never cheer even the people that you like being in power conducting unconstitutional acts. And speaking of which, Trump has also claimed sweeping authority to label someone an international gang member and deport them without due process. And there's no reason he couldn't apply that same logic to Elon Musk. This is, of course, what happened to Kilmore Abrego Garcia, a Salvadoran man that Trump deported despite a judge finding he faced credible threats from gangs in his home country. And although Abrego Garcia missed the one-year asylum filing deadline, an immigration judge granted him a withholding of removal, a protection that barred deportation to El Salvador due to the clear danger to his life. But notwithstanding, ICE agents arrested and deported Abrego Garcia anyway, claiming without evidence that he was a member of a gang. And the removal was carried out without a warrant, and ICE later admitted it had received but ignored the judge's 2019 order. The government never formally charged Abrego Garcia with being a gang member, so he never had an opportunity to challenge the government's claims. And a federal court described Abrego Garcia's deportation as a clear violation of due process that shocks the conscience. And his legal team is now seeking sanctions. And the subject of one of our future videos, the government has now fired back by charging Abrego Garcia with human trafficking because he drove people to a work site. Now, if the Trump administration can label someone as a gang member or a terrorist and then just simply deport them without due process, as they did with Abrego Garcia, they can do it to anyone, including Elon Musk. And that might sound absurd. Musk is obviously not a member of Tren de Aragua or MS-13. But look at what we're dealing with now. Donald Trump, the president of the United States, literally fabricated evidence against Garcia, claiming that he had MS-13 tattooed on his knuckles. The image he shared on social media was fake, but during an April 29th ABC News interview, he doubled down saying, quote, he had MS-13 on his knuckles. And reporter Terry Moran noted the letters were photoshopped, but Trump insisted the tattoo was real.
I can't have a trial, a major trial for every person that came in illegally. We have thousands of murderers that came in. They're going to murder people. They already have murdered people in our country.
Right, so
we have to get them out, and we have to get them out fast.
Really bad guys, but in our country, even bad guys get due process, right?
If people come into our country illegally, there's a different standard. These are illegal. They came in illegally.
But they get due process.
Well, they get a process where we have to get them out. Yeah.
Okay, let's talk about the Venezuelans.
They get whatever my lawyers say.
Oh, he had some tattoos that are interpreted that way. But let's move on.
Wait a minute. Hey, Terry. Terry.
He did not
Don't
have the
do that.
letter MS13.
It says MS13.
That was photoshopped. So let me
That
just...
was Photoshop, Terry. You can't do that.
But that's the thing about due process. If the government makes accusations against you, it's due process that allows you to fight those accusations. And yes, so far they have limited their accusations to marginalized people with dubious immigration status. But if you remove due process from any particular category of people, it can be used against anyone. Because there's simply no way to fight back if they're allowed to do it. Now, we are supposed to have a government that follows the law, but in less than 150 days, President Trump has decimated the legal norms that would normally protect Musk from an illegal denaturalization and deportation process. So it's all fun and games until the leopards eat your face. And he might come after Musk's companies next. As we've explained several times, the Constitution does not give the president broad power to block congressionally appropriated funds. The Impoundment Control Act and the Constitution prohibits the president from unilaterally refusing to spend money that Congress has directed the executive branch to spend. Under the act, if the president wants to withhold funds for any reason, they must notify Congress in writing through a rescission or deferral proposal. Then Congress must approve the rescission for it to take effect. Otherwise, the funds must be released and spent according to the law. Because, it's the law. And here, Congress has appropriated funds for SpaceX through NASA and the Department of Defense. Traditionally, this means that Trump cannot legally refuse to spend that money just because he's feuding with Elon Musk, unless Congress gives him the green light. Case closed? No, because Trump has illegally withheld funds, often with Musk's help so far. As head of Doge, Musk led aggressive government cutbacks, halting payments for state health departments, slashing cancer research programs, eliminating a consumer protection agency, and freezing USAID funds, all without congressional approval. And Musk gleefully supported Trump's assertion that the president had authority to override congressional budget laws. And this was all fun and games when it was happening to other people, but now Trump can turn it all back on Musk himself. Unless the judiciary steps in and enforces the law and prevents that from happening, but even that takes time and a lot of stuff can go wrong in the interim. And of course, Musk can argue that the impoundment, if it happens, is clearly retaliatory, and courts have consistently held that the government may not withhold benefits or contracts in retaliation for protected political speech, but Musk and SpaceX would have to sue the government, and Trump would obviously fight that. But the fun thing about this potential lawsuit would be Musk having to cite cases involving the same agencies and organizations that Musk dismantled at Doge. For example, courts have now ruled that Doge's actions at agencies like the U.S. Institute of Peace were illegal, but it's also likely that Trump could pursue more subtle forms of retaliation that wouldn't technically violate the ICA. He could change contract priorities, delay new contracts, or direct federal agencies to reassess contracts involving Musk companies. Now, Musk used his position and influence with Trump to stop agencies like the NLRB and the SEC from investigating his businesses, but don't be surprised if Trump orders federal agencies to ramp up regulatory scrutiny of Tesla and SpaceX. Because what the president giveth, the president can taketh away. And Musk companies stood to reap huge rewards by allying with Trump. SpaceX is one of the government's biggest contractors. And being buddies with Trump gave Musk the ability to put his thumb on the scale against his competitors like Boeing, siphon off more government money into his own pockets. And look, that was problematic in its own right. But here's the thing about that gamble. It only works as long as Trump doesn't betray you. And it also seems like Tesla is a company with a positive pro-environmental mission, but it seems that Musk has alienated every conceivable customer and painted Tesla into a corner. The Republican Party is dedicated to fossil fuels and opposed to all forms of green energy. Trumpers don't want Teslas, and people who don't like Trump will never ever buy a Tesla. But on top of that, if Trump makes good on his threat to cut off SpaceX, that company could meet a similar fate. Though for now, SpaceX is probably in a slightly better position than Tesla because the US is dependent on the company for its orbit launch service, and there isn't an alternative that can replace SpaceX on a short or even medium-term notice, which is why some right-wing commentators are calling for Trump to nationalize SpaceX. So live by the Trump sword and die by the Trump sword. But please, won't someone think of the children? And by children, I mean the Musk-aligned Doge employees. Now, the Trump administration is now hiring many of the Doge employees for permanent government positions. Like this guy, Thomas Fugate, a 22-year-old with no experience who is now in charge of terrorism prevention. I feel safer already. But it appears that all of them are worried about getting fired. The Wall Street Journal said, quote, Doge-affiliated staff, some of whom were responsible for pushing out thousands of federal workers, texted one another on Thursday about whether they would be fired next. Now, most of these people were hired because they were connected to Musk. And you have to wonder where their loyalties lie. But in years past, personal loyalty to the president wasn't a great reason to hire or fire a bureaucratic technocrat. So can these Doge bros really be fired over the Trump-Musk grudge match? Well, yeah, because Trump and Musk, following the blueprint outlined in Project 2025, successfully undermined merit-based civil service protections, or at least a lot of them. Now, the whole point of those protections was to ensure that public employees were hired, promoted, and retained based on merit, not political loyalty. And those protections created a non-partisan federal workforce that could serve the public interest regardless of which political party was in power. But a lot of that following Project 2025 was successfully cast aside or imperiled. And all this in March led French Senator Claude Malhuret to explain our situation as, quote, Washington has become the court of Nero, an incendiary emperor, submissive courtiers, and a jester high on ketamine in charge of purging the civil service. This is a tragedy for the free world, but it is first and foremost a tragedy for the United States. Yes, these actions caused the French to dunk on us. The French! So yeah, if you are an employee or associated with Doge, I would start brushing up on your resume. So can Trump weaponize the federal government to punish Elon Musk and those that are associated with him? Yeah, the only question is whether it would hold up in court. But at least maybe then Musk would finally understand why the rule of law with independent judges is worth keeping around. But maybe because of the immense power that the federal government has legitimately or illegitimately, Musk is now making amends for his disloyalty. He replied to a post from Vice President J.D. Vance about how the president was handling the situation in Los Angeles. Musk also posted a screenshot from Truth Social from Trump criticizing California Governor Gavin Newsom and Los Angeles Mayor Karen Bass. And he wrote cool to a video of Vance speaking in an interview where he says he thinks, quote, if Elon chills out a little bit, everything will be fine. So it seems like after taking the weekend off and thinking about the fate of SpaceX and Tesla, Musk decided to get back on board the Trump train. Happy Saturday! Now send me a list of 5 things you did this week or you're fired. No, I'm not going to read all 4 million emails, but I'm so obsessed with efficiency that I'm going to cause millions of government employees to waste their entire workday trying to figure out 1, if you need to respond, and 2, what you can possibly say while not violating government secrecy laws or other ethical obligations. Yes, I'm a genius. On Saturday, February 22nd, the Office of Personnel Management, or OPM, sent an email to federal employees instructing them to respond with 5 things they accomplished last week, or else they would lose their jobs. When Musk bought Twitter for $44 billion, he sent a similar email to Twitter employees, demanding that they send him screenshots of their most salient lines of code. Musk then fired thousands of them, leading to dozens of lawsuits, all of which he's lost so far, and a diminished user experience at Twitter, to put it lightly. And now that Elon Musk has purchased the US government for a much lower price, he got to work making America more miserable for everyone, but especially government employees. Now, Musk's ostensible mandate is to make things more productive and efficient, and what better way to do that than by giving employees busy work and new bureaucratic puzzles to solve? It's not like they've got anything better to do, like, I don't know, making sure planes don't collide in midair, monitoring the transmission of avian flu to humans, and preventing people from dying while climbing the Grand Canyon. That stuff can wait. Now name 5 things you did last week, losers. Now we still don't know all the repercussions of the email blast, but as you'll see, there's a very interesting legal twist. And it seems that the government's representations in court are finally coming back to bite them. And in fact, one lawsuit that was filed long before the email blast went out might be the reason that people don't get fired for ignoring it. And in another twist, the person who filed that lawsuit is someone that you've probably seen on this channel before. But let's take a step back. When Doge employees took over the Office of Personnel Management in January, they set up a new email system that let the OPM email all federal employees through a single distribution list. The new system was called the Government-Wide Email System, or I'm assuming it's called the GWIZ. It sends emails to federal employees through the email address hr@opm.gov. Now, I'm new to American politics, so I assume that everyone on both sides of the aisle is totally cool with an unauthorized email server. But storing private and classified information on an unsecured server is a big security risk. And we don't know where the OPM server is physically located or who built the system, but it seems the system is now retaining information about every employee of the US executive branch. And it seems to be going far beyond federal employees. It appears to be retaining information about every person with a .gov or .mil email, which is a much bigger set. And there's also evidence that employees of the judicial branch, including lifetime appointed federal judges, are also getting the emails. Now, civil servants are worried that their personal information is not secure. They say, quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new US government device as soon as they learn of its deployment. Now, sure, that sounded like a big problem, but Elon Musk wasted no time in using the system to send an ultimatum to federal workers. On January 28th, OPM sent an email with the subject line "Fork in the Road" to roughly 2.3 million government employees. And as we talked about at the time, the email rolled out a deferred resignation program that really wasn't a resignation program, where people could stay on until September 30th working remotely with pay and benefits, but they still had to do their own jobs. And the email instructed employees to respond by February 6th. Now, it was easy to see Elon Musk's hand in this because he did the exact same thing when he purchased Twitter. Musk sent an email with the subject line "fork in the road" and gave Twitter employees 24 hours to decide if they wanted to work for him or quit. And Musk eventually fired about half of Twitter's workforce. But as Elon Musk soon found out, sending an email to everyone connected to the government is not the same as sending a company-wide email. Federal employees have civil service protections, and they filed several lawsuits challenging the legality of the deferred buyout program. And for more information about the fork in the road debacle, you can check out the video that we did with Liz Dye. But undeterred by lawsuits, on February 22nd, Elon Musk tweeted that, quote, "consistent with President @real Donald Trump's instructions, all federal employees will shortly receive an email requesting to understand what they got done last week." Now, if it took you a second to parse whatever requesting to understand means, don't worry, it took me a second as well. I think what he meant to say is they'll get an email asking what people did last week. Now, 2 hours later, the OPM sent employees an email instructing them to respond with 5 things that they accomplished last week. Quote, "Please respond to this email with approximately 5 bullets of what you accomplished last week and CC your manager. Please don't send any classified information, links, or attachments. Deadline is this Monday at 11:59 p.m. Eastern Standard Time." Now, this was yet another email modeled on Musk's Twitter takeover. When Musk purchased Twitter, he told the employees to, quote, "email him a bullet point summary of what your code commits have achieved in the past approximately 6 months, along with up to 10 screenshots of the most salient lines of code." That email was a prelude to mass terminations. And federal employees were understandably confused. The email was from the random HR address rather than their supervisors. The email itself did not say what would happen if employees missed the 11:59 p.m. deadline. And in a contradictory fashion, Musk's tweet warned them that failure to respond will be taken as a resignation. So did they have to respond or not? What happens if all of your work is classified? How are you supposed to summarize that? Well, apparently when you move fast and break things, nobody knows what's going on. For example, quote, "officials at the Departments of Defense, State, Homeland Security, and Energy told workers not to respond. But leadership at the Cybersecurity and Infrastructure Security Agency and the Federal Emergency Management Agency, which are both housed within DHS, told their employees to answer the email. Treasury, Veterans Affairs, Commerce, and Interior instructed their employees to respond, but warned them not to share any classified information. The Department of Health and Human Services, which is now run by a guy with a legal brainworm, had no idea what was going on. At first, supervisors told staff to reply, but just hours later, the agency backtracked. On the following Sunday night, HHS sent an email asking employees to pause responses pending additional guidance. And the HHS acting general counsel said, quote, "I'll be candid with you. Having put in over 70 hours of work last week advancing administration's priorities, I was personally insulted to receive the below email." And according to the AP, he was concerned that some agency employees could not discuss their work because of attorney-client privilege. 1 day later, HHS sent a third email, quote, "There is no HHS expectation that HHS employees respond to OPM, and there is no impact to your employment with the agency if you choose not to respond." And HHS said that if anyone wanted to respond, they should not identify other HHS employees they worked with, matters they are working on, or specific grants or contracts. Quote, "Assume that what you write will be read by malign foreign actors and tailor your response accordingly." And I assume by malign foreign actors, they mean President Donald Trump. Speaking of whom, President Trump, ever a beacon of clarity, insisted that federal workers were required to answer Elon's 5 things email.
What he's doing is saying, are you actually working? And then if you don't answer, like you're sort of semi-fired or you're fired, because a lot of people are not answering because they don't even exist.
But while Trump was defending Elon's email, the OPM was contradicting him. OPM told federal employees that, quote, "any employee response to the email is voluntary and that not responding will not be considered a resignation." Meanwhile, OPM's acting director, Charles Ezell, was silent about whether employees who didn't respond had resigned. Ezell said, quote, "agencies should review responses and evaluate non-responses, and that agency leaders, quote, may exclude personnel from this expectation at their discretion." Ezell put the pressure on supervisors to decide whether to fire people. Quote, "agencies should consider any appropriate actions regarding employees who fail to respond to activity accomplishment requests. It is agency leadership's decision as to what actions are taken." But the Monday deadline came and went, and Musk fumed about it on Twitter. Quote, "subject to the discretion of the president, they will be given another chance. Failure to respond a second time will result in termination." So instead of clarity, we got a whole bunch of chaos. However, a lawyer emerged to save the day. Now, back on February 5th, Kel McClanahan with the National Security Counselors filed a lawsuit accusing the OPM of setting up an unauthorized, insecure server to send mass emails without conducting a privacy impact statement as required by law. And additionally, you might have also heard of the illegal email server. Well, our friend and fellow attorney Kel McClanahan filed a lawsuit against OPM on behalf of government employees who received potentially illegal and unsecured emails from Elon Musk and his Doge team. The 7 plaintiffs are either employees or affiliates of various government agencies or organizations. They allege that OPM, working with Doge, set up an unauthorized server built by a commercial entity to conduct email blasts without providing a privacy impact assessment for it. The lawsuit asserts that OPM used the server to send several test emails to workers across the government, as well as the fork in the road emails, which offered deferred resignations to federal employees. Now, under the E-Government Act of 2002, federal agencies are required to complete a Privacy Impact Assessment, or PIA, before initiating any new collection of personally identifiable information, PII, using information technology. This assessment must evaluate what information is collected, why it is collected, how it is to be used, with whom it is to be shared, and how it will be secured. Additionally, agencies must ensure that the Chief Information Officer or an equivalent official reviews and signs off on it. The appropriate government official must make the PIA publicly available through their website, the Federal Register, or other means. But here, the OPM allegedly did not conduct a PIA for the new email system and the server in question. McClanahan apparently discovered the issue when an OPM employee posted information to a union chat and someone circulated the message on Reddit. And the Reddit message warns of dire circumstances within OPM. Quote, an on-prem, on-site email server was set up. Someone literally walked into our building and plugged in an email server to our network to make it appear that emails were coming from OPM. It's been the one sending those various test messages you've all seen. We think they're building a massive email list of all federal employees to generate mass RIF, reduction in force notices, down the road. The non-political civil servants here at OPM are watching helplessly as our government is being systematically dismantled bit by bit. Even the IGs are being fired to prevent them from investigating the numerous whistleblower complaints we filed. The message also discusses the resignation of OPM CIO Melvin Brown. The message said Brown, quote, was pushed aside just 1 week into his tenure because he refused to set up email lists to send out direct communications to all career civil servants. And the plaintiffs are concerned about the security of their PII being stored on an unknown server. They cited the infamous 2015 data hacks, which compromised the information of 21.5 million people, including sensitive data drawn from background checks. Quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new US government device as soon as they learn of its deployment. Plaintiffs moved for a temporary injunction, declaring that the OPM's actions violate federal law, compelling the OPM to publish a legally sufficient PIA, and ordering the OPM to disgorge all improperly collected information. In response, the Trump administration opposed the TRO. They argued that the plaintiffs misunderstood the E-Government Act, and the government says that the act requires privacy impact assessments only for systems that deal with public information, whereas the OPM system only handles information related to federal employees. However, plaintiffs say that non-executive branch employees received some of the emails. For example, FedScoop reported that, quote, employees at the Library of Congress, which is a legislative branch agency, and thus outside the direct scope of the Trump administration's workforce actions, received a test email. The Trump administration denied that it was required to file a PIA, but filed one a mere hour before Kell's lawsuit went in front of a judge. So we thought we'd ask Kell McClanahan directly. So, Kell, what happened?
So what happened was that we were overtaken by events, as often is the case when dealing with these Trump actions, where we had filed a case when all we knew about the server was that it was sending out test emails. It was before they even sent out that fork in the road email. And then we filed a TRO a week later based on everything new we had learned about the system and said you need to shut it down until they do a PIA. Then, as you say, the day of their opposition to the TRO, they said, here's a shiny PIA that we just did. It's moot now, right? The judge said, well, you didn't say in your TRO motion or even in your complaint that they had to file a proper PIA. You just said they have to file a PIA. So I'm going to hold that this motion that you have filed is moot because they filed a PIA. However, if you want to argue that they filed a POS PIA, then you need to amend your complaint and file a new TRO. Do that tomorrow. And so we did that last night.
Now, the government alleges that the PIA requirement doesn't apply here. What do you say to that?
This is, first of all, just factually irrelevant and inaccurate. They did not collect information from just federal government employees. And that doesn't matter for whether or not you define federal government to be just the executive branch or the government as a whole. They collected it from everyone with a .gov or .mil address, which is more than just federal government employees. So it's just wrong. It doesn't apply. Number two is that prior to last year, the OMB guidance would have been entitled to, let's call it deference, perhaps even Chevron deference. And a whole bunch of people went and sued on behalf of Republicans everywhere to get rid of Chevron deference and say that judges can make decisions about whether or not they believe a law requires something, regardless of what the agency guidance on that says. And now they're turning around and saying, well, this agency guidance says that this does not apply. Therefore, ta-da, I found one weird trick. And that's nice. You're not entitled to Chevron deference anymore because you caught the car and you won that argument in Loper Bright. And it's up to the judge to decide if this applies to collections of information about people besides federal government employees. But then again, he might not because, as I said before, it's not just limited to federal government employees. And so this just falls flat.
What about the emails to the Library of Congress? Could they be construed as members of the public?
Well, they can. And they can also potentially be construed as federal government employees, depending on how you want to parse federal government. But even then, it doesn't matter because we know that legislative branch employees got this email. Judge Moss said in the hearing on Thursday that he got the email. And we've had wide reporting that judicial branch employees got the email. And I have clients who are contractors who got the email. And so even if you say that federal government employees applies to everyone in every branch of government, it does not apply to the contractors. It does not apply to the state of California employee who is one of my clients who got the email because she was in a program that partnered with a government agency. And so that's why she had a .gov email address. It just is an irrelevant point. These are a lot of arguments that are nitpicking based on the assertion that it only collected information about executive branch employees or maybe larger government employees. But once you knock that down, the whole house of cards falls.
Am I curious? Yes.
And what do we know about the OPM's PIA issued on February 5th?
All we know for sure is that it was done sometime between January 22nd, which was the day that Greg Hogan, the signatory, took over as chief information officer, because we know that Melvin Brown, his predecessor, refused to allow the government-wide email system to happen. It was also done sometime before February 5th, or including February 5th, because that's the day they filed it in my case, where they dropped it at 10 o'clock in the morning when we were supposed to have a status conference at 11 o'clock in the morning. So, that's not suspicious at all. It is more likely that it was done after I filed my temporary restraining order motion, but we don't have evidence of that. But what we do know is that even if they started writing it when they started doing the system, that's still only 2 weeks. You don't do a PIA for a major information system in 2 weeks. You do a PIA in, at best, 2 months, because it's complicated. Okay, fun fact. The reason that the OPM hack happened in 2014 was because the Chinese were very, very methodical and very, very patient. And they found an access point where they were able to spoof coming from opmsecurity.org, which fooled the system into thinking they were part of OPM. Then they sat there until they saw an opening, and then they stuck a person in there who could log in and be recognized by the system as an authorized individual. The system thought that that person was need to know as far as the access goes. So the fact that they are saying this system can only be accessed by people with the need to know is predicated on the idea that the only way to access the computer is by walking up to it and sitting down in front of it and typing into it. However, that is not how things work in cybersecurity, and even the net got that right. And so as long as they are sitting out here with this server with all of this information on it, the server doesn't know if you're sitting down in front of it or you're accessing it remotely. I guarantee you that some of these guys are accessing it remotely. And so what are we supposed to draw from this? What are we supposed to conclude by the fact that our security measures are, we make sure people can't get into the room where it's sitting connected to the entire network?
What do we know about exactly when this PIA was done?
PIAs take a long time to work on because they are important. And in fact, the law requires that the complexity of a system be commensurate with the complexity of the PIA. And when you have something like a major information system, as the law defines it, you have to be even more specific. So when you have that, and you look at the other PIAs that even just OPM has promulgated for its other systems, one of which is actually the Microsoft Office 365 information system that they use for all their communicating, you see these are very specific requirements, and these are very specific answers. They say who is doing what, why we decided on doing this, what security measures were considered, what we thought after we did the PIA, how we adjusted the way we used the system, et cetera, et cetera. Then you have this PIA. And this PIA, I want to make clear, I call a PIA so that every answer doesn't have to go with this document that purports to be a PIA. This is not a PIA. This is, as someone said a couple of days ago, a restaurant menu with PIA written across the top of it. It says things like, we don't need to do this because we are being very secure. How is the data being protected? It's being protected by protective measures. It does not give answers to any of the questions. Some of the stuff it says is factually just wrong, like we only collect information about government employees. Some of the information is extraordinarily misleading, and even if you accept that everything in it is truthful, it's still woefully legally insufficient.
Thanks for coming on, Kel, as always. And if you'd like to support the work that the National Security Counselors is doing, we'll leave a link for that down in the description. They receive a lot of their funding through private donation, and their work is more necessary now than it ever has been. Now, it seems that in response to the suit, OPM tried to conduct a privacy impact statement for the GWiz email system. The privacy impact assessment stressed that participation in the system was actually voluntary. Section 4.2 says, quote, "The employee response data is explicitly voluntary. The individual federal government employees can opt out simply by not responding to the email." And OPM acknowledges that some employees might not realize they aren't required to respond to these government emails. So the PIA concludes this risk can be mitigated, quote, "by ensuring that any email sent using GWiz is clear by explicitly stating that the response is voluntary and by including specific instructions for a response." Which is super weird because none of that language was ever included in any of these emails. But the OPM argued that the PIA mooted the case, quote, "Because the agency has in fact published a PIA despite it not being required to do so, this case is moot and plaintiffs cannot establish irreparable harm." Problem solved? Well, that response convinced the judge to deny plaintiffs' motion for a temporary restraining order, but forcing the OPM to publish a PIA wound up accomplishing quite a bit actually, because the OPM told the court that employees did not have to respond to these mass emails. OPM claimed that the government workers who had received emails from the email system had limited privacy protections, but OPM sent emails to people who were not within its jurisdiction, the executive branch. The 5 Things email even went out to some federal judges who obviously work for the judiciary and can't be fired by OPM. And according to an email from the director of the Department of Administrative Services for U.S. federal courts, quote, "We understand that some judges and judiciary staff have received an email from hr@opm.gov. Please be advised that this email did not originate from the judiciary or the administrative office, and we suggest that no action be taken." So if any of these employees responded, they might now have standing to sue along with their executive branch counterparts. And since the emails went out to so many people who were not executive employees, plaintiffs filed an amended complaint expanding the proposed class to everyone with a government email address. And Kel has now moved for Rule 11 sanctions against the government. Under Rule 11C2, lawyers must give the opposing side 21 days to correct the offending conduct. And he asked the court to shorten the safe harbor period to just 5 days, and the judge agreed, so the motion is now on the public docket. And plaintiffs allege that OPM submitted false evidence to the court in an attempt to avoid a temporary restraining order. And the PIA asserts that the GWiz system only collected voluntary responses from federal employees, and the PIA reiterated this claim 5 times. However, as we just discussed, the system was actually used to gather responses from non-executive branch employees, including judiciary staff. Guidance from the president and some agencies indicated that responding was mandatory, and the court relied on this inaccurate information when denying the initial TRO. So according to the plaintiffs, quote, both of these actions demonstrate a clear lack of candor to the tribunal, and OPM and its counsel should be sanctioned for unreasonably multiplying the proceedings and violating the integrity of the court's process by entering statements into evidence which were known to be false and then citing them uncritically to the court to convince the court that OPM's actions were legal and that plaintiffs were not at risk of imminent harm. Now, in the wake of President Trump's executive orders, there have been a deluge of federal lawsuits that have been filed. I think over 100 at this point. But I believe that this is the first time any of the plaintiffs' lawyers have sought sanctions against the government. But given the representations that the government is making in court, I doubt this will be the last motion for sanctions. And here the motion cites 3 legal authorities for imposing sanctions. Rule 11 requires attorneys to ensure that filings are factually and legally supported and not presented for improper purposes such as harassment or delay. Plaintiffs argue that, quote, OPM and its counsel intentionally, unreasonably, vexatiously, and in bad faith entered a document containing false information into evidence and argued that the court should rely on the statements made in that document. Plaintiffs twice asked the court to grant a temporary restraining order, and both times OPM lawyers asserted the issue was moot because of the PIA. So this undoubtedly added expense and time to the litigation. And as plaintiffs point out, quote, OPM convinced this court to deny plaintiffs' first request for a TRO, force the parties to brief a second motion for a TRO, and are forcing plaintiffs to respond to a motion to dismiss, which is largely predicated on the fact that the invalid and inaccurate GWiz PIA is in the record. Plaintiffs argue that because OPM and its counsel knowingly submitted false evidence, misleading the court and prolonging the proceedings, the court should strike the PIA from the record, prohibit OPM from relying on the PIA at this stage in the litigation, order OPM's lawyers to file sworn statements regarding how much they actually know about OPM's representations, and grant the plaintiffs any other relief that would deter OPM from repeating the conduct. Now, the court hasn't ruled on this motion yet, but on Friday night, OPM updated the PIA, sent out another round of emails, and issued more conflicting guidance. It really does feel like Groundhog Day because the Department of Government Efficiency is making everyone do the same thing over and over and over again. But the updated PIA says that responding to the email system is voluntary, but, quote, the consequences for failure to provide the requested information will vary depending on the particular email at issue. OPM and the agencies then sent a second version of the 5 Things email. The subject line was, what did you do last week, part 2? The email directed employees to file a weekly response summarizing what they accomplished. Now, some employees received this email from their agencies, which could be a different strategy to moot the case, because there's probably nothing wrong with asking an employee to respond by email to their direct supervisor. However, some employees still received the email directly from OPM, and OPM made the situation more confusing by telling agency leaders they should send a copy of their response to OPM, and OPM didn't say what the agency planned to do with these emails. OPM did say, quote, agencies should review responses and evaluate non-responses. And once again, agencies are taking different approaches. This time around, the State Department told its employees they did not have to respond to the email, but the Defense Department said all civilians must respond to emails from Pete Hegseth within 48 hours, and over at DHS, employees were directed to send their responses to an email address at DHS. And once again, Elon Musk issued directives from his Twitter account, quote, the president has made it clear that this is mandatory for the executive branch. Anyone working on classified or other sensitive matters is still required to respond if they receive the email, but can simply reply that their work is sensitive. So responding is mandatory or discretionary, and the consequences are dire or non-existent. But with respect to the OPM lawsuit, the plaintiffs took a loss when the government denied the motion for a TRO, but they at least forced OPM to cough up a document that lawyers all over the country will now use against them. And while we don't have a permanent resolution in this particular case yet, the lesson here is that it's good to make the government go on record about what it's doing. And as for what OPM will do with the 5 Things email, the humor website McSweeney's predicted that the government will, quote, feed them to an AI which will flag any forbidden words like diversity and woman, so it can eventually be read by a racist Doge bro. And what do you know? NBC News has just reported that Doge will use AI to review all the responses. Now remember in Looney Tunes when someone would rob a bank, they'd walk away with little bags with dollar signs on them? Well, that's basically what Tom Homan did. The corruption was that cartoonish. Because usually when you get a paper bag from a fast casual chain, they ask, do you want fries with that? But when the FBI met Tom Homan in Texas, the bag had a lot more than pita chips. It had $50,000 in cash. Homan, the man who once ran ICE and now serves as Trump's border czar, allegedly took the money with the understanding that he'd hook up government contracts once he was back in power. That's definitely one way to supersize a value meal. Now, accepting 50 grand from undercover FBI agents seems like it ought to be a one-way ticket to prison, but here's the wild part. Thanks to the Supreme Court's bribery rulings, Homan might not even get a slap on the wrist. So today we're gonna break down who Tom Homan is, why the FBI stuffed a bag full of cash into his lap, and what the law actually says about whether that's bribery or not. Now, Tom Homan has been an immigration officer since 1984. President Barack Obama appointed Homan as Executive Associate Director of Enforcement and Removal Operations in 2013. By 2014, Homan was arguing that separating children from their parents at the border would be an effective immigration deterrent. So not surprisingly, Donald Trump made Homan acting director of ICE in 2017. Homan's defining moment came in 2018 when he helped defend and carry out the zero-tolerance policy that separated thousands of children from their parents at the border. And Homan advocated for its expansion, arguing that American children with foreign parents should be deported too.
Why should a child who is an American citizen have to pack up and move to a country that they don't know?
Because their parent obviously entered the country illegally, had a child knowing he was in the country illegally, so he created that crisis.
Now, after leaving the government, Homan became a TV pundit. On the side, he was acting as a consultant, advising companies who wanted to get immigration-related contracts. And Homan's most significant work was for the GEO Group, a company that builds prisons. Now, stick a pin in that because it's this consulting work that now has landed Homan in hot water. Now, as Trump's second presidential run took shape, Homan was one of the architects of the mass deportation plan. And during a 2024 conservative conference with other anti-immigration activists like Stephen Miller, Homan promised to help Trump pursue a draconian immigration agenda. Quote, "Trump comes back in January, I'll be on his heels coming back and I will run the biggest deportation force this country has ever seen. They ain't seen shit yet. Wait until 2025. So when Trump won the 2024 election, he appointed Homan as border czar. As Media Matters reported, Trump's immigration policies have since gone far beyond what was even in Project 2025, including banning asylum at the southern border, shuttering refugee settlements, ending birthright citizenship, and designating drug cartels as terrorist organizations. And Homan supported all of these policies. He even called birthright citizenship a, quote, historical myth. Now, as border czar, Homan is responsible for coordinating immigration and border policies across agencies like DHS, ICE, and CBP, advising the president directly on immigration enforcement strategy and overseeing implementation of Trump's mass deportation initiatives, including the expansion of detention. But back in the summer of 2024, he was still outside of the government. And that's when Homan's name came up during a counterintelligence investigation. The FBI's initial target mentioned that a payment to Homan would help contractors get government contracts. And according to MSNBC, Julian Jace Calderas, who used to work under Homan at ICE during the Obama years, allegedly helped hatch the plan. Calderas told undercover agents as far back as May of 2023 that Homan could deliver federal contracts for a price. $1 million if Trump returned to power. Calderas, who now co-owns a detention services and government contracting firm in Texas called XFed, held multiple conversations with agents to float this cash for contracts idea. So although the FBI didn't start out looking at Homan, they decided to set up a sting to see if he would bite. By the time the sting culminated in September of 2024, Calderas and Homan were sitting side by side in Dallas. And the FBI cameras caught Homan allegedly accepting $50,000 in a kava bag, plus Calderas himself allegedly pocketing $10,000 from the same agents. And Homan reportedly indicated that he would arrange immigration-related government contracts in return, and that he would hold the bribe money in a trust until he joined the Trump administration. But at the time, Homan was running a private consulting shop, publicly boasting that he would return to government in a top role if Trump won in 2024. Calderas, now CEO of XFed, stood to benefit from his old ties to Homan. His company markets itself as veteran and minority-owned, with a, quote, insider perspective on DHS procurement. Yeah, I'll say. Now, Calderas told MSNBC that he didn't have any knowledge of the investigation. Now, with this evidence, the DOJ opened a grand jury probe in the Western District of Texas in December of 2024. And according to the New York Times, DOJ leadership debated if the evidence they had on Homan was strong enough to be indicted. They decided to wait and see if Homan acted on his promises once he accepted the position in the Trump administration. However, 6 sources told NBC News that once Trump appointed Homan as border czar, the case stalled. In February, Emil Bovee, who was then acting deputy attorney general and is now a federal judge for life, was briefed on the case. Bovee was unhappy with the investigation and said it was an example of a deep state operation. Now, as we've discussed before, Bovee himself is unbelievably corrupt. Among other things, not long after the meeting where he criticized the Homan probe, Bovee ordered prosecutors to drop corruption charges against New York City Mayor Eric Adams, and many career prosecutors resigned in protest. Bovee then departed to become a federal judge, again, for life. But in any event, FBI Director Kash Patel shut down the investigation into Homan. Patel and Deputy Attorney General Todd Blanche claimed the Homan investigation was politically motivated and that there was no credible evidence of any criminal wrongdoing. And the White House said that Homan has not been involved in awarding any contracts since he joined the administration. And Homan claimed back in December he would recuse himself from anything having to do with government contracts. However, quote, in June, it became clear that wasn't the case. According to a detailed account of a Defense Department meeting that month, a Navy official noted Homan's participation in a military contracting process, saying the border czar had been briefed by industry, government parlance for meeting with private companies seeking contracts. Homan was then expected to discuss the matter with Secretary of Defense Pete Hegseth. So yeah, that looks incredibly bad and corrupt. But now that the scandal is public, Homan denies breaking the law.
Look, I did nothing criminal, I did nothing illegal, And it's hit piece after hit piece after hit piece. And I'm glad the FBI and DOJ came out and said, said that nothing illegal happened and nothing, no criminal activity.
But here's what Homan didn't say on Fox News. He didn't say the story was false, and he didn't say he turned down the $50,000. What he did say was, I didn't do anything illegal. And here's what Laura Ingraham never asked. Did he take the cash? Did he stash it in a trust? Did he spend it? Or is it earning interest in some Swiss bank account? Now, Tom Homan has never explicitly admitted that he took the money, but he defended his actions by saying, quote, I'm back on a government paycheck. Now, admittedly, on its face, taking $50,000 in cash from undercover agents looks like an open and shut bribery case. It's just cartoonishly corrupt. But federal corruption law is rarely that simple. Under 18 U.S.C. 201, a public official commits bribery where he or she, quote, directly or indirectly, corruptly demands, seeks, receives, accepts, or agrees to receive or accept anything of value personally or for any other person or entity in return for being influenced in the performance of any official act. So the main federal bribery statute contains 5 elements. A public official who accepts anything of value corruptly and with the intent to influence an official act. And bribery carries a penalty of up to 15 years in prison and or fines not to exceed 3 times the value of the benefit received. Now, Congress wrote that very specific bribery statute with elements that prosecutors have to prove beyond a reasonable doubt, but over the past decade, the Supreme Court has made that job much harder. The Robert Court's landmark ruling on public corruption, McDonald versus United States, turned what looked like blatant corruption into a legal gray area. Now, we've talked about this case before, especially in the context of former Senator Bob Menendez, but in that case, Bob McDonald, a Republican governor of Virginia, and his wife Maureen accepted more than $170,000 in luxury gifts and loans from businessman Johnny Williams. Williams wanted state universities to study his tobacco-based supplement. And the McDonalds were in serious financial trouble. Maureen actually spelled it out for Williams, quote, it's okay for me to help you, but I need you to help me. And Williams got the message. And McDonald delivered by setting up meetings, hosting events, and making introductions to boost Williams' case. Now, a jury convicted McDonald in 2014 of honest services fraud and extortion under the Hobbs Act, which is the federal law prohibiting extortion. And that seemed like a pretty clear quid pro quo, but then the case reached the Supreme Court. And the Supreme Court overturned McDonald's conviction. And the court's decision turned on whether McDonald really gave Williams anything that could be termed an official act. Because under the statute, an official act is, quote, any decision or action on any question, matter, cause, suit, proceeding, or controversy, which may at any time be pending, or which may by law be brought before any public official in such official's official capacity, or in such official's place of trust or profit. But the Supreme Court construed the words question and matter narrowly. And according to the court, for the government to prove its case, there needed to be, quote, something more before an event, meeting, or speech related to a pending question or matter became an official decision or action. And the Supreme Court said something more is required than just favors or introductions. To count as bribery, an official has to actually take a step forward to a government decision, pressure another official to act, or give advice knowing it will shape an official decision. And the court drew a line between casual support and real government pressure. Hosting events or arranging meetings, the justices said do not qualify as official acts. So the court overturned the conviction and remanded the case to the Fourth Circuit to decide whether McDonald's other actions were official acts under the new definition. So after the McDonald decision, the elements of corrupt intent and official act are especially difficult to prove. And so the Justice Department's public corruption prosecutor, Jack Smith, yes, that Jack Smith, elected to drop the case. So what does this all mean for Tom Homan? Well, on its face, it seems like getting handed a bag full of cash at Cava sounds like the textbook definition of bribery. But remember, the Supreme Court said in McDonald that it's not enough to show that money simply changed hands. Prosecutors have to show a quid pro quo, that the money was given in exchange for a specific identifiable official act. And that's probably where this case against Homan runs into trouble. In August of 2024, when the sting went down, Homan wasn't working for the government. He couldn't award contracts at the time, sign off on detention centers or green light ankle monitoring programs. And he allegedly said that he'd hold the money in trust until he rejoined the future Trump administration. Now that's a promise, and an incredibly shady and corrupt one, but it's not the same as an official act already pending before him in his role as border czar, because at the time, he wasn't yet appointed to the government. Now, on top of it, we don't know exactly what the FBI caught him on tape saying, but Homan may not have gotten into details with the agents, like discussing a specific contract or leaning on a government official to push one through. But this really highlights the problem of ending this investigation early, and the fact that the FBI stopped this investigation might be even more corrupt than Homan's original bribery. So fair enough that handing $50,000 in cash to a civilian who's not in government is not in and of itself corruption or bribery, but apparently the man said, hey, thank you for this money. When I become a public official, I will then do all kinds of official acts, including steering government contracts to my buddies. it seems like it's only a matter of time until he actually commits that official act and completes what's necessary to form the crime of bribery. Unlike the McDonald case where making introductions or making phone calls wasn't necessarily an official act, I'm willing to bet that even this Supreme Court would agree that if you have control over steering government contracts and you then steer those contracts, that would be considered an official act. Now here, we don't even know what Homan has or has not done to steer government contracts. And if the investigation continued, he very well might have eventually overtly engaged in behavior that would have qualified as an official act and steered contracts to the people that gave him thousands and thousands of dollars in cash. But it really seems like when you have a guy who had an official role in a presidential administration, who cartoonishly receives bags full of money, and then also cartoonishly says, hey, as soon as I'm back in the administration, I'm gonna start steering these contracts to you, that's a guy you should probably watch. And on top of that, another reason to keep an eye on a guy who's engaged in cartoonish corruption is it's not clear whether he would have declared the $50,000 in cash on his tax returns. In fact, the only reason you take possession of $50,000 in cash in a fast casual food bag is to make sure that you don't have to declare that income on your tax return. So if this FBI investigation had continued, I'm pretty confident that eventually Tom Homan would have made good on his promise and engaged in outright bribery. But even if that wasn't the case, and I'm skeptical, I think they eventually would have had a very strong case of bribery. Even accepting that as true, eventually they'd probably have a slam dunk case for tax fraud. Because the IRS doesn't care whether the money came from a kava bag or a payroll check. Under federal law, all income is taxable, and that includes money earned illegally. And courts have long held that bribe money, drug money, and even embezzled funds must be reported on your taxes. Just ask Al Capone, who dodged murder charges but went to prison for tax evasion. If Homan pocketed $50,000 and failed to declare it to the IRS, then that's a straightforward tax crime. But even if bribery was too shaky, which I'm not sure about, I think they could have made a strong case depending on what Homan actually did, there are some other crimes that would fit. Public corruption prosecutors have used a whole menu of options to prosecute crooked officials, though that has been scaled back in recent years. One option is honest services fraud under 18 U.S.C. 1346, which says public officials owe the people the intangible right of honest services, and selling influence in secret cheats the public of that right. But in 2010, the Supreme Court narrowed the law in Skilling versus United States, the Enron case, holding it only applies to clear bribes and kickbacks. But again, this kind of seems like a preemptive bribe and kickback. There's also the option to charge conspiracy under 18 U.S.C. 371. The bar is much lower for conspiracy since all prosecutors need to show is an agreement and some overt act in furtherance of that agreement. So this means you don't actually need a successful bribe to charge conspiracy. All you need is an agreement and an overt act towards the end of that agreement. And a bag of cash in a kava bag could check that box. And even if the actual bribe didn't amount to an official act, prosecutors could charge conspiracy to commit bribery in the future. But since this meeting happened sometime in the summer of 2024, before Trump was elected and before Homan was appointed as border czar, prosecutors would have trouble showing that there was an official act before the Trump administration took power. But on the other side of the coin, all you'd need is some overt act in furtherance of the conspiracy once Homan was an actual official. But it's clear that this administration doesn't want one of its guys to take the fall and just spiked the investigation. It's clear that the Justice Department under other presidents certainly would not let Homan walk away with $50,000 in cash without charging him with at least a failure to report that money. But here we have a DOJ and an administration that's openly corrupt. Obviously, AG Bondi and FBI Director Patel don't care about the money or the corruption. Even if they couldn't prove bribery at the time just because of the sting, once Homan became border czar, the FBI should have continued to monitor Homan to see if he started delivering on explicit promises. But instead, they gave Homan the green light to enrich himself and his allies and go on Fox News and accurately, at that moment in time, say that he had not done anything illegal. Now, if you also haven't done anything illegal, wink, you'll want a good lawyer. Luckily, I know a guy. President Trump is big mad at Harvard. I mean, I am too, but for very different reasons. But in retribution for fighting back against the administration, President Trump is trying to prevent any international students from studying at Harvard. But hours after he tried to prevent Harvard from enrolling or continue to enroll international students, a judge stepped in and enjoined it, at least temporarily. Yes, President Trump and DHS Secretary Kristi Noem thought they could deport every international student and teacher at Harvard. But Harvard's conservative lawyers, led by Trump fighters Jenner and Block, marched into court early Friday morning, and a federal district court judge shot down the government's policy before Trump and Noem even had a chance to finish their morning coffee. This one might take the cake as the fastest injunction against the Trump administration, being issued just mere business hours after the initial complaint had been filed. As you may know, President Trump has been targeting Harvard ever since the university openly defied his demands to limit pro-Palestinian activism and end diversity, equity, and inclusion practices. But now Secretary Noem alleges that foreign students and teachers have turned Harvard into a den of anti-Semitism and communism. So she purportedly revoked Harvard University's certification under the Student and Exchange Visitor Program, which I'm just going to call CVIP for short, which is the program which allows universities to admit international students. And although the administration claims that their actions are motivated by students who are Hamas sympathizers, whatever that means, the policy makes no such distinctions. So today we're going to delve into Trump's attack on Harvard's foreign students and explain why a district court quickly put a stop to it. Now, for over 70 years, Harvard has hosted international students under the F1 and J1 visa programs. The F1 visa is for international students and the J1 visa is for teachers and researchers. Now, to maintain their certification, schools have to adhere to strict record-keeping, reporting, and compliance requirements, and students have to remain enrolled in school full-time to stay in status. But on April 16, 2025, DHS Secretary Kristi Noem sent a records request to Harvard, citing Harvard's alleged failure to condemn anti-Semitism and implying a hostile campus environment. The request demanded broad and vague data about every international student, including whether they had engaged in, quote, illegal activity, made threats, or obstructed the learning environment. Now, Noem's request did not define any of these terms. But according to Harvard's complaint, quote, over the last 12 years, Harvard had received only a handful of requests for information about its F1 visa students. These requests have generally sought straightforward information plainly contemplated by the applicable regulations, such as the student's email, physical address, and phone number about a single student at a time. No prior request has asked for information as broad or as open-ended or covering as many students as the records request. Now, DHS gave Harvard a laughably short 10 business days to comply, threatening that their failure would be treated as, quote, voluntary withdrawal from the F1 program with no appeal allowed. Now, despite the unprecedented scope of the letter, Harvard claims that they complied with the request. On April 30th, Harvard submitted the records outlined by 8 CFR 214.3, including records of coursework and academic transcripts. And on May 14th, it submitted additional information in response to a follow-up request. And in its response letter, Harvard asked the government for the opportunity to cure any alleged non-compliance. And the university contends that DHS cannot unilaterally revoke its CVIP certification without allowing it a chance to address the government's concerns. Now, when Harvard filed its lawsuit, its complaint cites 5 U.S.C. 558C, which states that before revoking a license, the government must give the licensee, quote, notice of the facts or conduct which may warrant the action and an opportunity to demonstrate or achieve compliance with all lawful requirements. Nevertheless, on May 22nd, DHS revoked Harvard's CVIP certification, calling its responses insufficient, without providing justification or citing any specific regulation that Harvard violated. Now, Harvard alleges that DHS failed to, quote, follow any of the detailed processes required under the regulations prior to revoking a school's certification. And the lawsuit brings 3 claims against the government. First, Harvard claims that the government violated the First Amendment by retaliating against the university after Harvard refused to adopt the political directives and suppress certain viewpoints. Harvard alleges the government explicitly tied its punitive actions to Harvard's speech and refusal to follow Trump's ideological mandates, such as conducting viewpoint audits and disciplining specific student groups. Now, the second claim is for violating the Fifth Amendment's right to due process. Harvard argues it was denied notice and an opportunity to contest the CVIP revocation, violating procedural due process. DHS allegedly skipped the entire regulatory process outlined in 8 CFR 214.3 and 214.4, which required notice, a formal review, and an opportunity to respond. And the third claim is for violations of the Administrative Procedure Act. Harvard asserts that DHS failed to follow mandatory procedures and did not identify any lawful basis or specific regulatory violation to justify revoking its certification. The government's decision to revoke Harvard's certification was arbitrary, capricious, and unsupported by a reasoned explanation. And it may not surprise you that all 3 of these claims appear to be very strong at first blush. But let's look at how the First Amendment actually operates in higher education. Do they have a leg to stand on? Now, the First Amendment protects individuals from government interference in freedom of speech, religion, press, assembly, and petition. However, it only restricts government actors. That means that Harvard, as a private institution, generally is not directly bound by the First Amendment in the same way that a public university like the University of California is. If Harvard wanted to implement all kinds of restrictions on speech, it probably could. Harvard itself enjoys robust First Amendment protections. That means that Harvard can speak as an institution, take positions on issues, and curate academic environments without government interference, generally speaking. And a school can also generally decide on who to admit, hire, or associate with, as long as it follows anti-discrimination laws. And the Supreme Court interprets the First Amendment to protect academic freedom of institutions and faculty, especially in contexts like scholarly research and teaching. The Supreme Court has held that academic freedom is a, quote, special concern of the First Amendment, and the first major recognition of academic freedom as a First Amendment concern came in the 1957 case of Sweezy versus New Hampshire. Paul Sweezy was an academic and Marxist economist, and during the Red Scare, New Hampshire passed a law empowering the state attorney general to investigate subversive persons. Now, the AG subpoenaed Sweezy to testify about the content of his lectures and political affiliations, and Sweezy testified that he was not a Communist Party member and did not want to overthrow the government. However, he refused to answer other questions such as his personal beliefs about communism, his knowledge of the Progressive Party in New Hampshire and its members, and the content of his lectures. But the state claimed that during a lecture he described, quote, socialism as inevitable in this country, and they asked him if he believed in the theory of dialectical materialism, because people always forget the connection between Hegel and Marx, and whether he advocated Marxism to his students. And when Sweezy refused to answer, he was held in contempt of court. Now, appeals courts upheld his conviction, but the Supreme Court overturned it. The plurality decision struck down the application of the state's Subversive Activities Act because it was overly broad. Then in 1967, the Supreme Court struck down loyalty oaths for public school teachers in Keishian versus Board of Regents. In that case, as a condition of employment, New York state laws required teachers to sign loyalty oaths to refrain from, quote, treasonable or seditious speech or acts. All employees had to certify that they weren't members of the Communist Party. The plaintiff and his colleagues refused to sign the loyalty pledge, and their contracts were terminated. The Supreme Court reversed in favor of Keishian on the basis that the statutes were unconstitutionally vague and overbroad. And the court held that the New York laws had a stifling effect on the, quote, free play of the spirit which all teachers ought especially to cultivate and practice. The majority said, quote, our nation is deeply committed to safeguarding academic freedom, which is of transcendent value to all of us and not merely to the teachers concerned. That freedom is therefore a special concern of the First Amendment, which does not tolerate laws that cast a pall of orthodoxy over the classroom. The vigilant protection of constitutional freedoms is nowhere more vital than the community of American schools. The classroom is particularly the marketplace of ideas. The nation's future depends upon leaders trained through wide exposure to that robust exchange of ideas which discovers truth out of a multitude of tongues rather than through any kind of authoritative selection. And that probably gives you an idea of why Harvard's lawsuit frames its First Amendment claims in the context of academic freedom. The complaint states that, quote, Harvard has long exercised its academic freedom by determining for itself on academic grounds who may teach and what they teach. And Harvard alleges that, quote, the revocation is a blatant violation of the First Amendment, the Due Process Clause, and the Administrative Procedure Act. And Harvard went out of its way in compiling evidence that the administration is retaliating against it for refusing the government's demands. On April 11th, the Trump administration sent a letter to the university seeking full control over Harvard's curricula. Quote, the government demanded, among other things, that Harvard hire a third party to audit the viewpoints of its students, faculty, and staff. Depending on the results of the audit, hire and admit a critical mass of people to achieve the government's preferred level of viewpoint diversity in each department, field, or teaching unit, refuse admission to international students hostile to American values, exclusively empower faculty supportive of the government's action and reduce the power of those opposed, allow the government to review its faculty hires, expel or suspend specific sets of students, disband disfavored student clubs, establish mechanisms for Harvard community members to report on one another and send those reports to the government, which, yeah, seems like an all-out assault on Harvard's First Amendment rights. Then on April 14th, Harvard refused the government's demands, and just hours later, the Trump administration retaliated by freezing more than $2.2 billion in research funding. On April 15th, Trump posted about revoking Harvard's tax-exempt status. Then on April 16th, Noam sent her letter demanding detailed information on all foreign students, and the government issued a press release explaining that Harvard had, quote, allowed anti-American pro-Hamas ideology to poison its campus and classrooms and undermine America's values. On April 24th, Trump's newly weaponized EEOC announced it was investigating Harvard's hiring practices, and on May 13th, the Department of Justice issued a civil investigative demand to the university for allegedly violating the False Claims Act by continuing to maintain affirmative action programs struck down by the Supreme Court. Quote, the surrounding events and defendants' express statements make clear that DHS took these actions not for any valid reason, but purely as punishment for Harvard's speech, its perceived viewpoint, and its refusal to surrender its academic independence or relinquish its constitutional rights. A central tenet of our constitutional system is that the government cannot invoke legal sanctions and other means of coercion to micromanage private speech. And it is bedrock law that the viewpoint-based justifications the government has repeatedly and publicly invoked as a basis for its campaign against Harvard are a particularly egregious form of content discrimination, subject to the strictest scrutiny. The government's actions violate Harvard's rights under the First Amendment several times over. So mere hours after Harvard filed its lawsuit, which itself was only mere hours after the government revoked its certification, Harvard filed a motion for a temporary restraining order asking the court to vacate DHS's revocation of its CVIP certification, enjoin DHS from enforcing the decertification, and restore its ability to enroll and host international students under the F1 and J1 visa programs. Harvard argued that the revocation inflicted serious harm by immediately stripping legal visa status from over 5,000 students, and it arguably barred new students from enrolling for the summer and fall terms. It also dealt a blow to Harvard's finances since most foreign students pay full tuition, which winds up subsidizing American students. And the revocation would also hurt the school's ability to recruit international talent. And surprising no one, the Massachusetts District Court immediately granted the motion. The judge's order enjoins the administration from, quote, implementing, instituting, maintaining, or giving effect to the revocation of plaintiff's CVIP certification, giving any force or effect to the Department of Homeland Security's May 22, 2025 revocation notice, and the court set a preliminary injunction hearing for May 29th. So Harvard's international students are safe for now. Trigger warning, if you are a lawyer, you probably do not want to watch this video. But if you're not, or you just want your daily dose of schadenfreude, let's talk about what happened. This is every lawyer's absolute worst nightmare. Yes, a poor lawyer at the DOJ did the unthinkable. Not only did they file the wrong document with the court, that's bad enough, but they filed an internal, privileged memo containing their legal analysis of the case. And spoiler, the lawyers think their case is terrible. Yes, this poor lawyer filed a secret work product memo that explains in detail why they should lose the case. I don't think you can see it under my Indochino suit, but I actually have goosebumps. This is horrible. I am dying of Fremdschämen. This is every lawyer's worst nightmare. And other than stealing from your client, this is probably the worst thing you can possibly do to your client. So this all comes from the Metropolitan Transit Authority versus Duffy case in the Southern District of New York. This is the case where the Trump administration is trying to block New York City's traffic congestion pricing program. And in their complaint, the MTA describes the Central Business District tolling program this way, quote, a market-based user pay solution that has seen success in major cities around the world. The program accomplishes its aims by tolling eligible vehicles entering the CBD in order to encourage mass transportation and using that money to support the city's transportation infrastructure. In a matter of weeks, the program has already achieved remarkable results. Traffic congestion and commute times have materially fallen, more people in Manhattan's commercial districts and supporting the region's businesses, and the MTA's vital transit system is seeing the benefit of increased funding. Despite its obvious success, however, the Trump administration has precipitously and for blatantly political reasons purported to terminate the program, as then candidate Trump proclaimed he would do in his first week in office. The administration's efforts to summarily and unilaterally overturn the considered determinations of the political branches, federal, state, and city, are unlawful, and the court should declare that they are null and void. Now, I don't want to get into the weeds on this case. Suffice to say, the program was overwhelmingly popular with New York City residents, loved by urbanists, and hated by the commuters in New Jersey and President Trump for reasons. But the Trump administration's efforts to stop the program were always on dubious legal footing. Most commentators agree that the federal government would not succeed in stopping the state program. So the New York MTA filed suit in February of 2025, seeking to prevent the Trump administration from stopping the program. Fast forward a few months to April of 2025, there have been some various procedural issues, some conferences, an amended complaint, totally normal stuff. And on April 9th, the court issues an order that defendants shall produce the administrative record by May 27, 2025. Defendants shall inform the court by no later than April 23rd, 2025, whether they anticipate the administrative record to include any documents other than Secretary Duffy's letter dated February 19th, 2025. Okay, again, totally normal stuff. The court just wants to know if the defendants want to include anything in evidence as they move forward with motion practice, and the main piece of evidence was Transportation Secretary Sean Duffy's letter, where he lays out a whole bunch of reasons why New York needed to shut down congestion pricing. And New York procedure is a little bit weird in this respect. When you're communicating with the court or you need to make a request, then you basically write a letter to the judge, and if you need to submit a document, then you attach that as an attachment to the letter itself. So on the agreed upon deadline of April 23rd, the DOJ lawyer files letter addressed to Judge Louis J. Lyman from Dominika Tarzinska, dated April 23rd, 2025, Ray, administrative record, in April 20th, 2025, Secretary Duffy letter. As you can see from the docket entry, it contained the letter itself and an exhibit, the letter from Sean Duffy that was dated earlier. Now for background, this is the copy of the original PACER docket. PACER, or ECF, is the god-awful electronic system that lawyers use to file documents in federal court. It's so bad, it was out of date 20 years ago and it hasn't really been updated since. But the docket entry looks right. But what's wrong is the attached document. It is not the anodyne letter stating that they intend to supplement the administrative record. No, it's much, much worse. The thing that was attached was this. It's a letter with the US Department of Justice letterhead. Okay, so far so good. But the person receiving it is not Judge Lyman. It's Aaron Hendrickson, Senior Trial Attorney, Office of Litigation and Enforcement, US Department of Transportation. Oh God, this is an internal strategy memo. The letter starts off, quote, "Dear Aaron, we write with respect to the above referenced litigation brought by the Metropolitan Transportation Authority against the U.S. Department of Transportation, U.S. Secretary of Transportation Sean Duffy, the Federal Highway Administration, and Executive Director of the FHWA, Gloria Shepard, to provide you with information concerning the litigation risk that DOT faces in defending the Secretary's February 19, 2025 decision, to provide you with information concerning 1, the litigation risk that DOT faces in defending the Secretary's February 19, 2025 decision, and 2, a process for terminating the CBD-TP agreement outside of the current litigation for DOT to consider. As discussed below, there is considerable litigation risk in defending the Secretary's February 19, 2025 decision against plaintiffs' claims under the Administrative Procedure Act that the decision was contrary to law, pretextual, procedurally arbitrary and capricious, and a violation of due process. For the reasons outlined below, it is unlikely that Judge Lyman or further courts of review will accept the argument that the CBD-TP was not a statutorily authorized value pricing pilot under the Value Pricing Pilot Program. Oh no! This is an objective memo talking about all the weaknesses of their case. It continues. The Secretary provides 2 reasons why the CBD-TP is not an eligible pilot project under the VPP statutory language. 1, the program constitutes impermissible cordon pricing, which is not authorized because it does not offer a toll-free option. And 2, the level of CBD-TP tolls has been set primarily by the need to raise revenues rather than prevent congestion. Neither of these reasons is likely to convince the court. First, with respect to the rationale that cordon pricing is not authorized under the phrase congestion pricing or value pricing, we have been unable to identify a compelling legal argument to support this position. Oh no, they're admitting that their arguments are bad. It continues yet further. As a result, it is unlikely that courts will narrowly construe the term congestion pricing to exclude cordon pricing projects based on the long-standing prohibition on tolling alone. Yikes. It continues. Although DOT's interpretation of the statutory language cannot bind a court may still look to the long-standing practice of the government, like any other interpretive aid, to inform the court's determination of what the law is, citing Loper Bright. Now, this is funny just as an aside because it was a right-wing cause célèbre that the court did away with called Chevron deference, where the courts would defer to an administration's interpretation of regulations, and the Supreme Court just did away with that. Here, the administration absolutely would have wanted the court to defer to the Department of Transportation's interpretation of its own regulation and law, but they can't now because the Supreme Court says it doesn't really matter what the agency thinks. It only matters what the court thinks. But they continue further. The Secretary's letter further asserts that cordon pricing in this context is impermissible because it, unlike other congestion pricing strategies, does not provide a toll-free option. As outlined above, the legislative history and FHWA's prior guidance implementing the VPPP undercut this assertion. It is very unlikely that Judge Lyman or any court of review would agree with that assertion. Ouch. And the letter goes on. Second, with respect to the argument that the CBD-TP is not authorized because the VPPP does not authorize tolls that are based on considerations separate from reducing congestion or advancing other road-related goals, there are 2 impediments to this argument being successful. It is very unlikely that Judge Lyman or further courts of review will uphold the Secretary's decision on the legal grounds articulated in the letter. Defending this case on this basis, with the most likely outcome being vacatur of the Secretary's decision or remand to the agency for further administrative process, will only serve to delay FHWA's elimination of the CBD-TP. The agency will have to answer the MTA's and interveners' complaints, compile and produce the administrative record, and then the parties will engage in briefing, likely oral argument, and await a decision from Judge Lyman, which is exceedingly likely to be adverse to the agency. I can't imagine filing this memo. I don't know what I would do. I would commit ritual seppuku. I would absolutely just stick a sword in my stomach and just, pull up. This is the most horrible thing I can think of as a litigator. It is the most horrible thing you could possibly do unintentionally to a client to file this strategy memo. And look, this strategy memo is totally normal. There's nothing wrong with it at all. The client needs to be fully apprised of the strengths and weaknesses of their case. The DOJ is bound to deal with their client, the federal government, in particular the Secretary of Transportation, Sean Duffy, and they have to zealously advocate to the best of their ability. So totally normal that you would put together an objective memo talking about the strengths and weaknesses of your particular case so that there can be internal discussion about the best way to move forward. But that analysis should never see the light of day. I'm shivering. It's so horrible. It's secondhand embarrassment. I'm going to die. But let's keep going. The letter continues. While there is considerable litigation risk in defending the decision to terminate the CBDTP based on the argument that it is not a statutorily authorized value pricing pilot under the VPPP, FHWA may be able to accomplish the same goal for the same reasons, utilizing established OMB procedures for the termination of cooperative agreements. Now, this argument is probably dumb too, but it's not really worth explaining here. And the DOJ lawyers are probably right that it makes more sense to go down that route than it does to actually try to defend Secretary Duffy's original letter. But basically, you get a window into the strategy of the DOJ. The inadvertently released memo goes through their entire strategy and explains that their arguments are bad and that everything the Transportation Secretary Sean Duffy said was stupid. Now, I want to make clear here that I don't think the lawyers did anything wrong here other than file the absolute worst incorrect document they possibly could. As lawyers, you have to zealously advocate for your client, and they were probably boxed in by the statements of the Transportation Secretary Sean Duffy into what legal arguments that they could make, and they were trying to make the best of a bad situation by saying that the arguments that he forced them to make were probably not going to win, and they had a better legal strategy that they thought they should use. And even if the original legal arguments were losers, well, sometimes as lawyers, you want to make every argument that you can, and some of them are going to win, some of them are not. So you kind of roll the dice. That's a totally normal thing for a lawyer to do. Now, the lawyer who putatively filed this was Dominika Tarczynska. She appears to be a 10-year veteran of SDNY. She's probably not a Trump hack. She probably just had the absolute worst day of her life. Though it also might not have been her. She seems to be fairly senior at SDNY. It's entirely possible that a paralegal, secretary, or a junior attorney made this particular filing. Lawyers who litigate in federal court give our PACER logins to staff all the time. I myself have relied on legal secretaries and paralegals to have filed many filings in federal court. But the thing is, if you give your PACER login away to someone who then files something in federal court, you're still on the hook for whatever gets filed. You have to supervise them. And as I mentioned before, the PACER system is terrible. It's incredibly clunky. It's not surprising that things get filed on accident by mistake. And I'm sure that that's what happened here. This is an honest mistake, a real screw up. And I feel terrible. I feel so awful to even talk about this. This is the kind of thing that could happen to everyone. I'm sure the file name said, Transportation Secretary letter. And, off the face of the file name, it was probably possible to confuse these two things and just attach the wrong PDF. That absolutely does not excuse the screw up, but it does help explain things. Now, what looks like happened here is that pretty soon after this thing was filed and started making the rounds on social media, it looks like they called the clerk and asked the clerk of the court to take this docket entry down, and the clerk did so. There is no longer a docket entry number 65 on the public docket, but of course the damage was done. If this was private practice, you would immediately file a letter with opposing counsel and the court seeking to claw back any document that was inadvertently released, and you would probably immediately get on the phone with your malpractice carrier and explain that you did a malpractice and that they might need to make some payments on the insurance policy for malpractice. And that's exactly what happened here. The lawyer issued basically a clawback letter explaining everything to the court, explaining that she had reached out to the clerk to take the original docket entry down. Opposing counsel didn't oppose and moved to seal the inadvertent filing so no one could see it on the public docket ever again, though at that point the horse was out of the barn. In this particular litigation, the document was taken down. There was a follow-up filing that included the correct letter. And I'm sure what's going to happen is that everyone is going to pretend like this never happened. This is pure legal analysis and strategy. So it's not like they are admitting that they suborned perjury or that they are holding on to evidence that they didn't turn over to the other side. Everyone's just going to pretend that they didn't read it after they, of course, did read it. And I don't really think this is going to affect the rest of the litigation. People are probably going to get fired over this. It's unbelievably embarrassing. And like I said, it's the worst thing that I can imagine doing inadvertently. The only thing that I can think that comes close to this is when Alex Jones's lawyers accidentally turned over gigabytes of phone data that they absolutely refused to turn over to opposing counsel, and then Mark Bankston cross-examined Alex Jones and used the evidence that his lawyers had turned over. This, I think, is still worse because this isn't just evidence, this is internal trial strategy and legal analysis. But for the sake of professional courtesy, I'm sure everyone from opposing counsel to the judge will just pretend it never happened. When President Donald Trump targeted law firms with executive orders, some fought back and some bent the knee. And I took that personally. Those who capitulated looked like fools, and as a bonus, they are also losing clients. Now, everyone already hated firms like Skadden and Kirkland & Ellis, but some got really taken for a ride. Case in point, the law firm of Simpson and Thatcher, which agreed to perform $125 million in free legal work for causes acceptable to the Trump administration. And shortly after Simpson and Thatcher bent the knee, one of their huge clients, Microsoft, dumped them. The firm was working on a massive case related to the company's acquisition of Activision Blizzard, but Microsoft dumped them and hired the firm of Jenner Block, a firm that actually stood up to Trump's executive orders. Now, as we predicted and opined on this channel, the law firms who responded with, "We'll fight you in court," are looking pretty good, but now they've been justified. Federal District Court Judge Beryl Howell in D.C. has now ruled that Trump's executive order targeting Perkins Coie was unconstitutional, rendering the order now null and void. And the judge's order is scathing. Judge Howell issued a permanent injunction blocking the executive order in its entirety, and she started off by saying, quote, "No American president has ever before issued executive orders like the one at issue in this lawsuit, targeting a prominent law firm with adverse actions to be executed by all executive branch agencies, but in purpose and effect, this action draws from a playbook as old as Shakespeare, who penned the phrase, 'The first thing we do, let's kill all the lawyers,' William Shakespeare, Henry VI. When Shakespeare's character, a rebel leader intent on becoming king, hears this suggestion, he promptly incorporates this tactic as part of his plan to assume power, leading in the same scene to the rebel leader demanding away with him, referring to an educated clerk who can make obligations and write court hand. Eliminating lawyers as the guardians of the rule of law removes a major impediment to the path to more power. See Walters versus National Association of Radiation Survivors, explaining the import of the same Shakespearean statement to be that disposing of lawyers is a step in the direction of a totalitarian form of government. The importance of independent lawyers to ensuring the American judicial system's fair and impartial administration of justice has been recognized in this country since its founding era. In 1770, John Adams made the singularly unpopular decision to represent 8 British soldiers charged with murder for the roles in the Boston Massacre, and claimed later to have suffered the loss of more than half his practice. "I had no hesitation," he explained, "since counsel ought to be the very last thing that an accused person should want in a free country, and the bar ought to be independent and impartial at all times and in every circumstance. The instant case presents an unprecedented attack on these founding principles. By its term, this order stigmatizes and penalizes a particular law firm and its employees, from its partners to its associate attorneys, secretaries, and mailroom attendants, due to the firm's representation, both in the past and currently, of clients pursuing claims and taking positions with which the current president disagrees, as well as the firm's own speech. In a cringeworthy twist on the theatrical phrase, 'Let's kill all the lawyers,' EO 14230 takes the approach of 'Let's kill all the lawyers I don't like,' sending the clear message, lawyers must stick to the party line or else." Now, in a footnote, Judge Howell addresses law firms like Simpson Thatcher, Kirkland & Ellis, and Skadden Arps. Quote, "This message has been heard and heeded by some targeted law firms, as reflected in their choice, after reportedly direct dealings with the current White House, to agree to demand terms, perhaps viewing this choice as the best alternative for their clients and employees. Yet some clients may harbor reservations about the implications of such deals for the vigorous and zealous representation to which they are entitled from ethically responsible counsel, since at least the publicized deal terms appear only to forestall rather than eliminate the threat of being targeted in an executive order. Only when lawyers make the choice to challenge rather than back down when confronted with government actions raising non-trivial constitutional issues can a case be brought to court for judicial review of the legal merits, as was done in this case by plaintiff Perkins Coie LLP, plaintiffs' counsel Williams and Connolly, and the lawyers' firms, organizations, and individuals who submitted amicus briefs in this case. As one amicus put it, "Our judicial system is under serious threat when determining whether to file an amicus brief could be a career-ending decision. But when lawyers are apprehensive about retribution simply for filing a brief adverse to the government, there is no other choice but to do so." If the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and, by doing so, serve to promote the rule of law will be the models lauded when this period of American history is written. Now, if you've been watching this channel recently, then you'll know that I, along with over 500 different law firms, signed an amicus brief in support of Perkins Coie. And the amicus brief that Judge Howell just cited is a different amicus brief, but I wholeheartedly join in the sentiments of the Pickering law firm in that particular brief. That brief was filed by a Massachusetts solo practitioner who, on his own, decided to stand up to Trump on behalf of his fellow lawyers. And the contrast between Kenneth C. Pickering and firms like Paul Weiss and Simpson Thatcher could not be more stark. And turning to the First Amendment, Judge Howell wrote, quote, "One obvious implication of these First Amendment protections is that government officials may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. This prohibition also extends to retaliation against individuals for the specific viewpoint expressed by the First Amendment protected activities. since the government may not use the power of the state to punish or suppress disfavored expression, nor use threats of legal sanctions and other means of coercion to achieve the suppression of disfavored speech, retaliation and threats of retaliation to effectuate viewpoint discrimination is uniquely harmful to a free and democratic society. To prevail on these claims, plaintiffs must show that the firm engaged in conduct protected under the First Amendment, 2, that EO 14230 took some retaliatory action sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again, and 3, that there is a causal link between the protected First Amendment activity and the adverse action taken against the firm. And the judge ruled that plaintiffs easily satisfied these requirements. Quote, here, no genuine dispute of material fact exists as to any of these 3 elements, and thus plaintiff is entitled to summary judgment on counts 5 and 7. EO 14230 openly acknowledges the plaintiff engaged in speech and other activities protected by the First Amendment. Section 1 of the order, which sets out its purpose, cites 3 reasons for the enumerated action items in sections 2 through 5 that federal agencies are ordered to take against plaintiff. 1, the firm's representation of Hillary Clinton during the 2016 presidential election. 2, the firm's involvement in litigation against election laws, including those requiring voter identification, and 3, the firm's alleged discrimination in hiring and promotion and efforts to purposefully hide the nature of this alleged discrimination through deceiving language. The associated fact sheet adds a 4th. Perkins Coie LLP has filed lawsuits against the Trump administration, which are also described as partisan lawsuits against the United States. Judge Howell ruled that President Trump's intent to retaliate against Perkins Coie because of its political views was obvious. Quote, the 1st, 2nd, and 4th reasons reference the firm's representation of clients, namely President Trump's opponent in the 2016 presidential election, parties in election litigation, and parties challenging Trump administration actions. Well-settled law establishes that advocacy by attorneys to the courts falls within the category of private speech protected by the First Amendment, meaning that plaintiff's representation of a political opponent of the current president and involvement in election litigation and lawsuits against the Trump administration explicitly qualifies as core First Amendment speech. Now, the Trump administration also claimed that law firms which champion diversity are breaking the law. As for the claim that Perkins engaged in unlawful employment practices, Judge Howell noted it's not illegal to hire black lawyers and female lawyers. She saw the government's assertion for what they are. Quote, the government's briefing reveals the true motivation lurking behind the facade of discrimination allegations, the administration's disapproval of plaintiff speech in favor of diversity. This revelation makes clear the pretextual nature of EO 14230's cited reason regarding plaintiff's reported discrimination. For instance, the government points to the firm's statements about efforts to contribute to the advancement of our historically underrepresented attorneys and success in hiring new partners who are women or attorneys of color. Once again, however, the government provides no evidence to suggest that any of these statements show any suspect or illegal actions by plaintiff. Even more probative of the fact that plaintiff's speech is at issue is that the government argues that statements in the amended complaint repeatedly asserting plaintiff's commitment to diversity and showing no apparent intention of backing away somehow support the government's actions targeting the firm in the order. These 4 reasons are the sole rationales provided for in the issuance of EO 14230, and each, on their face, implicate First Amendment protected activities. The judge also found that the executive order was enough to chill speech. Quote, the second requirement for a retaliation claim that plaintiffs show the actions taken against the firm were sufficient to deter a person of ordinary firmness in plaintiff's position from speaking again is satisfied by plaintiff's showing of irreparable harm and further bolstered by the reactions of plaintiff's peer law firms. The fact that Paul Weiss quickly negotiated a deal, including an agreement to provide the equivalent of $40 million in free legal work rather than face the potential injuries of this similar executive order targeting that firm, demonstrates the coercive power of such targeting by the Trump administration. This conclusion is further confirmed by the reaction of additional peer law firms that chose to negotiate deals with the Trump White House to avoid being targeted by similar executive orders. Now, President Trump claimed his executive orders were meant to protect the public interest, but Judge Howell found, quote, EO 14230, the accompanying fact sheet, and the context surrounding the order's issuance each express President Trump's disapproval of plaintiff's First Amendment activity and demonstrate that EO 14230 targeted plaintiff because the firm expressed support for employment policies the president does not like, represented clients the president does not like, represented clients seeking litigation results the president does not like, and represented clients challenging some of the president's actions, which he also does not like. This is unconstitutional retaliation and viewpoint discrimination, plain and simple. Plaintiff is therefore entitled to summary judgment on counts 5 and 7. And Judge Howell also explained the vagueness of the government's attack on diversity, equity, and inclusion. Quote, the order goes on to mention the administration's goal of ending discrimination under diversity, equity, and inclusion policies, leading to a possible inference that such policies and not any concrete evidence of discrimination are the problematic conduct that the plaintiff should avoid. The terms diversity, equity, and inclusion, taken collectively or individually, however, could refer to a wide range of actions and programs, formal or informal, as well as basic thoughts and beliefs. The order provides no definition or guidance as to what form of program possibly described by these terms is considered unlawful discrimination by the Trump administration, leaving plaintiff to guess at what is and is not permissible in the government's view, while already facing the threat of adverse actions during the guessing. The government's own briefing reflects this uncertainty. While repeatedly accusing the plaintiff of engaging in racial discrimination, the government at various times also state that 1, plaintiff should be investigated by the EEOC to determine whether they are violating the civil rights laws. 2, the government is merely trying to advance valid social policies regarding discrimination rather than enforcing any legal prohibitions. 3, diversity initiatives are legally suspect and thus plaintiff's practices provide ample basis for review. 4, the government is merely raising legitimate legal issues of just how far DEI policies and programs can go and whether such policies cross the line into illegal discrimination. 5, plaintiff engaged in aggressive DEI practices. And 6, plaintiff appears to have engaged in what the government characterizes as discrimination. When even the government cannot decide what exactly the grounds for its actions were, plaintiff is truly left unable to know what conduct to avoid. On top of that, in a topic that may only be interesting to legal weirdos like myself, Judge Howell did not get into the issue of whether the executive order qualified as a bill of attainder, but she made it very clear that had she gotten to that issue, she would have found that it was a bill of attainder, and specifically against one particular entity, in this case, the law firm. So at the end, the judge therefore concluded, quote, "The U.S. Constitution affords critical protections against executive action like that ordered in EO 14230. Government officials, including the president, may not subject individuals to retaliatory actions after the fact for having engaged in protected speech. They may neither use the power of the state to punish or suppress disfavored expression, nor engage in the use of purely personal and arbitrary power. In this case, these and other foundational protections were violated by EO 14230. On that basis, this court has found that EO 14230 violates the Constitution and is thus null and void. For the reasons explained, plaintiff is entitled to summary judgment and declaratory and permanent injunctive relief on counts 2 through 9 of the amended complaint. The government's motion to dismiss is denied. Now, it's possible this might go up on appeal, though this administration has shown that sometimes when they lose the really obvious cases like this one, they don't even bother to appeal it, so that's also a possibility here. But this case is now ripe for appeal if the government so chooses, and if they do, they're gonna lose again because this is unbelievably illegal conduct. And the lesson here is that lawyers and law firms simply cannot capitulate to a person who says he isn't sure if presidents have to uphold the Constitution. Doge went to war against peace. The Institute of Peace, that is. Yes, somehow Doge and the federal government went to war against the Institute of Peace, and they brought armed police officers. Yes, Doge brought guns to a peace fight. You might have heard that in February, President Trump issued an executive order directing the dismantling of the 40-year-old Institute of Peace, which had been created during the Cold War to prevent war and promote nonviolent conflict resolution around the world. But the Institute pointed to the law that created it, which specifies that the Institute is an independent nonprofit organization, not an executive agency, and thus isn't under President Trump's authority. Doge heard these arguments and decided to move forward with a hostile takeover anyway. Literally a hostile takeover with guns. And on March 17th, with the help of armed officers from 3 law enforcement agencies and 1 private security contractor, Doge staged a dramatic physical invasion of the Institute of Peace's privately owned headquarters, the building in Washington, D.C. This culminated in the ousting of the Institute's leadership, the takeover of the organization's computer systems, and the takedown of the Institute's website. And of course, yet another lawsuit against the Trump administration. I'd like to come up with a pithy metaphor, but when you physically take over the Institute of Peace with armed law enforcement officers, I got nothing. But how did we get here? Well, in 1984, the United States Congress established the Institute of Peace to, quote, promote international peace and the resolution of conflicts among the nations and peoples of the world without recourse to violence. The act that established the Institute stated explicitly that the Institute is an independent, nonprofit national institute. Now, over the past 40 years, the Institute has provided research, analysis, and training in diplomacy, mediation, and other peace-building measures. It has been on the ground in Iraq, Afghanistan, Pakistan, Colombia, and the Philippines. In Baghdad, for example, the Institute helped to reduce sectarian violence by conducting mediations between Sunni and Shia factions, imams from local mosques, militia leaders, and tribal chieftains. And when Congress created the Institute, it included several provisions designed to ensure the Institute's independence. First, Congress instructed that the Institute was to be run by a 15-member board, which would include 3 ex officio board members, the Secretary of State, the Secretary of Defense, and the President of the National Defense University, as well as 12 individuals selected by the President with the advice and consent of the Senate. The board must be politically balanced. No more than 8 members of the board can be from the same political party, and board members have specified terms and can only be removed by the President under the following narrow circumstances. 1, in consultation with the board for conviction of a felony, malfeasance in office, persistent neglect of duties, or inability to discharge duties. Or 2, upon the recommendation of 8 voting members of the board, or 3, upon the recommendation of a majority of the members of the Committee on Foreign Affairs and the Committee on Education and Labor of the House of Representatives, and a majority of the members of the Committee on Foreign Relations and the Committee on Labor and Human Resources of the Senate. Now, provisions like these are often known as for-cause provisions because they mean that a person can only be removed if certain causal conditions are met. Most agency heads in the executive branch serve at the pleasure of the president and can be dismissed for any reason whenever the president decides to remove them. But employees who are appointed under a for-cause provision, though, have additional protections and can only be dismissed by the president if certain requirements are met. Usually this involves misconduct or serious illegal activities. These for-cause removal provisions are designed to ensure that some employees are sheltered from partisan political whims and able to fulfill their statutory duties, which often involve some kind of oversight or independent action. Now, despite, or maybe because of its mission of peace, the Institute has long been in the political crosshairs. In 2011, with a little help from Republican Congressman Jason Chaffetz and Democratic Congressman Anthony Weiner, Republican Representative Chip Kravac introduced an amendment to cut all funding to the Institute, claiming that the Institute's programs could be replicated by several other agencies, including USAID, another agency that has recently been dismantled by the Trump administration. But the Institute's importance was defended by numerous public policy experts and military leaders, including General Anthony Zinni, who served as a special envoy under both George W. Bush and Donald Trump, and said that, quote, Congress would be hard-pressed to find an agency that does more with less, and that, quote, the idea that eliminating the United States Institute of Peace would benefit taxpayers is extremely short-sighted and ill-informed. America deserves better from Congress than eliminating something that saves American lives and taxpayer dollars. And he cited numerous instances where the Institute's personnel had real impacts in conflict resolution and violence reduction. President George W. Bush also proclaimed the importance of the Institute's work at the 2008 groundbreaking for the building Doge would later break into. And in fact, there were reports that the physical takeover of the building was simply because the building looks really cool. But he said, quote, the work of democratic development is the great cause of our time, and we shouldn't shy away from it. And we must be confident in our ability to help others realize the blessings of freedom. My big concern is that the United States becomes isolationist and nervous. We don't support those values that have stood the test of time. The Institute of Peace, I hope, will make sure that never happens. More recently, though, the Institute was the subject of a report by the Heritage Foundation, the same organization that spearheaded Project 2025, which we talked about at length in several of our videos. In a September 2024 Heritage Foundation report, the foundation urged Congress to defund the Institute of Peace based on the organization's supposed political bias and mission creep. And the Heritage Foundation offered a few examples of what it considered mission creep, stating, quote, in 2012, the USIP broadened its mission again to include interpersonal violence, with programs to end sexual violence during wars and internal conflicts, and in 2013 conducted a symposium on men, peace, and security that sought to encourage nonviolent notions of masculinity in societies affected by violent conflict. Now, defunding an organization through a lawful act of Congress like Heritage had recommended, though, would require the president to work with Congress. That would be totally legal. Congress could choose to defund an institute that it had previously decided to fund. But only Congress can decide that, since Congress alone has constitutionally delegated power to spend funds. And that's the kind of thing that happens in ordinary times. But we're not in ordinary times. So instead of asking Congress to defund the Institute of Peace, on February 19, 2025, President Trump signed an executive order 14217 titled Commencing the Reduction of Federal Bureaucracy, which recommended that the non-statutory components and functions of the Institute of Peace be eliminated to the maximum extent consistent with applicable law. But different people have a different definition of maximum extent consistent with applicable law. So armed with this executive order, Doge did what it does best, executing a chaotic and possibly illegal takeover. Now, after President Trump issued his executive order mandating the dismantling of the Institute of Peace, Doge wasted no time in moving in for the kill. The very next day, a representative of Doge contacted the Institute. The Institute leadership agreed to hold a virtual meeting with Doge several days later. In that meeting, representatives for the Institute, including its president, George Moose, and its outside attorney, George Foote, explained to Doge that the Institute is an independent nonprofit organization outside of the executive branch and thus is not subject to President Trump's executive order. The Institute followed up with a letter to the Office of Management and Budget, the OMB, reiterating its independent nonprofit status, but offering to maintain a cooperative relationship with the executive branch as it always had. In early March, though, George Moose heard that Doge was doing reconnaissance on the Institute's security operations, trying to determine who was the Institute's security contractor and strategizing how Doge could physically invade the Institute's headquarters. And shortly after that, the Trump White House engaged in one of its signature moves, questionably legal, politically motivated firings. Via email on March 14th, the White House doubled down on its position that the Institute is under the authority of the executive branch, ignored the statutory provisions of limiting the president's ability to fire Institute board members, and sent emails to all of the Institute's board members except the 3 ex officio members, declaring that they were fired. The emails, of course, didn't include any justification for the firings because there was none. Now, shortly after those emails were sent, Doge arrived at the Institute's building and tried to get in. But because the Institute, not the executive branch owns the building, George Moose told the Institute's private contractor security team, Intercon, not to allow Doge into the building unless Doge had a court order, which of course it did not. When Doge returned, they still didn't have a court order, but they did have several FBI agents. They presented the Institute's outside attorney with a letter that claimed that Moose had been removed from his position as president of the Institute. Then on March 16th, the FBI called and threatened the Institute's chief security officer, claiming that because he had denied Doge access to the building, he would now be under investigation by the Department of Justice. And fearing that Doge would try to strong-arm the Institute's security contractor, Intercon, the chief security officer recommended that the Institute suspend its contract with Intercon. The Institute followed this recommendation and revoked keycard access for Intercon. Unfortunately, the Institute leadership was unable to get back one of the physical keys that was held by Intercon's account manager. The next day, the account manager and several Intercon staff arrived with the physical key and entered the building, where the Institute's chief security officer and attorneys met them and told them that they were trespassing. The Intercon representative informed the Institute representatives that Doge had threatened to cancel every Intercon contract across the government if Intercon did not let Doge's representative into the building. Incredibly, Intercon staff then tried to get into the Institute's arms room where the guards' firearms were stored. At that point, the Institute's chief security officer and Institute president, George Moose, set the building on lockdown.
DC police showed up at my office and said, it's time for you to go.
Doge employees continued to try to access the building from the outside, at which point the DC police apparently arrived, and instead of assisting the Institute's original staff in keeping the Doge team out of the building, the DC police held open the doors to let Doge in. The DC police then escorted George Moose, the Institute's attorneys, and the Institute's chief security officer out of the building, not even allowing them to retrieve their personal belongings or cars on the way out. Doge wound up calling in the FBI and the Department of State's Diplomatic Security Service police officers to assist with the takeover. And the next day, Doge enlisted the help of an Institute of Peace employee in Georgia to help Doge get into the Institute's information systems. Since then, the Institute's website has disappeared entirely. Now, the Institute of Peace doesn't believe in violence, but it wasn't going to just capitulate to the Trump administration's bullying. Instead, the Institute's board members filed a lawsuit and asked for a temporary restraining order. And on March 18th, the Institute of Peace, along with 5 terminated board members, filed suit against President Trump, Secretary of State Rubio, Secretary of Defense Hegseth, National Defense University President Garvin, several members of Doge, and the individual that President Trump had tapped to be the new Institute president. The plaintiffs asked D.C. District Court Judge Beryl Howell to stop the termination of the board members and the Institute president and to prevent Doge from continuing to access the Institute's building and information systems. The plaintiffs generally argued that President Trump's executive order had overstepped his executive authority because the Institute is not an executive agency. Instead, it is a nonprofit organization incorporated under D.C. nonprofit laws. And by attempting to exert control over the Institute, President Trump had usurped the authority of Congress, which had created and funded the Institute and had explicitly designated it not as an agency under the executive branch, but as an independent nonprofit organization. The plaintiffs argued that President Trump had also violated the statute that created the Institute when he fired the board members without meeting the requirements for dismissal, and plaintiffs also asserted that President Trump and his 3 ex officio board members did not follow the correct procedures to remove the Institute's president, so they argued his firing was also illegal. And lastly, the plaintiffs argued that Doge's invasion of the Institute's headquarters was an illegal trespass. They pointed out that the building belongs to the Institute itself, not the executive branch, and the building purchase was funded by private gifts and contributions as authorized by the statute. Therefore, Doge's incursion into the building after being told repeatedly to leave was an illegal trespass. So plaintiffs asked the court for a temporary restraining order, or TRO. As we've talked about before, that's an extraordinary remedy which allows the court to issue an order without a hearing or the opportunity for appeal. And in order to obtain a TRO, a party has to demonstrate a likelihood of success on the merits, irreparable harm, and that the public interest weighs in favor of the TRO. Now, in their counter, the administration claimed that plaintiffs were unlikely to prevail on the merits because the institution is not actually an independent nonprofit. Instead, the administration argued that the Institute is part of the executive branch. They pointed out that the board is appointed by the President of the United States with the consent of the Senate, and because of this, defendants claim that the court doesn't actually have the authority to adjudicate a dispute between the Institute and the President, since both are within the executive branch of the government. And the defendants relied on the signing statement of President Reagan to argue that these statutory provisions that only allow for removal in narrow circumstances were not actually meant to limit the President's authority to fire board members. In Reagan's signing statement on the original 1984 U.S. Institute of Peace statute, President Reagan stated, quote, "I have been advised by the Attorney General that Section 1706F, relating to the President's power to remove members of the Board of Directors of the Institute, is neither intended to nor has the effect of restricting the President's constitutional power to remove those officers." Now, this was rather strange since a presidential signing statement has no effect and can't actually alter the plain text of the law, and the statute that created the Institute of Peace is clear about when a board member can and cannot be removed. But the administration also argued that while Congress can limit the grounds upon which the President may remove officers who serve quasi-judicial or quasi-legislative functions, it cannot limit removal for for executive officers who perform only executive functions. Defendants argue that the institute is more like the plaintiff in Myers versus United States and less like the plaintiff in Humphrey's Executor versus United States. So let's break this argument down. Now, Humphrey's Executor, which you might have heard in the news lately, was a Depression-era case that involved President Franklin Roosevelt's attempt to oust a federal trade commissioner. The FTC statute specified that commissioners could only be terminated for cause. President Roosevelt argued that this was an unconstitutional limitation on his executive power, but the Supreme Court disagreed, holding that the removal limitations in the FTC statute were permissible because the agency had quasi-judicial and quasi-legislative functions rather than executive branch functions. And when it's holding, the court relied on the specific functions of the FTC commissioners, which include making investigations and reports for Congress, a quasi-legislative function, and acting as an administrative judge, a quasi-judicial function. Now, the Humphrey's Executor Court distinguished Humphrey's Executor from the court's earlier case, Myers v. United States, which involved the removal of a postmaster. In Myers, the court ruled that the president could remove the postmaster in large part because the postmaster was an executive officer serving executive functions. As the Humphreys court said, quote, he's charged with no duty at all related to either legislative or judicial power. Now, more recently, in a 2020 case, Saylor Law versus Consumer Financial Protection Bureau, a divided Supreme Court considered whether the CFPB's structure was constitutionally sound under the parameters established in Humphrey's Executor. The CFPB is run by a single director who is appointed by the president for a 5-year term. And under the Dodd-Frank Act, the president could only remove the director for cause if the director demonstrated inefficiency, neglect of duty, or malfeasance in office. The court ruled that the president could fire the director at will, which means for any reason or no reason at all. And the court found a legal distinction between independent agencies headed by multiple members and independent agencies headed by single officials. Critics of the Saylor Law decision say there is little historical or textual support for creating a distinction between agencies headed by a single director and those with multiple members, though. But this was a victory for those who support the unitary executive theory of the Constitution. However, the decision did not overrule Humphrey's Executor, at least not entirely. The court reiterated that while the president does enjoy broad power to remove executive branch officials at will, there are exceptions to that power, including for, quote, a multi-member body of experts balanced along partisan lines that performed legislative and judicial functions and was said not to exercise any executive power. Which actually sounds a lot like the Institute of Peace. But the Trump administration argued that the Institute of Peace is more like the postmaster in Myers because the institute does not have quasi-legislative or quasi-judicial functions. Thus, Congress had unconstitutionally limited the president's removal power vis-a-vis the Institute's board. And this is part of the administration's larger goal of undermining or even eliminating independent agencies. The Trump administration has previously fired the head of the Office of Special Counsel, the Democratic members of the Privacy and Civil Liberties Board, numerous inspectors general, and most recently 2 Democratic FTC commissioners. And all this is in the news recently because President Trump wants to be able to fire, hire, or not hire anyone even remotely connected to the executive branch. And many people are worried in particular because Trump has indicated several times that he wants to be able to fire the head of the Federal Reserve and install someone who will implement the interest rates that President Trump wants. And the Saylor Law case is one of many indications that the Supreme Court is receptive to the unitary executive theory and will overturn Humphrey's Executor on that basis when the question comes before them. So while that case is still good law now, it may not be in the future. And defendants also contended that the plaintiffs failed to meet another part of the TRO requirement because they had not suffered irreparable harm. Defendants argued that the worst plaintiffs would suffer, even if their firings were legally impermissible, was the inconvenience of being unable to serve their job functions for a short period of time. So Judge Howell, a famous straight shooter, was tasked with figuring out whether plaintiffs had met these strict requirements for a TRO. And largely because of the complexity of the legal issues, Judge Howell declined to grant the Institute's request for a restraining order. While she expressed deep disapproval of DOJ's heavy-handed tactics, Judge Howell didn't feel like the Institute met the high standard for a TRO. Specifically, she wasn't sure that the Institute had made a legally sufficient showing that the Trump administration lacked authority to fire the board members and the Institute president. So while Judge Howell's order wasn't a victory for the plaintiffs, it wasn't a permanent defeat either. And this also highlights how extraordinary it is that judges keep issuing TROs against the Trump administration in other cases. It's a very, very high bar. Judges don't take it lightly, and the Trump administration keeps getting enjoined. But here, once Judge Howell had the opportunity to consider the full case on the merits, she issued a sweeping injunction reinstating the board members and repudiating everything DOJ did. Because remember, a TRO has a very, very high burden. It's emergency relief that's only temporary. A permanent injunction, while it takes longer to brief and to get the court up to speed, has a different standard. And Judge Howell ruled that the Trump administration's actions, quote, represented a gross usurpation of power and a way of conducting government affairs that unnecessarily traumatized the committed leadership and employees of USIP who deserve better. Now, the judge first determined that USIP was not part of the executive branch. Quote, instead, USIP supports both the executive and legislative branches as an independent think tank that carries out its own international peace research, education and training, and information services. As an independent entity exercising inconsequential government power and de minimis of any executive power, Congress's ability to restrict the president's removal power is even greater than that outlined in Humphrey's Executor versus United States. So since USIP does not exercise executive powers and is not a part of the executive branch, the president had no constitutional authority under Article 2 to remove the Institute's board members. Quote, the executive branch, per the Constitution, executes or administers the laws. Put plainly, that means interpreting a law enacted by Congress to implement the legislative mandate. Implementing the law through adjudications or rulemaking may also be considered executive branch activities. By contrast, purely investigative and information activities are not executive and rather fall into the same general category as those powers which Congress might delegate to one of its own committees. Apart from those core duties, the executive branch also wields significant power over foreign affairs, appointing ambassadors, making treaties, recognizing foreign nations, and engaging in direct diplomacy with foreign heads of state and their ministers. So, after review of the factual record, Judge Howell found that USIP wasn't engaged in foreign affairs in the Article 2 sense of the word. Quote, USIP does not execute, enforce, administer, interpret, or implement any law. It does not make binding rules of general application or determine rights and duties through adjudication. It issues no orders and performs no regulatory functions. This was underscored by Section 4604, which gives USIP authority to do 10 specific activities, quote, all of which are related to the development and dissemination of information. USIP is permitted to create grants and do outreach, but only for the purposes of supporting research, promoting the study of international peace, educating individuals, assisting the Institute in its information services programs, and assisting the Institute in the study of conflict resolution, and promoting the other purposes outlined. USIP can serve federal entities as well, but again, only in these capacities, investigating, examining, studying, and reporting on any issue within the Institute's competence. USIP has no residual statutory authority to engage generally in foreign diplomacy or foreign peacemaking expeditions. The Trump administration argued that all activities which touch on international peace and conflict resolution are within the president's purview over foreign affairs. Judge Howell disagreed, though, stating, quote, the executive branch does not control everything touching that subject area, contrary to defendant's suggestion. USIP's powers are not serving the executive branch's foreign affairs function. USIP does not wage war, conclude peace agreements, recognize foreign nations, establish foreign policy, make treaties, negotiate with foreign sovereigns for agreements binding on the United States, or transact with other states or maintain diplomatic relations on behalf of the government. Now, the Trump administration argued that by meeting with foreign officials, USIP engaged in diplomacy, which means the agency should be under his power. But Judge Howell found that when the USIP meets with foreign officials, it doesn't represent the United States government. Quote, while defendants are correct that official diplomacy is quintessentially executive, they ignore that USIP acts as a completely independent, non-governmental organization when engaging with foreign groups. In fact, the value in having USIP organize and conduct trainings and promote peaceful resolution abroad is that USIP can do so without the burdensome bureaucracy and without carrying the sometimes controversial clout of the United States government. So since USIP is not an executive branch agency, the president does not have the right to remove its members at will. However, it's obvious that Judge Howell knows the government will appeal this decision, so she's also evaluated whether the outcome would be different if USIP were considered part of the executive branch. Now, this required her to engage with the Supreme Court's decision in Saylor Law. As the Trump administration acknowledged, even after Saylor Law, for-cause removal restrictions remain constitutionally valid for entities which have, quote, multi-member bodies of experts balanced along partisan lines, with staggered terms and duties that are neither political nor executive. And USIP's structure meets all of that criteria, according to Judge Howell. The USIP board is composed of members with relevant expertise, has bipartisan representation, capped by statute, and features staggered term limits. But the Trump administration argued that to fall within the parameters of Humphrey's executor, an agency has to exercise quasi-judicial or quasi-legislative power. Since USIP has no judicial or legislative authority, Trump argues that Humphrey's executor does not apply. But Judge Howell disagreed. Quote, the exercise of quasi-judicial or quasi-legislative authority was not dispositive to those decisions. Rather, those decisions use those terms to describe how the agencies were exercising something other than the core executive authority. The fact that USIP is exercising neither purely executive nor quasi-judicial or quasi-legislative authority here, rather exercising minimal to no governmental authority at all, means the reasoning of those decisions applies a fortiori. An entity does not become more subject to presidential control because it exercises far less overall governmental power of any kind. In contrast to agencies like the FTC and the NLRB that exercise quasi-judicial and quasi-legislative authority, USIP has no decision-making authority to direct the activities of citizens citizens through rulemaking or authority to impact their rights or distribute their property. USIP, in short, is an institute of research and teaching, has far less authority, and is in far less need of executive control to promote political accountability and prevent unchecked exercise of governmental power. And finally, the court addressed President Trump's contention that he needed the authority to fire the board because they could impede his foreign policy agenda. Quote, USIP simply does not exercise any executive power that the president needs to control at all. And Judge Howell said that the Saylor Law decision supported her conclusion and recognized the distinction between single-head agencies and multi-member boards. So where did that leave the president's termination of the board? Well, the court ruled that the for-cause removal protections provided under 22 U.S.C. 4605 were constitutional and remained in effect. As such, the president's actions were ultra vires and violated statutory law. Any subsequent actions taken based on those removals, including the firing of Ambassador Moose as USIP's president and the appointments of his successors, were also invalid. The court found in favor of plaintiffs on all related counts, including those asserting that these removals and appointments were illegitimate and void under the USIP Act. When defendants entered and took control of USIP's headquarters in March of 2025, they did so without lawful authority since the removal of the legitimate board and president had no legal effect. Therefore, the plaintiffs' trespass and ejectment claims were valid. It was illegal for representatives of DOJ and the temporary organization to enter the building. Judge Howell ruled that any property transfers executed by the unlawfully appointed leadership, including the transfer of USIP's assets to the General Services Administration, were invalid. And finally, the court granted USIP both declaratory and injunctive relief. Plaintiffs were wrongly removed and suffered irreparable harm, including the loss of their statutorily protected positions and the impairment of USIP's independence and reputation. Consequently, plaintiffs were entitled to full restoration of their roles and the nullifications of all actions taken by the improperly appointed officials. The issues presented by this case are novel. Here, Congress created a hybrid entity, part government, part charity. The Supreme Court has yet to weigh in on the legal ramifications of a hybrid entity. And hello, it is Devin from the future, and we seem to have gotten our answer on that last question, and it's not good. Just in time to rain on our parade, the Supreme Court has all but overruled Humphrey's executor, which will almost certainly mean that Judge Howell's ruling will be overturned on appeal. And of course, this will be appealed to the Court of Appeals and then the Supreme Court. Now, the case at issue is Trump versus Wilcox, which is a dispute about whether the president has the constitutional authority to remove members of certain independent federal agencies without cause. It centers on President Trump's attempt to remove Gwen Wilcox, a member of the National Labor Relations Board, and Kathy Harris, a member of the Merit Systems Protection Board. Now, the NLRB and MSPB are independent agencies created by Congress. Federal law says their members should be nonpartisan, appointed to fixed terms, and protected from political firing. However, Trump fired only the Democratic members of the NLRB and MSPB, asserting that the for-cause removal protections unconstitutionally infringed on the president's Article II authority to oversee the executive branch. Now, as we talked about earlier in this video, overruling Humphrey's executor was a major part of Project 2025, and Trump has been methodically following the Heritage Foundation's blueprint, and his actions align with the unitary executive theory, which posits that the president should have comprehensive control over the executive branch. Now, Wilcox and Harris sued Trump alleging that their firings were illegal. However, the Supreme Court decided to allow the terminations to move forward on a procedural basis, which telegraphs that they are gutting 90 years of precedent in less than 2 pages, without the case being fully briefed. This litigation wasn't over the merits yet, it was simply whether there should be a stay pending appeal before the court gets to the full case itself. And the government asked for a stay of the lower court's order that reinstated the employees. The Supreme Court, however, decided procedurally on a preliminary basis that the stay should be in place, so the employees are as good as fired, and you would only do that if you were telegraphing what you were going to do on the larger merits case. And this is what we call a decision on the shadow docket. The shadow docket is a term used to describe the Supreme Court's practice of making significant rulings without full briefing, oral argument, or assigned opinion on these procedural issues. Now, the Roberts Court has decided more cases on the shadow docket than any court in U.S. history. Now, some reliance on the shadow docket is understandable and even necessary since the court needs to respond quickly in emergencies. And, you know, there have been a lot of emergencies, especially when President Trump is the president. However, when the court overrules sweeping precedent without full briefing and public argument, it undermines the court's legitimacy and the rule of law. And here, the Supreme Court granted the government's application for a stay, effectively permitting Trump to remove Wilcox and Harris without cause while the case proceeds through the appellate process. And the court's conservatives cited the Saylor Law decision for the proposition that generally the president's Article II powers means that he can remove executive officers who exercise that power on his behalf without cause, except in narrow circumstances. And the court determined that the government faces a greater risk of harm from an order allowing Wilcox and Harris to continue exercising executive power than they face from being unable to perform their statutory duties. In other words, the conservative justices picked President Trump over the fired Democrats and over the law enacted by Congress. Now, overruling Humphrey's executor has far-reaching implications because it could apply to many other regulatory bodies. Like we talked about, the Federal Elections Commission, which is a nonpartisan independent agency with a similar board structure as the NLRB and the MSPB. And his decision means that Trump could probably reshape the FEC in future elections virtually overnight. The Supreme Court did not address the FEC calamity, but it did carve out an exception for the Federal Reserve, even though this case has nothing to do with the Fed. But as we talked about, President Trump reportedly wants to fire Fed Chair Jerome Powell. So the court summarily concluded that this decision doesn't apply to the Federal Reserve because, quote, the Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the first and second banks of the United States. And it cited a Saylor Law footnote 8. What is footnote 8 to Saylor Law? It said, quote, but even assuming financial institutions like the Second Bank and the Federal Reserve can claim a special historical status, the CFPB is in an entirely different league. It acts as a mini legislature, prosecutor, and court responsible for creating substantive rules for a wide swath of industries, prosecuting violations, and levying knee-buckling penalties against private citizens. And of course, it is the only agency of its kind run by a single director. Now, that brief footnote is directed to the history and structure of the CFPB and does not prove anything about the Federal Reserve. And I honestly have no friggin' clue about what possible history of the Federal Reserve would make it an exception to this general rule that the president can fire any one of these independent agencies. But what I can be sure is that the majority of the court just absolutely conjured that out of absolute thin air. And this two-page decision did not go over well with the 3 liberal justices who all dissented. Justice Kagan said, quote, in valuing so highly in an emergency posture the president's ability to fire without cause Wilcox and Harris and everyone like them, the majority all but declares Humphreys itself the emergency. Justice Kagan excoriated the majority for its pronouncement that the Federal Reserve is exempt from the president's wrath, quote, except apparently for the Federal Reserve. The majority closes today's order by stating out of the blue that it has no bearing on the constitutionality of the 4-cause removal protections for members of the Federal Reserve Board or Open Market Committee. I'm glad to hear it and do not doubt the majority's intention to avoid imperiling the Fed, but then today's order poses a puzzle. For the Federal Reserve's independence rests on the same constitutional and analytical foundations as that of the NLRB, MSPB, FTC, FCC, and so on, which is to say it rests largely on Humphreys. So the majority has to offer a different story. The Federal Reserve, it submits, is a uniquely structured entity with a distinct historical tradition, and it cites for the proposition footnote 8 of the court's opinion in Saylor Law, but sorry, footnote 8 provides no support. Its only relevant sentence rejects an argument made on the dissenting opinion, even assuming that financial institutions like the Second Bank and Federal Reserve can claim a special historical status. And so an assumption made to humor a dissent gets turned into some kind of holding. Because one way of making new law in the emergency docket, the deprecation of Humphreys, turns out to require yet another, the creation of a bespoke Federal Reserve exception. If the idea is to reassure the markets, a simpler and more judicial approach would have been to deny the president's application. The markets will like the bespoke Federal Reserve exception, but that issue, the president's authority to meddle with the Federal Reserve Board, was not the subject of this case. Traditionally, courts only decide actual ongoing controversies. Yet here the Roberts Court acted as a super legislature. So yeah, just as traditionally the Supreme Court is very reluctant to overturn precedent, but the Roberts Court seemingly has little respect for it. And a few days ago, Justice Roberts told Georgetown law students that the rule of law is under attack. Yeah, man, we're all trying to figure out who did this. The Supreme Court smacked down the Trump administration's efforts to summarily cut off aid around the world. Hooray! The Supreme Court decided that Congress still matters. And that's great, the celebration by most commentators is warranted, but I'm sorry to tell you there are some very, very dark clouds lurking in the background. And this decision's tepid defense of the rule of law could spell disaster in the future. In a very brief 5-4 unsigned opinion, the Supreme Court upheld the lower court's order for the administration to pay out on its debts. Yes, if you're keeping score at home, that's 4 votes in favor of basically dictatorship. But at least Justice Amy Coney Barrett sided with Justice Roberts and the liberals in defense of the law, I guess, which caused all kinds of right-wing infighting, so that's nice. But it may be too early to celebrate because the Supreme Court's willingness to even consider overruling a lower court's temporary restraining order was itself a strange and ominous sign. And more troublingly, 4 members of the Supreme Court signaled that they didn't think the courts even have the authority to consider this case because this case is a violation of sovereign immunity. But what does this all mean and how did we get here? Well, a week ago, we talked about the AIDS Vaccine Advocacy Coalition versus the Department of State case, but that feels like a lifetime ago, so let's do a quick refresher to delve into the aspects of this case. On January 20th, 2025, President Trump issued an executive order titled Reevaluating and Realigning United States Foreign Aid, which directed an immediate freeze in United States foreign development assistance. This halted a broad array of foreign aid programs, many of which were life-saving campaigns aimed at alleviating hunger and providing essential medical care. OMB then issued a memorandum detailing instructions for the fulfillment of Trump's executive orders on grant programs, including the Foreign Aid Executive Order. In its memorandum, OMB ordered other agencies to pause the disbursement of all federal financial assistance, including foreign aid. Soon afterward, 2 separate courts issued orders forbidding the Trump administration from continuing this funding freeze. The administration took that court order under advisement and continued to do what it wanted to do, withholding funding on a wide variety of grants, contracts, and awards, including 800 USAID awards and contracts. The administration conducted these funding freezes with its usual level of incompetence. One of the plaintiffs in this case noted it received, quote, a flurry of stop work orders, often without any indication of what awards they were in reference to. The stop work orders contained vague and contradictory statements. Some letters indicated the award was being terminated because it no longer effectuated agency priorities. Others claim that the award termination wasn't because of any actions of the organization and was instead being ordered so that the new administration could have time to review the awards. Chaos ensued. Organizations around the world were forced to shutter their offices, lay off their staff, and turn away people the United States had pledged to help. Millions of people around the world were affected, and humanitarian operations for refugees in places like Syria were abruptly stopped. Soup kitchens in Khartoum were closed, and clinical trials for life-saving children's tuberculosis treatments in Uganda were halted. So on February 10th, a lawsuit was filed for a variety of aid organizations, including an AIDS research organization, an organization that promotes journalism about corruption-related issues, an organization that protects refugees and asylum seekers, and an organization representing small businesses in this sector. These organizations laid out a list of heart-wrenching harms in their filings and pleaded for a temporary restraining order from the court. And as we've talked about, this is an unusual and challenging ask. Now, lately we've spent a lot of time talking about temporary restraining orders, or TROs. And that is weird because TROs are an extraordinary remedy and only appropriate in cases where the imminent harm justifies immediate court action and the loosening of usual procedural requirements. So it's remarkable that so many TROs have been granted against the Trump administration, and all in less than 2 months. And in the AIDS Vaccine Advocacy Coalition case, the plaintiffs argued that a TRO was warranted, though, because the plaintiffs are likely to succeed on the merits of the case, there's irreparable harm, the balance of the equities tips in their favor, and the injunction is in the public interest. And plaintiffs managed to make their case on all counts to Judge Ali in the DC District Court. In their filings and in hearings, the plaintiffs laid out a long list of irreparable harms, including the disruption of clinical trials for HIV prevention medication, the shuttering of program offices that protect refugees and asylees, the closure of small businesses that provide aid, the disruption of maternal and child health programs, the end of medical services for adolescents and students, and a freeze on time-sensitive anti-malaria campaigns. And the administration's attorneys were, at least, willing to concede that this parade of horribles contained irreparable harms. They argued, though, that the plaintiffs were unlikely to succeed on the merits of the case. The court disagreed, finding that the plaintiffs were likely to succeed on the merits, and the court agreed that a blanket freeze on all contracts was likely a violation of the Administrative Procedure Act because it was arbitrary and capricious, stating that, quote, there has been no explanation offered in the record, let alone a satisfactory explanation, including a rational connection between the facts found and the choice made, as to why reviewing programs, many long-standing and taking place pursuant to contractual terms, required an immediate and wholesale suspension of appropriated foreign aid. The defendants, for their part, tried to claim that this wasn't actually an agency action, it was a presidential action and was thus not subject to the Administrative Procedure Act, which governs agency actions. But the court wasn't buying it, finding that the defendant's argument, quote, would allow the president and agencies to simply reframe agency action as orders or directives originating from the president to avoid APA review. And that makes perfect sense because on some level, all directives come from the president, and if that's all it takes to avoid the APA is meaningless. But Judge Ali declined to give the plaintiffs the full relief that they were asking for, choosing instead to grant a narrow order which temporarily enjoined the government from freezing funds or issuing stop work orders on programs that were already in existence as of January 19, 2025. The court, however, allowed the government to stop funding for individual contracts if it was part of enforcing the pre-existing terms of their contracts, including expirations, modifications, and terminations. And the administration took full advantage of that loophole. In the government's February 18th briefing, the defendants unabashedly stated that, quote, thus far that analysis has confirmed that at least substantially all of the terminations, suspensions, and stop work orders issued on USAID contracts, grants, and cooperative agreements were allowed by the terms of those instruments or terms implicitly incorporated into those instruments. That was not only wrong, but it would have been impossible for them to make that determination on hundreds or thousands of contracts in that time frame. So in response to the revelation the defendants were still effectively freezing nearly all funding, the plaintiffs filed a motion for contempt. The court was apparently unimpressed with the defendants' failure to comply. Judge Ali declined to find the defendants in contempt, but he did reiterate that the defendants needed to end the blanket freeze on funding. But for some reason, this was still not clear enough direction for the defendants, who asked the court to clarify its order. On February 22nd, Judge Ali replied to defendants' motion for clarification, stating that, quote, the line here is unambiguous. Defendants cannot continue to suspend programs or disbursements based on the blanket suspension that was temporarily enjoined. and defendants cannot simply come up with a new post hoc rationalization in an attempt to justify the action that was temporarily enjoined and is likely arbitrary and capricious for what it failed to consider. Judge Ali reiterated that particular contracts could be paused, but only if there was an individual evaluation of that specific contract. A blanket freeze, however, would be a violation of his order. And to underscore his point that he'd already been clear enough, Judge Ali quoted from his own prior order. And defendants, intent on continuing the blanket freeze on life-saving congressionally appropriated foreign aid funds, filed an interlocutory appeal to the D.C. Circuit Court and asked Judge Ali to stay his order in the meantime, complaining the, quote, court's order requires defendants to disperse nearly $2 billion by 11:59 p.m. tomorrow. And Judge Ali, who was apparently very good at suffering fools, denied the motion for a stay and reminded the defendants he'd already granted them a fair amount of flexibility, and it appears as though they haven't done anything to comply with his order. He was unmoved by the defendants' arguments that they hadn't had enough time to comply, pointing out that they had never actually asked for more time, and after reciting a laundry list of insufficiencies in the defendants' arguments, he denied the motion for a stay pending their appeal. But that appeal itself is also procedurally weird. Now, fun fact about TROs, they usually aren't appealable. That's because they are extraordinary and temporary relief. But the defendants tried a sleight of hand. They claimed they weren't appealing the judge's TRO itself, they were appealing his subsequent orders to enforce the TRO. Well, the Court of Appeals could not be tricked. In a very brief 2-page ruling, Judges Pillard, Pinn, and Garcia held that TROs generally aren't appealable, and neither are any later issued orders seeking to enforce an unappealable TRO. And so the defendants, still intent on withholding life-saving congressionally appropriated foreign aid, appealed their case to the Supreme Court of the United States, asking the court to vacate Judge Ali's order. Now, this was also a procedural anomaly because, again, TROs are usually not appealable. So all the Supreme Court needed to do here, and arguably should have done here, was nothing. Nothing would have been the ordinary thing to do. Instead, on February 26th, the Supreme Court took the extraordinary step of granting the defendants a stay so the Supreme Court could consider the case. Now, if you go to McDonald's and ask for a tire change, the answer should not be, we'll think about it. But that's what happened here. Then, on March 5th, the court issued a 1-paragraph decision holding that because the deadline for the original TRO had passed, and because the parties are in the midst of briefing for a preliminary injunction in the district court, the stay would be vacated. In other words, that the original TRO would be in effect. But the court also instructed Judge Ali to, quote, clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order, with due regard for the feasibility of any compliance timelines. Now, let's be clear, this was a victory for the plaintiffs. The TRO will go into effect in some respect. But the TRO had already been on the books for 3 weeks and the government had done nothing to comply. And the court had issued 4 different orders ordering enforcement of the TRO. So it's not a great sign that the Supreme Court said, issue yet another order, but be more favorable to the government this time. But worse, that very brief ruling was followed by a fiery 7-page dissent authored by Justice Alito, joined by Justices Thomas, Gorsuch, and Kavanaugh. Now, by definition, a dissent does not carry the force of law, but what's in this dissent has a lot of bad signs for the rule of law. In a memorable opening salvo, Justice Alito wrote, quote, does a single district court judge who likely lacks jurisdiction have unchecked power to compel the government of the United States to pay out and probably lose forever $2 billion taxpayer dollars? The answer to that question should be an emphatic no, but a majority of this court apparently thinks otherwise. I am stunned. I mean, technically, yes, that is one way that you can summarize a court forcing the government to comply with the Article 1 and Article 3 obligations of the Constitution. It's a summary that belongs more on Fox News than in the pages of something issued from the Supreme Court, but here we are. Alito referred to Judge Ali's order as a lawless act of judicial hubris and said that Judge Ali had wrongly brushed aside and shrugged off the government's argument that sovereign immunity barred this enforcement order. He argued that by undoing the stay, the majority of the court had abrogated its duty to ensure that the power entrusted to federal judges by the Constitution is not abused. And in what is likely to be a common theme throughout the next 4 years, Justice Alito bemoaned the nationwide injunction in this context, though he loves it when it comes to restricting anything related to abortion. And Justice Alito argued that a TRO wasn't the right mechanism for all this, where vast sums of money would, as he put it, probably be lost forever. Weird way to say that the government is spending money on something it chose to spend its money on. But instead, the DC District Court ought to have taken the steps to order a preliminary injunction, which is an appealable order. The Court of Appeals should have vacated the District Court's, quote, erroneous order. Justice Alito also disagreed strongly with Judge Ali about which party was likely to prevail on the merits of this case. Alito wrote that the government would likely succeed in its argument that sovereign immunity deprives the district court of having jurisdiction over this matter at all, because sovereign immunity generally bars monetary suits against the government. Now, because the majority's response was so brief, they didn't delve into any of this, but there's good reason to believe that Justice Alito was mistaken on this point. Alito is correct that generally sovereign immunity bars lawsuits against the government. In particular, there's case law that bars monetary suits, but the government can waive that immunity, and it has done so in the Administrative Procedure Act, which expressly allows plaintiffs to sue the government for monetary relief. Alito argues that even the APA's waiver doesn't apply here because the relief Judge Ali granted would result in the government paying out billions of dollars. But Alito is confusing the plaintiff's request that the court order the government to honor its contracts with a demand for monetary damages. The plaintiffs in this case are not asking for monetary damages, and Judge Ali did not grant them in the traditional sense. Instead, he said the money at issue would be paid out as the natural result of the ordered action, the unfreezing of the contracts. That's an important distinction and would fit under the APA's waiver, allowing plaintiffs to file suit and seek unfreezing of the contracts. It's also important to note, as Judge Ali did after the case had been appealed, that defendants didn't really argue the sovereign immunity angle in their earlier filings. Alito is arguing it for them, but it was never really briefed on the district court level. Still, Judge Ali pointed out that he didn't think that this would be a strong argument or change his opinion about the plaintiff's likelihood to succeed on the merits. Alito also argued the district court's remedy was too broad because it had ordered the government to honor all of its contracts, not just the contracts it had with the plaintiffs. Now, it's impossible to know what the majority would think about this because it wasn't included in their one-paragraph opinion, but plaintiffs point out in their own briefings that what they were asking wasn't overbroad. What they demanded was merely the restoration of the status quo in which the United States government honored its contractual obligations. And this is the real crux of the case. If the government wanted to conduct an audit of all of its contracts, there's a way to do that. They could have reviewed each contract and then ended the ones that showed signs of fraud or abuse. That's what would have happened in a normal world. Instead, they put a blanket freeze on all contracts, ostensibly so they could conduct a review, but that's a review that they didn't or weren't conducting. And that's an extraordinary action that justifies Judge Ali's grant of extraordinary relief. But Justice Alito concluded his dissent with a parting shot at the, quote, self-aggrandizement of the district court and Judge Ali's hubris in ordering the Trump administration to pay out on government contracts. Justice Alito sees a constitutional crisis in the situation, and plaintiffs also see a constitutional crisis, but they're clearly seeing different crises. Now, where plaintiffs believe this is a question of separation of powers between Congress and the president, Justice Alito instead believes that this is a question of separation of powers between a lowly district court judge and the president. Now, we've discussed this before. The president doesn't have the authority to direct the disbursement of taxpayer funds. Article 1 of the Constitution, only Congress has that authority. And Congress has already designated these funds for foreign aid. For the president to step in and overrule Congress's spending choices, that's an extraordinary overstep and a violation of basic separation of powers. Now, we pointed out that the separation of powers issues will put this country into a constitutional crisis, but we might need to make that constitutional crises plural because there are multiple constitutional issues here. First, as we've mentioned before, will the president obey the order to unfreeze the funds? And second, if this case does return to the Supreme Court, will that court recognize that only Congress has the power to pass laws and appropriate funds? Or will the court instead allow the president to unilaterally overrule Congress's spending decisions? And the Trump administration's track record in this case, repeatedly ignoring Judge Ali's orders, should raise some major red flags. And the Supreme Court's choice to issue a ruling at all in this matter should probably raise some yellow ones, because as noted earlier, TROs are usually unappealable. Now, it could have been worse, of course, if the court had outright said that TROs are now appealable for the Trump administration, or if a fifth justice had agreed with Justice Alito's blistering analysis. It could have been worse might be the best that we can hope for in the current moment. But I'd argue this decision is not a cause for celebration, because there were 4 justices in the dissent who said outright that they didn't think that any court has jurisdiction over the case because the government has sovereign immunity, even when the government fails to pay out on billions of dollars of contracts. That signals that those 4 justices are likely to allow the Trump administration to get away with even more legally dubious actions, because those justices believe strongly in executive power, perhaps absolute executive power, and think that the job of the court isn't to restrain an out-of-control monarchical president. It's hard to overstate how important this is. If the court says that sovereign immunity prevents anyone from suing over the executive's refusal to honor congressionally appropriated funds, then Congress can pass whatever laws it wants to, but the executive can just refuse to enforce those laws. And it only takes 4 justices to grant certiorari on a case, to allow a case to be heard in the Supreme Court, which Justice Alito clearly invited the defendants to ask for here when he stated that the majority should, quote, at least stay the district court's enforcement order until the government is able to petition for a writ of certiorari. But for now, the case has returned to Judge Ali in the DC District Court. On March 6, Judge Ali held a status conference for the parties. The parties each reiterated their arguments, and the plaintiffs pointed out the extent and cost of the defendants' noncompliance with the court's order, including the government's apparent invention of new bureaucratic hurdles to obtain the promised funds. Plaintiffs argue that defendants' own declarations make it clear the administration has added new layers of bureaucracy to prevent the review process, requiring political appointees to sign off on each individual payment and confirm that the payment isn't only valid, but is also in line with the president's policy priorities. Plaintiffs also argue that despite the court's order to halt stop work orders, the defendants have continued to terminate contracts en masse. Some contracts have been reinstated, but the process and guidelines for reinstatement are predictably chaotic and disorganized. Plaintiffs laid out a proposed schedule for the government to pay out on its contractual obligations. Defendants claim that they are actually already in compliance with court orders. They argued that they had continued to individually assess contracts and that no contracts are in a paused state because they have all either been retained or terminated. Defendants assured the court that they had reviewed the plaintiffs' contracts and are in the process of making payments to plaintiffs, and they argued that therefore, the plaintiffs' challenge to the executive order's pause on payments is now moot. But the plaintiffs disputed the assertion that the payments owed to them have been satisfied, and the court has yet to rule on these warring factual accounts. But it's very likely that if the court rules that the government's actions still haven't fulfilled their obligations, there will be a speedy appeal by the Trump administration, which will eventually end up back at the Supreme Court where, best case scenario for the plaintiffs and possibly democracy, a razor-thin majority will uphold the requirement that the United States make good on paying its debts. And at the scheduled hearing, Judge Ali apparently ordered the government to pay up by Monday at 6 p.m., which might be the day that you're watching this. So I also look forward to finding out what the government does just as much as you do.
Who gets to decide who prosecutes federal crimes in New Jersey? The courts or the president or the mob? That's the central question in a high-stakes legal battle over Alina Habba, Donald Trump's former personal lawyer turned acting U.S. attorney. After a federal judge panel rejected her reappointment and appointed a career prosecutor in her place, the Trump administration quickly fired the court's pick and reinstated Habba through a different legal mechanism. This procedural shell game now threatens to derail key criminal prosecutions and challenge boundaries of executive power. So, just another day in Trump's second term. This dispute involves major questions, like a federal court's authority to appoint a U.S. attorney, whether the attorney general is permitted to fire a court-appointed U.S. attorney, and of course, whether Habba still has her job. So today, I'll dive into the murky legal waters presented by the Habba mess. Okay, let's set the scene for this unusual legal dispute. On March 24th, 2025, President Trump posted on Truth Social that he was appointing Alina Habba as interim U.S. attorney for the District of New Jersey. Her 120-day tenure was set to expire in late July unless she was confirmed by the Senate. The Habba pick was controversial, in part because Habba has no prosecutorial experience, and in part because her work as a member of Trump's civil defense team was, shall we say, just a bit outside the norm.
Vaughn into the windup in his first offering. Just a bit outside.
When Habba met Trump, she was in the minor leagues, leading a small firm in suburban New Jersey. She previously served as general counsel to a parking garage company that was owned by her husband. Habba proved herself to Trump by inserting herself into the sexual harassment case of 20-year-old server Alice Bianco, who worked at Trump's Bedminster Golf Club. Bianco alleged that her manager sexually harassed her and that after she rebuffed his advances, he retaliated against her. When other employees described this toxic workplace to HR, Habba entered the picture, communicating directly with Bianco despite knowing she had legal counsel. That's a big no-no. Habba pressured Bianco to fire her lawyer, sent texts undermining his credibility, and ultimately advised her to ignore him altogether. Soon after, Bianco signed a non-disclosure agreement prepared by Habba, which contained illegal confidentiality clauses and harsh financial penalties for speaking out, despite New Jersey law making such provisions unenforceable in harassment cases. This conduct arguably violated many ethical rules, like communicating with a person she knew was represented by counsel while actually representing the interests of an adverse party. It's also pretty bad to draft an NDA that's illegal under New Jersey law. But as we all know too well, what sounds bad to legal ethics committees is music to Donald Trump's ears. And so Habba entered the big leagues as a fixture of his civil defense team. As Liz Dye explained, Habba's major accomplishments for Team Trump consisted in getting fined nearly $1 million for filing a frivolous lawsuit against Hillary Clinton and getting reprimanded at least 14 times in a single day during the E. Jean Carroll defamation trial. While all that may not look good on a conventional resume, Trump values loyalty and ethical flexibility above all else. After Trump's election, Habba served as counselor to the president. On March 24th, 2025, Trump announced that he was appointing Habba to be the interim U.S. attorney for New Jersey, effective immediately. New Jersey's 2 Democratic senators were not pleased. On July 1st, Trump formally nominated Habba to serve as U.S. attorney for New Jersey, but the Senate never considered her nomination. Meanwhile, Habba's 120-day interim term was set to expire on July 22nd. On July 22nd, a panel of U.S. District Court judges invoked their power under federal law and declined to extend Habba's interim term. They voted to replace Haba with Desiree Grace, a longtime federal prosecutor whom Haba chose to be her first assistant. 2 days later, on July 24th, President Trump withdrew Haba's nomination from the Senate. This was a strategic move that allowed Attorney General Pam Bondi to fire Grace and reappoint Haba as the first assistant, which, like a legal Pez dispenser, automatically caused Haba to move up to be the acting, not interim, acting U.S. Attorney for up to another 210 days, despite lacking Senate confirmation. So was any of this legal? To find out, we need to look at 3 sources of law: the Appointments Clause of the U.S. Constitution, the Federal Vacancies Reform Act of 1998, which we're going to call the Vacancies Act, and 28 U.S.C. Section 546, which we're just going to call Section 546. Let's start with the constitutional text, since it sets the stage for everything. One key legal question is whether a U.S. attorney is considered a principal officer or an inferior officer. And why does that matter? Because under the Constitution, principal officers like cabinet secretaries must be nominated by the president and confirmed by the Senate. Inferior officers, who are lower ranking, can often be appointed by courts or department heads without Senate confirmation. If a U.S. attorney is a principal officer, then only the president can appoint or remove them. But if they're an inferior officer, courts may have the authority to appoint someone temporarily, which is what happened in this case. So the distinction shapes really who has the power to decide who prosecutes federal crimes. I know we're all hoping that the question has an easy answer, but then we wouldn't have a channel. Well, let's look at the text of the Appointments Clause. Article 2, Section 2, Clause 2 includes the following: He, meaning the president, shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, other public ministers and consuls, judges of the Supreme Court, and all other officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers, as they think proper, in the president alone, in the courts of law, or in the heads of departments. So, who are officers? Well, notice the text specifies 2 different types: officers and inferior officers. The first type, usually called principal officers to avoid confusion, has referred to high-level executive officials like cabinet secretaries, the Secretary of State and the Secretary of Treasury, or heads of independent agencies like the Federal Election Commission or chairs of the Security and Exchange Commission. Basically, people exercising significant authority pursuant to the laws of the United States, as the Supreme Court said in Buckley v. Vallejo in 1973. Importantly, as the clause says, while the president always has to be the one to appoint principal officers, if Congress chooses to do so, they can vest the power of appointing inferior officers in lower-level officials. Inferior officers aren't defined or delineated from principal officers by any specific criteria in the constitutional text. As the Supreme Court said in Morrison v. Olson in 1988, the line between inferior and principal officers is one that is far from clear, and the framers provided little guidance into where it should be drawn. The Morrison Court helpfully provided some clues of inferior status. The officer can be removed without cause by a higher-level executive official, can only perform certain limited duties, or has a limited or time-bound tenure. In Edmund v. United States in 1997, the Supreme Court said that, generally speaking, inferior officers are officers whose work is directed and supervised at some level by others who were appointed by presidential nomination with the Senate's advice and consent. Unhelpfully, whether U.S. attorneys are principal or inferior officers is not 100% clear. On the one hand, they're nominated by the president and appointed subject to Senate confirmation and possess significant independent discretionary authority. On the other hand, they're subject to oversight by the Attorney General, and their authority is geographically constrained to their district. So the prevailing view is that they're probably inferior officers, but it's a slightly open question. So let's look at our cast of characters so far. Donald Trump is the President of the United States. Again. Alina Habba we'll get there, his nominee for U.S. Attorney for the District of New Jersey. Here's 2 senators, Cory Booker and Andy Kim, who want Trump to pick someone else, and so aren't exactly rushing to vote to confirm because they're concerned she's an unqualified hack. My words. Who does not meet the standard to be a U.S. attorney, and who, in her short tenure as an interim U.S. attorney, has degraded the office and pursued frivolous and politically motivated prosecutions. Booker and Kim's words. To zoom out just a little bit further, note that it's standard practice for U.S. attorneys appointed by one president to resign their posts if the president from a different party is elected. That's what happened after Joe Biden's loss last November. His appointee for the U.S. Attorney for New Jersey, Philip Selinger, submitted his resignation on December 8, 2024. This left the office vacant. And that's where the second piece of law comes from. 28 U.S.C. Section 546, which deals with vacancies specifically in U.S. attorneys' offices and nowhere else. Section 546 empowers the Attorney General to appoint an interim U.S. attorney when the office is vacant. The Attorney General is not allowed to appoint a person who was previously nominated to that office but rejected by the Senate. An interim U.S. attorney can only serve for 120 days or until the Senate confirms a nominee, whichever is earlier. Most importantly, if the 120-day clock expires, the district court for such district may appoint a U.S. attorney to serve until the vacancy is filled. Section 546 adds 2 more characters to our cast, the Attorney General and the district court. Here's Pam Bondi, Trump's Attorney General, definitely a principal officer who is confirmed by the Senate. And here are the judges for the United States District Court for the District of New Jersey. Not really. I couldn't find a picture of all 17 of them together. Congress specified in Section 546 that it's okay for someone other than the president to appoint an interim U.S. attorney, which means, at the very least, that interim U.S. attorneys are definitely inferior officers, and also that they can be removed at will by the figure who appointed them. Trump publicly announced Haba's appointment on Truth Social on March 24th. It is with great pleasure that I am announcing Alina Haba, Esquire, who is currently serving as counselor to the president and has represented me for a long time, will be our interim U.S. attorney for the District of New Jersey, her home state, effective immediately. Trump announced it before Bondi did the paperwork, which raises questions about which date starts the 120-day legal clock. Under Section 546, it would seem that Trump can't appoint an interim U.S. attorney, since in the law itself, Congress vested that power in the Attorney General. Normally, we might say that, functionally, this doesn't really matter. Hypothetically, Bondi could have just said, yeah, Trump announced it on the 24th and said it was effective immediately, but it was my call to do it. Haba was my choice. But we're dealing with a ticking clock here, remember, 120 days. And it turns out that whether it was effective immediately after Trump's announcement on the 24th or the day after Bondi's appointment on the 27th is pretty significant. If Haba's interim appointment was actually effective immediately like Trump said, then this appointment should have expired on July 22nd. But if Bondi's order, which specified Haba's appointment would begin the following day on March 28th, was the true effective date, then the interim appointment expiration would be July 25th. This matters. In either case, soon after her interim appointment, Haba handpicked a first assistant to serve as her deputy, Desiree Grace, a career civil servant who had been serving the U.S. Attorney's Office for New Jersey since 2016. On July 22nd, Haba's 120-day term apparently expired. And so under Section 546, the judges in New Jersey's federal district court exercise their prerogative to appoint a United States attorney to serve until a vacancy is filled. This wasn't really a surprise. According to the New York Times, in a staff meeting a little over a week prior, Haba acknowledged that she was unlikely to be appointed by the judges and offered an emotional, preemptive farewell. And she was right. In an order signed by Chief Judge Renee Bum, the court declined to extend her interim appointment and instead appointed First Assistant Grace, effective July 22, 2025, or upon the expiration of 120 days after appointment by the Attorney General, whichever is later. Then all hell broke loose. Later that day, Deputy Attorney General Todd Blanche tweeted, "The district judges in New Jersey just proved this was never about the law. It was about politics. They forced out President Trump's pick, then installed her deputy, colluding with New Jersey senators along the way. It won't work. Pursuant to the president's authority, we have removed that deputy effective immediately. This backroom vote will not override the authority of the chief executive." Bondi also chimed in. "This Department of Justice does not tolerate rogue judges, especially when they threaten the president's core Article 2 powers." But that's wrong for at least 2 reasons. First, the New Jersey District Court judges didn't go rogue. Section 546 clearly and specifically allows for district court appointments when an interim U.S. attorney's 120-day term expires. That provision exists for a reason. It's meant to pressure the executive to nominate someone and get them confirmed. If the president fails to do that in time, control temporarily shifts to the judiciary. Second, even if Grace was removed as first assistant, the court could still appoint her since she's qualified and the law allows the court to appoint anyone. If Bondi was attempting to remove Grace as interim appointee by herself, she can't. She has no authority to do that. Generally, the power to remove follows the power to appoint, and Bondi didn't have the appointment power, which was used to appoint Grace. In a new court filing, the Trump administration refuses to concede that Grace's appointment was ever valid, so the closest thing to a firing is 2 government officials notifying Grace on July 26th that Trump would remove her if somehow her appointment were effective. In addition, many such appointments have been made over the years. A similar situation came up in 2020 when the Trump administration forced out Jeffrey Berman, a court-appointed U.S. attorney in New York. The removal was legally murky, and Berman initially resisted, but he ultimately stepped down after Barr claimed the president had authorized it. That case wasn't litigated, but it's now being used as precedent to argue that Trump can remove Grace as well, which would allow Haba to resume the job under the Vacancies Act. That's a plausible reading of executive power, one echoed in Office of Legal Counsel opinions. A 1979 OLC memo indicates that the president probably would have the power to remove Grace despite the district court's appointment if he wanted to, but Bondi would not be able to on her own. But Berman's removal was never tested in court. Okay, I regret to inform you that things are about to get even more complicated. So, the Trump administration's story is that Grace was fired as first assistant on July 22nd and that Haba's 120-day term was set to expire on July 25th. That on July 24th, Haba sent a letter informing Bondi that she was resigning her position as interim U.S. attorney effective at 5:00 p.m. today, and that later that same day, Bondi issued an order appointing Haba as a special attorney to the U.S. Attorney General and designating her as first assistant to the District of New Jersey, the same position that Grace had been serving in days earlier. As first assistant U.S. attorney, this order says Ms. Haba will have the authority to serve as acting United States attorney upon a vacancy in that office subject to the conditions and time limitations of the Federal Vacancies and Reform Act of 1998. This is our third and final piece of law, the Vacancies Act, starting at 5 U.S.C. Section 3345, which concerns acting officers. The Vacancies Act is much broader than Section 546. Section 546 is specific to U.S. attorneys' offices, but the Vacancies Act covers the entire government, including U.S. attorneys' offices. As a practical matter, an acting officer under the Vacancies Act has the same authority as an interim appointee under Section 546, but is subject to different time limitations, 210 days instead of 120. One other difference. While Section 546 empowers the Attorney General, and sometimes the court, to appoint an interim U.S. attorney at any given time, Section 3345 of the Vacancies Act automatically makes the first assistant the acting U.S. attorney as soon as there is a vacancy. Because, of course, someone has to be in charge at every moment. There can't be a gap in authority. This explains the elaborate song and dance of firing Grace, having Haba resign from interim status, rehiring Haba as special attorney, and then instantly promoting her to first assistant. Under the Vacancies Act, the first assistant automatically assumes acting status when there's a vacancy. Recall that the district court's order appointing Grace under Section 546 made the appointment effective July 22nd or 120 days after appointment, whichever is later. The administration's theory then is this. Bondi's order naming Haba the interim appointee on March 27th was the real one, meaning the 120-day mark wasn't until July 25th. By finishing the whole song and dance before the end of the day on July 24th, they beat the district court to the punch by a few hours. That's their story, and they're sticking to it. But the Vacancies Act has more. A person is barred from serving as an acting officer when two conditions are met. First, if in the year preceding the vacancy, the person either did not serve as first assistant or served as first assistant for less than 90 days. Second, if the president submits a nomination of such person to the Senate for appointment to such office. Well, wait a second. We know that Haba had been nominated to the Senate on July 1st, and the vacancy occurred when the Biden-appointed U.S. Attorney Philip Selinger resigned. Since Haba hadn't served as first assistant prior to the vacancy occurring, that subsection seems to disqualify Haba right there. If Trump hadn't also withdrawn her nomination pending Senate confirmation on the same day. But a spokesman for the Justice Department said Thursday that the White House had withdrawn her nomination, allowing her to serve as acting U.S. attorney. It seems like the administration has given up trying to have Haba be the real deal nominee at this point, and instead is going to see how long they can just keep her around as a temporary time-limited official. But there's another wrinkle. It's arguable that under the Vacancies Act, if the president nominates someone for a role once, that person becomes forever ineligible to serve in that role in an acting capacity. The Vacancies Act makes someone ineligible to serve in an acting capacity if the person submits a nomination of such person to the Senate and the other condition applies. And Trump did exactly that on July 1st. The law does not say anything about withdrawal of nomination, just submitting it. Defense lawyers in New Jersey are using that exact argument, saying Haba is barred from acting as U.S. Attorney for New Jersey, period. The leadership limbo is having tangible consequences for New Jersey's federal court docket. You see, Section 3348 of the Vacancies Act voids all actions taken by improperly serving acting officials. Every charging instrument in every criminal case is signed under her purported authority. If her appointment is found to be a Vacancies Act violation, all of those charging instruments go poof. All of the trials, guilty pleas, motions, responses shall have no force or effect. Already, a triple homicide trial and dozens of other cases have been delayed, with defense attorneys estimated that more than 1,500 active federal cases could ultimately be affected. The Justice Department insists that Haba's appointment is lawful, and that even if overturned later, prosecutions conducted under her tenure remain valid under the de facto officer doctrine. Many documents issued by her office now include a so-called de facto officer disclaimer, just in case Haba's appointment is later deemed invalid. Which, no. The de facto officer doctrine is a common law doctrine that allows courts to validate the past actions of an improperly serving official. Common law courts have applied this doctrine for nearly 6 centuries. Think of it like this. You have someone who has been serving in an office, getting a lot of work done, everyone thinks they belong there and is relying on their actions, and blam, some legal technicality says they were never properly appointed. The de facto officer doctrine is a common sense solution born out of a desire and need to protect the interests of the public and ensure the stability of government functions over time. There's no definitive test for application of the de facto officer doctrine. It's a common law doctrine responsive to equities. But at its most fundamental, the de facto officer doctrine will only validate the past actions of an improperly serving official who was widely believed to be properly serving and doing so in good faith. Once it's known that an officer is improperly serving, or once questions are widely raised about the propriety of that officer's appointment, the de facto officer doctrine is no longer available. And I think we're there. I mean, we made this video. New York defense attorneys are sharpening their knives and filing their motions. As the New York Times reports, U.S. District Judge Edward S. Keel recently said in a hearing related to a motion arguing that Haba was appointed unlawfully, "At this point, as I said, you'll see, generally, that a lot of judges will not be hearing any criminal cases that are of a non-urgent matter. Because, for example, if we take a plea today and that motion is granted, I don't think that the plea colloquy today and what the United States Attorney does here in this case would be effective, and we would have to redo all those things." Judge Keel then transferred the motion to Chief Judge Matthew Brann in Pennsylvania, and the Third Circuit Court of Appeals has placed the question of Haba's acting appointment on an accelerated docket, promising a binding, precedential ruling within months. Whatever the outcome, this dispute is poised to clarify just how far a president can go to hold on to favored prosecutors and loyalists.
Another video on Kilmar Abrego Garcia? In this economy? Look, I am as surprised as you are. We've done a lot of videos about this one apparently normal guy, and we will happily stop and go back to cracking wise about Mr. Beast or Justin Baldoni and Blake Lively or Jake Paul just as soon as the government stops doing crazy shit to this dude. From snatching him off the street back in March to threatening to deport him to a bunch of random African countries to lying to federal judges. This case just keeps getting wilder. So what is it about this guy that makes the Trump administration so mad? And what the hell is a Scrivener? And who the hell is this rando nunc pro tunc anyway? By now, we all know the story of Kilmar Abrego Garcia. He crossed into the U.S. in 2011 when he was 16 and lived a quiet life with his brother in Maryland until 2019. Then he was picked up by local cops in the parking lot of Home Depot for loitering and handed over to immigration officials. Immigration Judge David Jones believed Abrego's testimony that he feared being killed by gangs trying to extort his family's pupusa business in El Salvador if he was sent back to his native country. But asylum claims have to be made within 1 year of arrival, so instead of deporting him, the judge issued an order withholding removal to El Salvador. Abrego was then released under what's called the non-detained docket. In a 2001 case called Zodvitas v. Davis, the Supreme Court ruled that the government cannot indefinitely detain a non-citizen when there's no plan to deport him imminently. They said it violates the Due Process Clause of the Fifth Amendment to keep someone in jail just because there's no country willing or able to take him. The default is 90 days, after which the government has to let people go as long as they agree to keep ICE informed of their whereabouts and check in regularly. And while there is a legal framework to deport non-citizens to third countries, we mostly didn't do it because it seemed kind of cruel and pointless to dump people in a country they have no connection to. But then Trump got elected on a promise to throw millions of people out of the U.S., and the non-detained docket full of non-citizens who'd been released into the community was functionally a list of targets for Homeland Security to snatch off the street. And that's exactly what happened to Abrego. For years, he'd been living with his wife and raising his kids and working as a union sheet metal laborer. But on March 12th, federal agents pulled him over with his little boy in the car, told him that his status had changed, and threatened to put the child in foster care if Abrego's wife didn't show up and take him in 10 minutes. Within 3 days, Abrego was on a plane headed for El Salvador, despite Judge Jones's order saying that could not happen. He was imprisoned in Sikat, a notorious gulag where he and hundreds of men deported along with him were beaten and tortured for months. Abrego's wife, Jennifer Vasquez Sura, filed a habeas corpus petition, which is an ancient legal writ effectively asking the court to order the government to release someone held in custody. It literally means produce the body. The case landed on the docket of Maryland federal judge Paula Exinas, who spent months trying to get the government to bring this guy back. First, lawyers for the Justice Department admitted that Abrego had been deported in air, but almost immediately they pivoted to claiming that Abrego was a dangerous criminal who was exactly where he should be and who would never walk the streets of the United States again.
Kilmar Abrego Garcia is an illegal alien, MS-13 gang member, and foreign terrorist who was deported back to his home country.
For months, the DOJ told Judge Axinas that it was impossible for the U.S. government to get Abrego back, and they stuck to that line right up until June 6, when he miraculously showed up at the border and was arrested on charges of human trafficking in Tennessee. At that point, the government moved to dismiss the habeas case on the ground that they had, at long last, produced Abrego, and that would have been extremely convenient, since it would have put an end to that contempt inquiry Judge Axinas was conducting into all the apparently untrue things the government told her about how Abrego wound up on that plane and how it was simply impossible to bring him back. Judge Axinas said, hell no, and that inquiry is ongoing. And right about here, you may want to Google the Chekhov's gun principle. Down in Tennessee, where Abrego was criminally charged, prosecutors appear to have tried to use the threat of deportation to extort Abrego into pleading guilty in that case. After the court released him on bail, prosecutors offered him a deal. If he would immediately plead guilty, they would deport him to Costa Rica. They produced a letter from Costa Rica's public security minister, Mario Zamora Cordero, attesting that the country would accept him as a refugee and not send him back to El Salvador. If he refused to plead guilty, though, the offer of deportation to Costa Rica would be off the table forever. Now, I would be remiss if I did not point out that, if true, that is a gross abuse of both the legal and immigration processes. Deportation is not supposed to be punitive, and it's certainly not supposed to be used to extort a defendant to plead guilty in court. So instead of taking this dirty deal, Abrego filed a second habeas case in Maryland with Judge Axinas, who entered an order barring the government from deporting him from the continental United States. When he left the jail in Tennessee, Abrego turned himself in to the immigration facility in Baltimore and was immediately taken into ICE custody. Having arbitrarily refused to send him to Costa Rica, where he was and is still willing to go, the government sent him a series of letters threatening to deport him to a list of seemingly random African countries. On August 22nd, ICE sent him a letter saying that they were about to remove him to Uganda. Abrego responded the next day by saying that he feared being persecuted in Uganda and requested to be sent to Costa Rica. On September 5th, ICE informed Abrego that it was sending him to Eswatini. A week later, the government of that country said that it had not received any communication regarding Abrego. Now remember, they can't hold you in custody if they have no realistic possibility of deporting you. And so Judge Axinas kept asking DHS and DOJ what they were actually doing to deport Abrego. Next, DHS said it was going to send him to Ghana, except as soon as that story broke, Ghana's foreign minister said on X, Ghana is not accepting Abrego Garcia. He cannot be deported to Ghana. This has been directly and unambiguously conveyed to U.S. authorities. Oopsie! Then, on October 24th, ICE said it was deporting Abrego to Liberia. They finally found a country in Africa willing to take him. But there's a little problem, because under 8 U.S. Code Section 1231, a deportee gets to designate the country he wants to be removed to. And for months, Abrego has been shouting, I designate Costa Rica. So the government had to explain to Judge Axinas why they weren't going to send him to Costa Rica like he asked, and that explanation was not convincing. First, the government filed a declaration by John Cantu, an acting assistant director for ICE's enforcement and removal operations. He said that Costa Rica's offer to repatriate Abrego came with undisclosed strings attached, that the Department of State assesses that the government of Costa Rica would not accept the transfer of Mr. Abrego Garcia to Costa Rica at this time without further negotiations, and that the Republic of Liberia is at present the only state willing to accept Mr. Abrego Garcia without further negotiations and additional commitments from the United States. But they submitted that declaration under seal so no one in, say, the Costa Rican Public Security Ministry would find out about it. Smelling a rat, Judge Axinas ordered Cantu to show up in court and testify, and unsurprisingly, Cantu was a terrible witness because even though he put his name on that declaration saying that he knew for a fact that Costa Rica wasn't willing to accept Abrego, under oath he admitted that he had no idea whether the State Department had even spoken to Costa Rica at all. Asked what he meant when he referred in his declaration to certain understandings, he said, I don't know. What did he mean by contingencies? I do not know. Interim developments? I don't know. Cantu admitted that he'd had a 5-minute Zoom call with a lawyer from the State Department who told him what to say, and then he put those words in the declaration and signed his name to it. Cantu had no idea if Costa Rica had actually backed out of the original deal, and as it turns out, it hadn't. Costa Rican Security Minister Zamora Cordero told multiple news outlets that there had been no communication with the U.S. State Department and no change to the offer to accept Abrego Garcia. But there was yet another problem with DH's plan to deport Abrego, and that problem goes back to 2019. So you remember when I told you that in 2019, Immigration Judge David Jones issued that order withholding removal, saying that Abrego couldn't be deported to El Salvador? The government has been treating that as a final order of removal, but it actually isn't. At the risk of sounding glib, a final order of removal says, get out, and an order withholding removal says, but not to your native country. And here, no one is quite sure whether the get out part ever happened. If there was a final order of removal in the file 6 years ago, it isn't there now. And without a final order of removal, DHS cannot deport Abrego, which is one of the many reasons Judge Ixinis finally granted the habeas petition. On December 11th, the judge ordered the Department of Homeland Security to release Abrego from custody because you can't deport someone without a final order of removal. The DOJ tried to argue that the final order is implied by the existence of a withholding order, but the Fourth Circuit and the Supreme Court have said otherwise, and even if he could be removed, DHS would still have a Zadvitas problem because clearly the government has no actual plan to deport him. As the court said, if DHS had wished to remove him, they certainly could have as early as August 21, 2025 to Costa Rica. Instead, they serially notified Abrego while he sat in ICE custody of his expulsion to Uganda, then Eswatini, then Ghana, despite the fact that none of these countries were ever viable options, and at least 2 had not even been asked to take him. And all the while, they took no steps to remove Abrego Garcia to the country which had offered to take him, Costa Rica. Obviously, the point of this exercise wasn't to deport him, since he's willing to leave for Costa Rica today. The point is to send him someplace maximally unpleasant where he doesn't want to go. Keep that in mind when you see stuff like this.
When he becomes deportable, he is going to get deported, and he needs to be deported now.
That's Greg Bavino, who calls himself the Commander-at-Large of Customs and Border Patrol. He's a character. But the fact of the matter is that DHS could have deported Abrego any time during the past 4 months. It chose not to because Costa Rica's not cruel enough. And so Judge Ixinis ordered ICE to let him go home to his wife and kids, which should have been the end of the matter. Let the man spend Christmas with his family, but it wasn't. On December 11th, the very same day that Judge Ixinis granted Abrego's habeas petition, he got 2 pieces of mail from the immigration court in Baltimore. The first was an order signed by an immigration judge named Philip Taylor. It noted a, quote, scrivener's error in the 2019 order withholding removal. A scrivener's error is like a typo or a clerical error. It goes back to a time when legal documents were written out by hand. You can usually go back and fix an obvious goof in a legal document. It's not a big deal, but that's not what happened here. Instead, Judge Taylor purported to correct a scrivener's error in Judge Jones's 2019 immigration ruling by inserting a final order of removal in the original document, and he purported to backdate that language 6 years. See where it says, these corrections are hereby issued nunc pro tunc? Nunc pro tunc is Latin. It literally means now for then. It's a way of treating something as if it took legal effect earlier, and it happens all the time, but not like this. The immigration judge is just using, or some might say abusing, these legal doctrines to magic up an order of removal where none existed. The second piece of mail was an order from ICE instructing Abrego to report at 8 a.m. to the Baltimore office, where he'd presumably be taken back into custody now that the scrivener's error had been corrected, nunc pro tunc. Once again, Abrego's lawyers raced back to Judge Ixinis with a motion for a temporary restraining order, and once again, the judge issued emergency relief just a few hours later, telling DHS not to deport this guy. She consistently referred to Judge Taylor's order in sarcasm quotes, and she pointed out that backdating the removal order nunc pro tunc wouldn't help DHS because they would still have a Zadvitas problem, only worse. Remember, under Zadvitas, the government gets 90 days after the removal order to hold a non-citizen and figure out where to deport him. Hot tub time machining the removal language back to 2019 only means that the 90 days expired almost 6 years ago. And so, for the time being, Abrego's with his family. He checked in at the ICE facility in Baltimore and walked out a free man. An ordinary guy fought the system and won, at least for a little while.
Estoy aquí como un hombre libre y siempre recuérdenme así, con la cabeza en alto.
I stand before you as a free man, and I want you to remember me this way, with my head held up high.
Like the man said, keep your head up, and don't ever let anyone tell you the law doesn't matter.
Newsflash, the super illegal tariffs are still super illegal. An appeals court has canceled Trump's tariffs because the president doesn't actually have the legal authority to tariff everything on the planet. But get out your bindles, because according to Trump, we're headed for the second Great Depression. And according to the Trump administration's own legal filings, Trump has essentially bet the country's entire economy on the unproven legal theory that he has the authority to unilaterally impose sweeping worldwide tariffs. And now, if the Supreme Court doesn't rule in Trump's favor, or doesn't take up the case, and allow those tariffs to continue, Trump claims that we're facing total economic collapse, the likes of which we haven't seen since 1929. Which, I'll remind you, got much worse because of tariffs. And so Trump's lawyers filed a petition for cert, demanding that the Supreme Court review the Circuit Court's decision. And on September 9th, the court accepted the case. During Trump's first term, he adjusted several tariffs, but to do this, he followed putative authority under the Trade Act of 1974. And this was after a months-long investigation into the ways that Chinese companies were supposedly harming U.S. economic interests by doing things like stealing intellectual property. And a qualified agency made an official finding that these harmful practices were in fact occurring. And then in 2018, the first Trump administration placed targeted tariffs on a specific list of Chinese products. But that was then, and this is now, and a formal government investigation with facts and a public hearing is boring and takes way too long. And we seem to be in more of a feelings don't care about your facts style of governance at this point. And on the 2024 campaign trail, Trump leaned hard into tariffs.
I said, if I run this country, if I'm going to be president of this country, I'm going to put a 100, 200, 2,000% tariff. They're not going to sell one car into the United States, because we're not going to destroy our country.
One of his favorite mantras was about tariffs.
I always say tariffs is the most beautiful word to me in the dictionary.
And basically, tariffs will cure what ails us.
Because tariffs are going to make us rich as hell. It's going to bring our country's businesses back that left us.
And after the election, he promised to, quote, on January 20th, as one of my many first executive orders, I will sign all necessary documents to charge Mexico and Canada a 25% tariff on all products coming into the United States. And in early 2025, he claimed to have emergency powers to launch a series of dramatic tariffs. First came the so-called trafficking tariffs in February, putatively justified as a response to drug trafficking and border threats. These slapped a 25% duty on nearly all goods coming from Canada and Mexico, and a 10% duty on all Chinese products. A month later, tariffs on China were doubled to 20%, while small-value Canadian and Mexican imports were let back in duty-free. Then in April, the administration escalated with, quote, reciprocal tariffs, which the administration claimed were justified because other countries were putatively treating the U.S. unfairly by charging us higher tariffs than we were charging them and engaging in supposedly other unfair trade practices. In retaliation, the administration proposed a sweeping plan to impose a 10% baseline duty on almost all U.S. trading partners, with some countries facing rates of up to 50% to offset supposed trade deficits and other supposedly unfair practices. China was singled out for especially harsh treatment. Within days, its tariff rate soared to 84%, then to a staggering 125%, before later being dialed back to 10% after a diplomatic thaw. But what followed was a roller coaster of pauses and adjustments. Economists, corporate leaders, and policy wonks declared that this kind of instability would be bad for the economy, but the administration persisted. The end result was a patchwork of global tariffs that affected nearly every U.S. trade partner and swung wildly from punitive spikes to temporary reprieves, depending on Trump's mood and what supposedly sweet private deal the country offered him, though those deals were few and far between, and really none have been actually papered. The National Emergencies Act and the International Emergency Economic Powers Act, or IEPA. The National Emergencies Act was passed in 1976 to create structure and accountability around the president's use of emergency powers, and it allows the president to unlock certain special powers when he legally declares an emergency. But it also includes several important checks on that power, like requiring the regular reporting to Congress and setting an automatic expiration date for declared emergencies. And one of these special powers the NEA unlocks is IEPA. And once a national emergency has been declared under the NEA, IEPA gives the president special powers to deal with, quote, unusual and extraordinary threats from abroad. And as we've talked about many times, its core provision authorizes the president to, quote, regulate, direct, and compel, nullify, void, prevent, or prohibit a wide range of economic activities involving foreign entities, including imports and exports. Now, IEEPA has most often been used for sanctions, freezing assets, banning transactions, restricting trade with hostile nations or groups. And after September 11th, for example, President George W. Bush used IEEPA to blacklist terrorist groups and their backers, making sure U.S. money and resources wouldn't aid them. But no president has ever dared to use IEEPA to set sweeping tariffs. And so this was an entirely unprecedented power grab, which quickly inspired a flurry of lawsuits in courts around the country. So faced with an existential threat to their businesses, a group of companies filed suit in the Court of International Trade, the federal court that deals with this sort of subject area. And the plaintiffs argued that President Trump had exceeded his lawful authority because IEEPA doesn't authorize the president to impose tariffs at all, let alone sweeping unlimited ones like these. Plaintiffs also claim that IEEPA shouldn't have been triggered here because the statute requires a, quote, unusual or extraordinary threat, and longstanding trade deficits and supply chain issues just shouldn't cut it. And even if the law could be stretched to cover tariffs, the plaintiffs argued that would be unconstitutional because it would mean Congress handed over too much of its taxation and commerce power to the president. So under the major questions doctrine, if Congress wants to delegate these kinds of economically and politically significant powers, Congress must do that with clear, specific language, which IEEPA doesn't include. And because of the imminence of the tariffs and the existential threat to their businesses, plaintiffs asked the court to grant a temporary restraining order. Now, in response, the administration argued that the political questions doctrine bars the court from second-guessing the president's decision to declare a national emergency. But if the court did decide to hear the case, problems like trade deficits and supply chain risks count as the kind of serious threats that trigger IEEPA. And under IEEPA, once the president has declared an emergency, he has the power to control imports, which should include setting tariffs. And the administration pushed back on the plaintiff's use of the major questions doctrine because the major questions doctrine cannot be used against Republican presidents, only Democratic presidents. No, I'm just kidding. Although that is probably the case, it remains to be seen. But actually, they argued that it doesn't apply when the president is acting in areas like foreign affairs and national security. And even if it did apply, Congress already gave the president clear authority to use tariffs under IEEPA. And lastly, the government said the plaintiffs don't deserve an immediate court order stopping the tariffs because they haven't proven real harm yet, pointing out that none of them had actually paid the new duties at the time. But on May 28, 2025, a 3-judge panel of the Court of International Trade granted the plaintiffs' motion for a restraining order, finding that the tariffs exceeded the president's authority under IEEPA. The court agreed with plaintiffs that routine trade disparities and some drug trafficking issues, which are also sadly pretty routine, didn't really meet the definition of an emergency. And even if there was an emergency, the court found that the plain language of IEEPA didn't give the president authority to, quote, impose unlimited tariffs on goods from nearly every country in the world. The court then permanently enjoined the government from imposing these tariffs. The Trump administration appealed the same day and asked the Federal Circuit Court to stay the lower court's ruling. During the appeal, the Federal Circuit Court agreed to stay the Court of International Trade's ruling while it considered the case. And then it took the unusual step of deciding to hear the case en banc. En banc means that instead of a handful of judges, usually 3, the court's entire lineup of judges would hear the case, generally to make sure that a majority of the justices or judges in the Court of Appeals agrees with the verdict. Because if you only have 3 judges, you might get a wacky selection that comes up with a rule that not everyone would agree with. And this is typically reserved for cases of unusual importance and impact. And the parties reiterated their arguments, but the Trump administration upped the ante, claiming that if the court blocks the tariffs, it would basically be the end of the world. In a letter to the court, the Solicitor General, John Sauer, argued, quote, if the United States were forced to unwind these historic agreements, these are not actual agreements, but whatever. The president believes that a forced dissolution of the agreements could lead to a 1929-style result. In such a scenario, people would be forced from their homes, millions of jobs would be eliminated, hardworking Americans would lose their savings, and even Social Security and Medicare could be threatened. In short, the economic consequences would be ruinous instead of unprecedented success. Now, even if that were true, it would be a disaster of the administration's own making. The reason the administration supposedly needed these tariffs was because Trump and the Republican Congress wrote drastic sweeping tax cuts into the eponymous One Big Beautiful Bill. And even with the most generous estimate of the taxes that Americans would pay as a result of the tariffs, that would only partially make up for the shortfall created by the OBBB. But they planned to make up at least some of the shortfall with these questionably legal tariffs. But not surprisingly, the case attracted a huge number of amici, or friends of the court, to submit briefs, including senators, policy experts, scholars, and former government officials. And the Circuit Court was not swayed by the administration's proclamation of doom and gloom or their legal arguments. The Circuit Court began with a history lesson about tariffs. When the founders drafted the Constitution Constitution, they gave Congress the exclusive power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. This included the power to set tariffs. The founders vested this power in Congress explicitly because they were concerned about the president abusing his powers. When Patrick Henry worried that the president, quote, may easily become king, James Madison replied that this couldn't happen because the purse is in the hands of the representatives of the people. And for more than 100 years, tariffs were the country's main source of income. Then, in 1913, the 16th Amendment was ratified, giving Congress the power to set and collect income taxes, and the tariffs faded into the background. For most of the early history of the United States, Congress held on to its power to tax and set tariffs. Now, over time, Congress has delegated some of its authority to the executive branch, and in fact, one of the statutes that does this is the Trade Act of 1974, the statute that Trump relied on during his first term to put tariffs on China. But in the Trade Act and other statutes, Congress maintained its tariff power by setting strict limits on the president's authority in this area. These included requirements that the government conduct an investigation, give foreign powers a consultation, and take public comments before simply rolling out tariffs. And the Circuit Court pointed out that IEEPA is different from all of the statutes that delegated tariff power because IEEPA has none of those requirements. This raised red flags for the court because it makes it look like IEEPA is either not a delegation of tariff power at all, or is an unconstitutionally vague or broad one. Additionally, under the court-created major questions doctrine, which has recently been a favorite of conservative justices who want to curtail agency power, if Congress intends to delegate issues of, quote, vast economic and political significance to the executive branch, that delegation must be very explicit and give, quote, clear congressional authorization. And the Circuit Court concluded that IEEPA simply doesn't meet that standard. IEEPA states that once the president declares an emergency under the NEA, he may, quote, investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any acquisition, holding, withholding, use, transfer, withdrawal, transportation, importation, or exportation of any property in which any foreign country or national thereof has any interest by any person. The parties in the courts all zeroed in on one part of that admittedly convoluted phrase, that the president has the power to, quote, regulate importation. The Trump administration claimed that meant the president has the power to enact tariffs, even sweeping ones, without any additional congressional authorization or oversight. The plaintiffs argued there was no such power in the actual text of the statute, and the Circuit Court agreed with the plaintiffs. And as the Circuit Court pointed out, IEEPA never uses the word tariff or any synonyms like duty or tax. And Congress is clearly capable of using such clear terminology because it has in numerous other statutes. And a common understanding of the word regulate simply doesn't sweep in vast, seemingly boundless tariff power against basically every country in the world. Many agencies regulate, none unilaterally impose worldwide tariffs. And the Circuit Court pointed out that even the founders understood regulation and tariffs to be different things, because they're discussed in different sections of the Constitution. As the court held, quote, whenever Congress intends to delegate to the president the authority to impose tariffs, it does so explicitly, either by using unequivocal terms like tariff and duty, or via an overall structure which makes clear that Congress is referring to tariffs. The Circuit Court found that the best argument the Trump administration had managed to muster was based on a case called Yoshida International versus United States, a 50-year-old decision by the Circuit Court's predecessor, the Court of Customs and Patent Appeals, though that decision was not binding on the Circuit Court. Though it was a really interesting case. In 1971, facing a balance of payment crisis, President Nixon temporarily set aside the tariff agreements that had lowered statutory rates. This effectively resulted in a 10% temporary increase in some import duties. But this temporary duty was specifically set to not exceed the amounts set in the congressionally approved tariff schedules. And to do this, President Nixon did not use IEEPA, but the predecessor statute, the Trading with the Enemies Act, or TWEA, though it did include similar regulate importation language as in IEEPA. But the Court of Customs and Patent Appeals reversed the lower court's decision and ruled in favor of President Nixon. The court reasoned that the Trading with the Enemies Act broad emergency powers, including the authority to regulate importation, did encompass the limited power to impose a surcharge, provided it was appropriately and reasonably related to the declared emergency, it was temporary, and did not override Congress's tariff scheme. So while the Trading with the Enemies Act did have similar regulate importation language as IEEPA, the Circuit Court here easily distinguished Yoshida from the current case. First, in Yoshida 2, President Nixon's temporary duty increase was explicitly set to not exceed the tariffs already approved by Congress. Trump's 2025 tariffs, on the other hand, vastly increased tariffs far beyond congressionally approved schedules and directly contradict a whole raft of free trade agreements. Also, the tariffs in Yoshida 2 were time limited. Trump has set no time limit on the 2025 tariffs. And as the circuit court here noted, quote, Yoshida does not broadly conclude that regulate importation must be read to include any type of tariff imposition. In fact, it held the opposite. The Yoshida court expressly said that, quote, the executive does not here seek nor would it receive judicial approval of a wholesale delegation of legislative power. So in a way, the Trump administration was trying to claim that Yoshida stood for the exact opposite of what the case actually stood for. But I guess that's what you have to do when you have no actual legal arguments, or as the circuit court said, quote, a wafer-thin reed on which to rest such sweeping power. So the circuit court ruled against the Trump administration on the merits. The judges punted on the question of whether or not the lower court could impose an injunction. They asked the lower court to consider the recent shadow docket case Trump versus Casa, which appeared to eliminate the possibility of nationwide injunctions. Yes, the injunction in the lower court here came out before the Supreme Court sort of did away with nationwide injunctions. Now, it's still possible that all the tariffs will be enjoined, but it might need to be on a class-wide basis, meaning that the plaintiffs and the lower court will need to jump through some extra hoops to get the tariffs actually enjoined. Additionally, the opinion was not quite as broad as it could have been, possibly to avoid having the Supreme Court take up the case. The court stated, quote, we're not addressing whether the president's actions should have been taken as a matter of policy, nor are we deciding whether IEEPA authorizes any tariffs at all. Rather, the only issue we resolve on appeal is whether the trafficking tariffs and reciprocal tariffs imposed by the challenged executive orders are authorized under IEEPA. We conclude that they are not. And while the court says that they're not deciding whether IEEPA authorizes any tariffs at all, it's kind of hard to read this opinion any other way. So it'll be very interesting to see what the Supreme Court does here. The court could just simply not take the case up and let the opinion stand, or a particularly politically motivated Supreme Court might say, nope, Trump gets to do whatever he wants with tariffs. But at the moment, the Trump administration went absolutely apoplectic. They begged the circuit court to stay its ruling so they could appeal to the Supreme Court. Commerce Secretary Lutnick claimed that the ruling would, quote, cause massive irreparable harm to the United States and its foreign policy and national security, both now and in the future. Treasury Secretary Bessent argued that it would lead to, quote, dangerous diplomatic embarrassment, and Secretary of State Rubio claimed this would even hurt the Ukraine war negotiations. President Trump took to Truth Social to post a characteristically restrained response, proclaiming that, quote, if allowed to stand, this decision would literally destroy the United States of America. And as promised, the administration appealed to the Supreme Court. And according to President Trump and his lawyers, quote, 1 year ago, the United States was a dead country, and now, because of the trillions of dollars being paid by countries that have so badly abused us, America is a strong, financially viable, and respected country again. Now, I'll leave you to consider whether you think the United States is more respected than it was a year ago, but the Supreme Court has agreed to review the case on an expedited basis, and briefs are due in a couple of weeks, which is lightning fast for the Supreme Court, which is galling in its own right because the Supreme Court, when it wants to, can move really fast. And when it doesn't want to, as in the case of the president's immunity case, which took basically 2 years, well, they'll just go with the regular course. But tariffs are important enough to take them on an expedited basis. So the ball is in your court again, Chief Justice Roberts. But if the Supreme Court does affirm the circuit court's decision and invalidates the tariffs, well, then you're probably going to want a good lawyer to get your refund from the tariffs back. Luckily, I know a guy.
Lindsay Halligan is an insurance lawyer with no experience as a prosecutor. Donald Trump handpicked her to lead his political revenge tour in the justice system, and it just imploded. I know because I was in the room where it happened. Turns out former FBI Director James Comey may have never actually been indicted. This was such a shocking revelation that I felt cosmically compelled to memorialize the hearing in a courtroom sketch. Yeah, that's real, I did that. I mean, who needs cameras in the courtroom when you've got that? But this bombshell is not the only problem the prosecution is facing. In just a few weeks, Halligan managed to rack up more catastrophic legal oopsies than most prosecutors see in an entire career. She discussed sensitive case information with a legal journalist. A magistrate judge accused her office of, quote, indict first, investigate later. There's a looming ruling that could toss the case for vindictive prosecution. And now there's the mind-melting possibility that the final indictment against former FBI Director James Comey was never actually voted on by the grand jury, potentially invalidating it. Halligan's case against Trump's #1 political target didn't just go off the rails, it went into the ravine and exploded in the flames of incompetence. So, let's break down Lindsay Halligan's no good, bigly bad week. We've all seen the headlines, James Comey indicted on criminal charges. But here's a question, was he? Because after last week's hearing, there is a very real possibility that the answer is no, not legally, not at all. To indict James Comey, Lindsay Halligan needed to convince 12 grand jurors out of a minimum of 16 that he probably committed a crime. Typically, that's not that hard for prosecutors to achieve. So, when she marched into the grand jury room, she brought a draft indictment with 3 possible counts. First, a false statements charge alleging Comey lied to Congress when he said he didn't remember being informed of a so-called Clinton plan to tie Trump to Russia. Second, a false statements charge alleging Comey lied when he said he never authorized someone at the FBI to speak anonymously to reporters. Third, obstruction of justice. But when the grand jury foreperson returned the paperwork in open court, things got really weird. 2 different indictments were handed up to the judge. Indictment number 1 was a 3-count indictment with a report saying that the grand jury, quote, did not find an indictment in this case. In grand jury terms, that means a no bill, as in the grand jurors rejected it. Indictment number 2 was a separate 2-count indictment, which was marked as a true bill, which is grand jury speak for, we voted on this version and found probable cause to indict. The magistrate judge was baffled by this. Nothing on indictment number 1, the 3-count version, indicated that only count 1 had failed. Instead, it looked like the grand jury rejected all 3 charges. The foreperson had to handwrite an annotation on the spot, clarifying that only count 1 was a no bill on that indictment. The magistrate ended up accepting indictment number 2, the one with only 2 counts on it. So this was all just a simple clerical error, and the 2-count indictment that the magistrate actually accepted is still legal, right? Maybe not. Well, this is actually uncharted territory, and it could lead to the whole case getting tossed. All of this came to a head when Judge Nachmanoff held a hearing on Comey's motion to dismiss for vindictive prosecution. And I was there to watch it all go down. Here's what happened. Halligan entered the courtroom with her 2 reinforcements from North Carolina, Assistant United States Attorneys Tyler Lemons and Gabriel Diaz. Comey arrived with legal heavyweights Michael Dreeben and Pat Fitzgerald. These guys are absolute legends in the world of federal criminal defense. Seriously, Google them. Meanwhile, I'm sitting in the gallery watching what feels like a lawyer WWE smackdown. Team Comey's argument was strong and straightforward. He claims the prosecution only exists because the president hates his f***ing guts. And that's pretty hard to argue with. The man does have a decade's worth of presidential tweets to back it all up. In response, Lemons, the guy arguing for the government, did everything he could to lean on the supposed legitimacy of the grand jury. He emphasized, quote, a grand jury of the defendant's peers indicted him, not the U.S. attorney, and certainly not the president. That's when Judge Nachmanoff asked what should have been a simple procedural question. Was the 2-count indictment ever shown to the grand jury and voted on in the grand jury room?
That is when Tyler Lemons, the prosecutor, standing next to Lindsay Halligan, the U.S. attorney who was also seated at a counsel table, says, standing in front of you right now, no.
Translation, the 2-count indictment, the only indictment Comey is facing, was never shown to the full grand jury. It was never voted on. It appears to have been simply signed in the courtroom during the return of the indictment. So my eyes immediately go to Lindsay Halligan, who just sits there silently without disputing any of this. And if this is true, then the indictment against James Comey was maybe never properly returned under the Fifth Amendment. And that's bad news bears for Halligan and Trump because the statute of limitations expired a while ago, which means the government cannot re-indict Comey if the case gets tossed out. So this isn't just a screw up because of a typo. This is a prosecutorial extinction level event. And the government's response did not help. In the immediate aftermath of this hearing, Halligan tried to limit the damage. Later that same day, prosecutors filed a letter saying Halligan had presented a 3-count indictment. The foreperson reported that jurors did not indict Comey on count 1. The foreperson also signed a 2-count indictment reflecting the charges the grand jury supposedly approved. And the surviving 2 counts were identical to the original counts 2 and 3, just renumbered and on a new document. Confused? I was, and so was the court. And this still didn't show that the full grand jury ever saw or voted on the actual 2-count indictment filed with the court. Then, the very next day, Halligan and Lemons abruptly reversed course. In a filing titled Government's Notice Correcting the Record, they suddenly claimed the grand jury did vote on the true billed 2-count indictment. It was essentially an attempt to unsay what they had clearly said in open court just one day earlier. So how did the Comey case get so catastrophically messed up that we're now unsure whether an indictment even exists? To answer that, we need to rewind a little bit. Okay, let's set the scene for this mess. Back in September, Trump pressured U.S. Attorney Eric Siebert to file criminal charges against Comey. Siebert refused because there was no there, and he was forced to resign. Trump then plucked Lindsay Halligan from her White House job de-wokeifying the pandas, don't ask, and installed her as the new U.S. Attorney for the Eastern District of Virginia. That's one of the most important prosecutor's offices in the country, and within a week on the job, Halligan dove straight into carrying out boss man's orders, charged James Comey with crimes. Any crimes. There was one teensy tiny little problem. The statute of limitations was about to expire, and no career prosecutor in the entire office would touch this case with a 40-foot pole. So Halligan took matters into her own hands. She charged into the grand jury room herself and somehow convinced the jurors to return what appeared to be an indictment. It alleged Comey lied to Congress during his September 30th, 2020 Senate judiciary testimony, and that he committed obstruction of justice during that same testimony. According to prosecutors, Comey testified that he had, quote,
"Have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton investigation?"
No.
The government insists this was a big fat lie. They believe Comey really did authorize someone at the FBI to be an anonymous source. This guy, Dan Richman. Richman is a Columbia Law professor, former federal prosecutor, longtime friend of Comey, and, at one point, a special government employee advising the FBI on encryption issues. He was also, crucially, Comey's personal attorney. Richman officially resigned from his FBI SGE role on February 7th, 2017. That date, extremely important. Circle it, highlight it, tattoo on your heart, because 3 of the 4 communications that the government based their case on happened after Richman resigned on that magic date, February 7th, 2017. So he literally can't be the mythical FBI guy at the FBI because he was no longer employed at the FBI. Sorry. And the one remaining 2016 email thread, as I reported for Lawfare, internal FBI records strongly suggest Richman's SGE status had already lapsed by then. That means Richman probably was not employed at the FBI during any of the communications that the government relies on in their case against Comey. And that's kind of a problem, kiddo. Like, your entire case is built on a fiction problem. Because if Richman wasn't at the FBI, then Comey didn't lie when he said he'd never authorized someone at the FBI to be an anonymous source. And we're not even done there. The 4 sets of communications prosecutors cite, none of them actually show Comey authorizing Richman to serve as an anonymous media source about the Clinton investigation. So that raises the obvious question. Where exactly is the lie Comey told? I've been looking and I cannot find it. And here's the wild part. As bad as all of this is, and it is bad, it's still not Lindsay Halligan's biggest problem. With the government's core theory hanging by a thread, you would think the prosecution would move carefully, methodically even. But dear viewer, I'm here to tell you they did not. That brings us to Halligan's no good, very bigly bad week, and it all starts with this guy, Judge William Fitzpatrick. Now, Fitzpatrick isn't actually the presiding judge in the Comey case. That's this guy, District Judge Michael Nachmanoff. Fitzpatrick is a former federal prosecutor who was appointed as a magistrate judge in 2022. As a magistrate judge, Fitzpatrick handles the less glamorous but structurally important work like warrants and discovery disputes, so trial judges like Nachmanoff can focus on the avalanche of major motions Comey's team has filed. Selective and vindictive prosecution, literal truth, fundamental ambiguity, unlawful appointment, the full buffet. That's probably why Nachmanoff sent what seemed like a routine issue to Fitzpatrick. The government's request for a filter protocol to review potentially privileged materials seized from Dan Richman years earlier during a leak investigation called Arctic Haze. A filter protocol is a process for separating attorney-client privilege material so that prosecutors don't see anything they're not legally allowed to review. The Arctic Haze probe was an FBI investigation into how classified details about its earlier investigation into Hillary Clinton's use of a private email server ended up in a 2017 New York Times article. Since the article quoted Richmond by name, the FBI scooped up a sprawling set of data from his electronic devices. Think emails, texts, documents, memos, maybe even a selfie or two. Now, investigators cleared Richmond and Comey, and they also shut down the probe in 2021. But prosecutors held on to the trove of data they had from Richmond, and they later went digging through it again, searching for anything that might support their theory that Comey lied. But remember, Richmond was Comey's attorney, and attorney-client privilege is a thing that exists. Comey never got an opportunity to assert his claims of privilege over these materials. The government even admitted this at one point. That's a problem for their case. Why? Well, for one thing, attorney-client privilege material can't be used at trial. But more importantly, it's a big legal and ethical no-no for prosecutors to knowingly pilfer through a defendant's privileged communications. So a whole lot of what's in these documents could turn out to be privileged communications between an attorney and a client. At some point during its review of the materials, Halligan's team suddenly realized that they were dealing with potentially privileged materials. But they really wanted to keep looking through those documents, just in case there's a smoking gun or something. So they filed a motion asking the court to implement a filter protocol so that they can review and segregate these privileged materials. In response, Comey's team basically said, "Whoa, hold up, you're putting the cart before the horse there, bud." They argued that questions surrounding the legality of the government's access to and use of these materials has to be resolved before any filter protocol is authorized. The defense raised two main concerns to that end. First, they argued that the government may have blown past the Fourth Amendment's particularity requirement. The original warrants for Richmond's devices only authorized searches for the Arctic Haze offenses, which were stealing government property or transmitting national defense information. But Comey isn't charged with either of those offenses. And prosecutors never bothered to get new warrants, yet Halligan's team dug through the material anyway. I guess they were operating on the warrants are just vibes theory of criminal prosecution. The second argument from Team Comey warned that a case agent who testified before the grand jury may have been exposed to attorney-client privileged communications, or worse, that the government may have used privileged material in the grand jury presentation itself. Magistrate Fitzpatrick, a former federal prosecutor, found all of this deeply troubling. During a hearing on this issue, he called out Halligan's team for having a, quote, indict first, investigate later approach. That's never a phrase you want directed at you by a federal judge. Fitzpatrick then took the extraordinary step of ordering the grand jury transcripts turned over to the defense. Under Rule 6E, that only happens when there are concrete reasons to suspect irregularities serious enough to taint an indictment. And that almost never happens. But here, Fitzpatrick concluded that that threshold had been met. What the government did next was, in retrospect, a truly incredible legal own goal. Team Halligan asked Judge Fitzpatrick to review the grand jury testimony himself. They wanted him to do that because it would, quote, confirm the baselessness of the defendant's claim that privileged information may have been shared with the grand jury. So, Fitzpatrick reviewed the material and then, in a move that shocked exactly no one, he still ordered the government to fork over the transcripts. That much is unsurprising. What is remarkable, though, is this 24-page opinion Fitzpatrick issued explaining his order. In the opinion, which was issued on November 17th, he sets out a litany of concerns about what happened in front of the Comey grand jury. Those factual findings lead him to conclude that the government's actions, quote, raise genuine issues of misconduct that are inextricably linked to the government's grand jury presentation and deserve to be fully explored by the defense. So what did Fitzpatrick find? A hell of a lot, actually. So let's speedrun it. Prosecutors may have violated the Fourth Amendment's particularity requirement. The government didn't get a new warrant for the 2025 search. During the 2025 search, there appeared to be no precautions in place to avoid the collection of privileged communications. On 2 occasions, Lindsay Halligan appears to have misstated the law to the grand jury. Halligan suggested to the grand jury that Comey does not have a Fifth Amendment right to forego testifying at trial. He does. We teach this in 7th grade civics. Halligan clearly suggested to the grand jury that they did not have to rely exclusively on the record before them. They do. And the grand jury transcripts presented to the court seemed to be incomplete. That was a lot. A real potpourri of prosecutorial misconduct. After Fitzpatrick's 24-page judicial flamethrower, you'd think things had hit rock bottom for Halligan's prosecution of Comey. But no, things were about to get much worse. Judge Fitzpatrick's opinion was a roadmap for Judge Nachmanoff to consider whether the case should even survive. After detailing a, quote, disturbing pattern of profound investigative missteps, Judge Fitzpatrick ordered the government to turn over the grand jury transcripts so the defense could seek dismissal or suppression. Halligan immediately moved to block that order, and Judge Nachmanoff granted a temporary stay, leaving the issue unresolved for now. But Fitzpatrick also wrote in his order that if a second presentment to a grand jury did not take place after Team Halligan repackaged the indictment documents, then the court is in, quote, uncharted legal territory, and that the indictment returned in open court was not the same charging document presented to and deliberated upon by the grand jury. And all of that set the stage for our fateful day in Judge Nachmanoff's court, where we learned that the grand jury never even saw the final indictment documents. Make no mistake about it, Fitzpatrick is right. This is uncharted legal territory. So Judge Nachmanoff directed both parties to address Gaither versus United States, a 1969 D.C. Circuit case that deals with defective indictment procedures. Specifically, what happens when the foreperson signs something that wasn't actually voted on by the grand jury? Spoiler, the results don't really seem to be that great for the prosecution. The Fifth Amendment requires that prosecutors obtain a grand jury indictment in felony cases. And in Gaither, the court crafted a flat rule that grand jurors must see the full text of the indictment. But Gaither is a D.C. Circuit opinion, so it's not controlling precedent in the Eastern District of Virginia, which is where Comey's being prosecuted. Halligan, of course, disagreed that Gaither requires dismissal. In a filing, they wrote, quote, in Gaither, the grand jury never saw any version of the eventual indictment. In this case, the grand jury was provided the proposed indictment, deliberated, and determined that probable cause existed to believe that the defendant had committed the crimes charged in 2 counts. In other words, it's no big deal for her to edit the second indictment since the charges, quote, are identical to the second and third charges that were included in the proposed indictment that was provided to the grand jury. Halligan went on to say that the grand jury foreperson, as the representative of the grand jury, endorsed the revised 2-count indictment by signing it and explaining on the record in open court that the indictment reflected the vote of the grand jury. In other words, Team Halligan just made a little bit of a clerical error that doesn't prejudice Comey in any way. At least that seems to be what they're going with for right now. On the other hand, Comey's lawyers have not yet filed a brief detailing their take on how Gaither applies. But I'm calling it right now. They're going to file a motion to dismiss. At the hearing, one of Comey's lawyers, Michael Dreeben, argued, quote, if the operative indictment in this case was never shown to the grand jury, then no indictment was returned before the statute of limitations expired. And that would be a complete bar to further prosecution. And Dreeben's probably right. If Halligan really did bungle this in the grand jury room, then Comey isn't just not guilty. He's unprosecutable. Because the statute of limitations has already expired and there's nothing the government can do to fix it. So in the end, the legal reality might be this. James Comey was never charged with a crime. And Lindsay, if you want to talk to me about it, just text me.
Look, we've all been there. You're trash talking a friend, but you accidentally send the text straight to them. Instead of texting your boss goodbye, you say, I love you. You accidentally send all your active war plans to the editor-in-chief of The Atlantic. Whoopsie. Luckily, that party didn't make national security the cornerstone of their existence, because that would be awkward.
If there was anyone other than Hillary Clinton, they would be in jail right now.
But this month, the president's highly qualified team of national security experts got together on Signal for a super secret conversation about a military strike in Yemen. And they invited a journalist from The Atlantic into the text thread. No, this wasn't a rare effort to create more transparency by an administration that seems bent on secrecy, nor was it an effort to reach out to the so-called liberal media that Trump has banned from the White House press room. Instead, it was a colossal, monumental screw-up. Compliments of Michael Waltz, the president's national security advisor, and seemingly the entire Trump cabinet, including Secretary of Defense Pete Hegseth and Vice President J.D. Vance. This is a national embarrassment and an unbelievable breach of national security. So what happened and how illegal is it? Well, apparently on March 11th, Jeffrey Goldberg, the editor-in-chief of The Atlantic magazine, received a Signal chat invite from someone who shared a name with President Trump's national security advisor, Michael Waltz. Mr. Goldberg wasn't sure if it was really that Michael Waltz, but he was hopeful that it actually was the national security advisor and that Waltz might want to discuss Ukraine, Iran, or some other important national security-related matter. So Goldberg accepted the chat request. Jeffrey Goldberg had good reason to be skeptical that President Trump's national security advisor would reach out to him for a friendly chat because Mr. Goldberg has been the subject of Donald Trump's ire since at least 2020. In 2020, Mr. Goldberg attracted Trump's attention with a story he wrote reporting that Mr. Trump had called members of the American military who died in war suckers and losers. Then last year, Mr. Goldberg reported that Mr. Trump had said, quote, "I need the kind of generals that Hitler had." In response, then candidate Trump called The Atlantic a, quote, "failing magazine run by a guy named Goldberg." So it was weird that Waltz had reached out, but things were about to get weirder still. 2 days later, the person purporting to be Michael Waltz added Jeffrey Goldberg to a Signal group chat called Houthi PC Small Group. Now, first, a brief explanation about Signal. It is an open source encrypted messaging app popular with people who want more privacy than the average text messaging apps provide. It is not, however, approved by any government agency for the transmission of secret or classified information. Signal allows users to set deletion deadlines for text messages, so all messages will be automatically deleted once a specified amount of time has passed, which also makes it ill-suited for government work because deleting messages is a violation of federal records laws. But we'll talk more about that later. Now, soon after inviting Mr. Goldberg, the putative Michael Waltz texted the Houthi PC small group and said, quote, "Team establishing a principals group for coordination on Houthis." Waltz was presumably referring to a principals committee spelled PRINCIPALS, not PRINCIPLES, which is a group of the senior-most national security officials, including secretaries of defense, state, and the treasury, as well as the director of the CIA. But honestly, the typo was probably the least of their worries. If Waltz was looking to find principals LES in this administration, he's probably out of luck. But Waltz's statement about starting a principals group also raised red flags for Mr. Goldberg. As Goldberg pointed out in The Atlantic, quote, "It should go without saying, but I'll say it anyway, that I have never been invited to a White House Principals Committee meeting, and that in my many years of reporting on national security matters, I've never heard of one being convened over a commercial messaging app." Nonetheless, Waltz asked the other group members in the chat to identify the best people on their staff for Waltz to coordinate with. Mr. Goldberg watched as several group members, which appeared to include White House Deputy Chief of Staff Stephen Miller, Secretary of State Marco Rubio, Vice President J.D. Vance, I still can't believe it, Director of National Intelligence Tulsi Gabbard, Treasury Secretary Scott Bessent, Secretary of Defense Pete Hegseth, and numerous others chime in, volunteering various members on their staff. Even the director of the Central Intelligence Agency offered to name an active CIA intelligence officer. And Mr. Goldberg couldn't believe that the top national security officials would really engage in an unsecured group chat, let alone carelessly include a journalist in the chat, so he quite reasonably assumed that this was some kind of elaborate hoax or disinformation campaign. He watched, though, as a surreal policy conversation unfolded between these supposed Trump administration officials as they discussed on Signal how and when to stage an attack on the Houthis and how to message to the public about the attack. As a lawyer, one of the more interesting legal aspects of it is that Goldberg makes it clear throughout this article that at no time did he possess the requisite mens rea to be liable for possessing national security information himself. Obviously, a lawyer read this piece before it went live. But on the morning of March 14th, Michael Waltz texted the group stating, quote, "Team, you should have a statement of conclusions with taskings per the president's guidance this morning in your high-side inboxes." High-side, by the way, is a special segregated computer or communication system, which is specifically set up to manage classified or sensitive information. Unlike Signal, high-side systems must comply with the rigorous requirements and are specifically designed to protect sensitive information from cyber threats. So Waltz's message indicates that the information being discussed was sensitive enough to merit the use of these super secret secure computer systems. And we can surmise the president's high-side message apparently instructed the United States military to strike the Houthis, an Iran-backed terrorist organization that had been attacking cargo ships in the Red Sea. J.D. Vance, who so far publicly has made a point of genuflecting to everything that President Trump has said, interestingly appeared to actually disagree with the president's instruction. Vance responded, quote, "I think we are making a mistake," and quote, "I'm not sure the president is aware how inconsistent this is with his message on Europe right now." What Vance was referring to was Trump's policy of abandoning our European allies by refusing to provide any more American-funded support for them. Hegseth, the Secretary of Defense, disagreed with Vance, stating, quote, "If I had a final go or no-go vote, I believe we should." Vance replied saying, quote, "If you think we should do it, let's go. I just hate bailing Europe out again." As an aside, one of the most terrifying, but perhaps not strictly speaking, legal issues here is that these people are deciding to bomb another country, and they don't have clear instructions from the President of the United States. Not great. But Hegseth agreed with Vance's sentiments regarding America's European allies, proclaiming, quote, "VP, I fully share your loathing of European freeloading. It's pathetic. But Mike is correct, we are the only ones on the planet on our side of the ledger who can do this. Then SM, who Mr. Goldberg assumed was White House Deputy Chief of Staff Stephen Miller, chimed in stating, quote, "As I heard it, the president was clear, green light, but we should soon make clear to Egypt and Europe what we expect in return. We also need to figure out how to enforce such a requirement. E.g., if Europe doesn't remunerate, then what? If the US successfully restores freedom of navigation at great cost, there needs to be some further economic gain extracted in return." At this point, Mr. Goldberg says he still remained unconvinced that these were really the nation's top national security and defense officials arguing policy in a Signal chat without ever taking the time to consider who else was in the chat. The next day, though, Secretary of Defense Hegseth sent the Houthi PC small group chat a very specific message about the attack that would take place that afternoon in Yemen, including operational details like targets, weapons that would be deployed, and attack sequencing. Vice President Vance replied, quote, "I will say a prayer for victory." 2 hours later, at the time when Hegseth had specified the attacks would begin, Mr. Goldberg waited in his car at a grocery store parking lot. He checked Twitter and confirmed that at that moment explosions were being heard all across Sana'a, the capital city of Yemen. And back in the Houthi PC small group chat, the leaders of the US were celebrating with exclamations and emojis. They then moved on to discussing assessments of damage done, including the likely death of a specific individual. At this point, Mr. Goldberg had come to the startling conclusion that the Signal group chat really was populated by the leaders of US intelligence agencies who were openly discussing presumptively classified and sensitive national defense information on an unapproved channel. He removed himself from the group, which triggered an automatic notification to the group's creator, Michael Waltz. No one seemed to notice, and no one followed up with Mr. Goldberg about his presence and subsequent absence from the group. Mr. Goldberg later privately emailed several members of the group to inform them that he had been mistakenly included in the Signal chat and to ask about whether the chat was genuine. Brian Hughes, spokesman for the National Security Council, replied back saying, quote, "This appears to be an authentic message chain." Hughes tried to spin the story, arguing that, quote, "The thread is a demonstration of the deep and thoughtful policy coordination between senior officials." John Ratcliffe, head of the CIA, also later authenticated the text thread in a hearing before Congress.
So you were the John Ratcliffe on that chat?
I was.
Thank you, thank you.
And Secretary of Defense Pete Hegseth, who some have now started to call whiskey leaks, apparently did not get the memo the administration had owned up to the text chain because in a conversation with reporters, he said, quote,
"You're talking about a deceitful and highly discredited so-called journalist who's made a profession of peddling hoaxes time and time again. So this is the guy that peddles in garbage. And you see, we've been managing 4 years of deferred maintenance under the Trump administration."
And J.D. Vance's spokesperson confirmed that Vance had returned to his usual spineless fetal position, saying, quote, "Vice President Vance unequivocally supports this administration's foreign policy. The president and vice president have had subsequent conversations about this matter and are in complete agreement." And when asked about the Houthi PC small group chat in a meeting on March 24th, President Trump gave a characteristically thoughtful and level-headed response.
I don't know anything about it. I'm not a big fan of The Atlantic. To me, it's a magazine that's going out of business. I think it's not much of a magazine, but I know nothing about it.
And Mike Hotdog Man Waltz vowed to get to the bottom of how Goldberg could have possibly gotten on the text chain after Waltz had added him to the text chain.
It's embarrassing, yes. We're going to get to the bottom of it. I just talked to Elon on the way here. We've got the best technical minds looking at how this happened.
And it's me, Devin, from the future. Tulsi Gabbard testified under oath that there were no war plans discussed, and whatever was discussed wasn't classified. And White House spokesperson Caroline Leavitt also leaned into a typo-ridden response and claimed there were no war plans discussed, but she still objected to the release of the full text. So Jeffrey Goldberg just released the entire text message chain. And yeah, it's basically exactly what he described, inclusive of a whole bunch of classified top-secret war plans. As Goldberg wrote, on the day of the attack, Saturday, March 15th, the discussion veered toward the operational. At 11:45 a.m. Eastern Time, Hegseth posted in the chat, in all caps, "Team update." The text beneath this began, "Time now, 11:44 ET, weather is favorable, just confirmed with CENTCOM we are go for a mission launch." CENTCOM, or Central Command, is the military's combatant command for the Middle East. The Hegseth text continues, 12:45 ET, F-18's launch, first strike package. 13:45, trigger-based F-18 first strike window starts. Target terrorist is at his known location, so should be on time. Also, strike drones launch MQ-9s, and Goldberg opines, if this text has been received by someone hostile to American interests or someone merely indiscreet and with access to social media, the Houthis could have had time to prepare for what was meant to be a surprise attack on their strongholds. The consequences for American pilots could have been catastrophic. The Hegseth text then continued. 14:10, more F-18s launch, second strike package. 14:15, strike drones on target. This is when the first bombs will definitely drop, pending earlier trigger-based targets. 15:36, F-18 second strike starts. Also, first sea-based Tomahawks launched. More to follow per timeline. We are currently clean on OPSEC. Godspeed to our warriors. But to say this isn't classified or sensitive national defense information is to make the joke from Airplane real.
My orders came through. My squadron ships out tomorrow. We're bombing the storage depots at Daiquiri at 1800 hours. We're coming in from the north, below their radar.
When will you be back?
I can't tell you that. It's classified.
Following what are obviously war plans, there's a bunch of self-congratulation and real-time intelligence, including at 2 p.m. Walsh responds, the first target, their top missile guy, we had positive ID of him walking into his girlfriend's building. It's now collapsed. Vance responded a minute later, excellent. 35 minutes after that, Ratcliffe, the CIA director, wrote, a good start, which Waltz followed with a text containing a fist emoji, an American flag emoji, and a fire emoji. The Houthi-run Yemeni Health Ministry reported that at least 53 people were killed in the strikes, a number that has not been independently verified. Steve Witkoff replied, prayer emoji, arm emoji, American flag emoji, American flag emoji. The timing is also incredible. Goldberg released the first article the day of the Senate Intelligence Committee hearing on worldwide threats, which allowed Gabbard and Ratcliffe to be grilled just hours after the release. And because these are the dumbest people, their denials allowed Goldberg to release the full text chain the next morning and allow Gabbard and Ratcliffe to be grilled again in the second day of the hearing. And they did not disappoint.
So it's your testimony that less than 2 weeks ago, you were on a Signal chat that had all of this information about F-18s and MQ-9 Reapers and targets on strike, and you in that 2-week period simply forgot that that was there. That's your testimony?
My testimony is I did not recall the exact details of what was included there.
That was not your testimony. Your testimony was that you were not aware of anything related to weapons packages, targets, and timing.
But experts, lawmakers, and honestly anyone with a brain were very alarmed when Mr. Goldberg's story broke on The Atlantic because the unauthorized release of classified or sensitive material is a serious crime. As Signal chat participant and Director of National Intelligence, Tulsi Gabbard pointed out on Twitter just a few weeks ago. Now, there are two especially large legal issues with this Signal group chat. The first is the issue of carelessly sharing classified or sensitive information with an unvetted outsider. Now, I was surprised when I saw this story, so I reached out to our resident military law expert, Spencer the Scowlowl. Now, Spencer, you've been actively deployed in combat before, and you've actually ordered airstrikes yourself, right?
Yeah, Devin, that's correct. I was a JTAC in Western Iraq, and I dropped many warheads on ISIS foreheads.
And what are your thoughts here? Can you text active war plans to a journalist over an unsecured app on a personal phone? What the f? My thoughts exactly. Now, when the Trump National Security Team carelessly included Mr. Goldberg in their Signal chat, they likely violated the Espionage Act, which protects documents, materials, or information related to national defense. But don't worry, Donald Trump knows a thing or two about unauthorized disclosure of national defense information. Oh my God. But the Espionage Act, 18 U.S.C. Section 793F, makes it illegal for someone who lawfully possesses information relating to national defense to allow that information to be released through unauthorized parties through gross negligence. Michael Waltz carelessly added Mr. Goldberg to the group chat without ever bothering to confirm who he was or ask whether he was cleared to receive that information. That certainly seems grossly negligent. That same provision of law, section 793F, also specifies that if someone who lawfully possesses information relating to the national defense finds out that the information has been wrongly shared with an unauthorized person, they have to report that leak. It's notable that even after Mr. Goldberg emailed several of the people on the Houthi PC small group chat to inform them of his accidental inclusion, it doesn't appear as though anyone acted on the information. But they were legally obligated to under Section 793F. Both of these violations of 793F carry the possibility of a fine of up to 10 years of imprisonment. And in a contentious hearing the day after the Goldberg article came out, CIA Director John Ratcliffe confirmed that it was indeed him in that Signal chat. Director Ratcliffe, along with the Director of the Office of National Intelligence, I still can't believe it, Tulsi Gabbard, claimed that the information exchanged in that chat, which again included specific attack plans, wasn't classified, and thus none of this was a problem.
So my communications, to be clear, in a Signal message group were entirely permissible and lawful and did not include classified information.
Well, we will make that determination, because if it's not classified, share the text with the committee.
Now, that's not necessarily true, though, because neither provision of 793F requires that the leaked information be classified. The information just has to be related to the national defense. Specific times, dates, locations, and weapons used in attacks would certainly seem to fit into the ordinary understanding of sensitive information related to the national defense. Senators, including Senator Mark Warner, vice chair of the Senate Intelligence Committee, weren't buying their arguments.
There was no classified material that was shared in that
So then,
Signal
if there was no
chat.
classified material, share it with the committee. You can't have it both ways. These are important jobs. This is our national security. Bobbing and weaving and trying to, filibuster your answer. So please answer the question.
And the argument that improperly handled information wasn't actually classified has been tried before. By Hillary Clinton when the Republicans were hounding her about the emails before the 2016 election. So it's odd that Republicans are making the same argument now. And as Pete Hegseth pointed out during a 2016 appearance on Fox News,
if there was anyone other than Hillary Clinton, they would be in jail right now.
Marco Rubio, who also appeared to be included in the Houthi PC small group chat, also criticized Hillary Clinton for her information handling practices.
He was less than truthful about it repeatedly. And it goes to the issue of both competence and credibility. It is irresponsible for an elected official in her capacity to be discussing highly sensitive things on a format that she had to have known was not fully secured.
Now, the Espionage Act protects not only important national security interests, but also the lives of allies and members of the U.S. military and intelligence community. Military experts pointed at the obvious danger created by the Trump team's carelessness. The plans leaked by Secretary of Defense Hegseth contained details about attack locations and timing, which, had they fallen into enemy hands, could have put service members at risk. And the CIA director named an active CIA agent, which also could have put that person at risk. And Goldberg also refrained from publishing excerpts that he deemed particularly sensitive. And here Ratcliffe and Gabbard are seemingly daring him to release the rest of the text messages. Senator Jack Reed, ranking member of the Senate Armed Services Committee, said, quote, "If true, the story represents one of the most egregious failures of operational security and common sense I've ever seen. Military operations need to be handled with utmost discretion, using approved secure lines of communication, because American lives are on the line. The carelessness shown by President Trump's cabinet is stunning and dangerous. I will be seeking answers from the administration immediately." Senator Tammy Duckworth, a veteran, was unsparing in her criticism of Secretary of State Hegseth, in particular saying, quote, "Pete Hegseth, the most unqualified Secretary of Defense in history, is demonstrating his incompetence by literally leaking classified war plans in the group chat. Hegseth and Trump are making our country less safe." But that's not all. Now, the second legal issue raised by the Houthi PC small group Signal chat is the use of Signal at all for this purpose. The use of Signal itself potentially implicates another provision in the Espionage Act, 18 U.S.C. Section 793D, which makes it illegal for lawful possessors of national security information to willfully transmit that information in a way that could allow an unauthorized person to obtain it. Signal is known to be insecure. In fact, the Department of Defense recently issued a warning about Signal's insecurity. That warning stated explicitly that Signal can only be used for, quote, "unclassified accountability recall exercises, but are not approved to process or store non-public unclassified information. Typically, classified or sensitive information has to be conveyed only in high-side systems. And there are specific DoD platforms that are used for classified and secret communications. One, called the Joint Worldwide Intelligence Communications System, is a top-secret network used to gather and analyze data. The other, called the Secret Internet Protocol Router Network, is used for day-to-day communication and information sharing of secret information. The government has specifically designed systems for handling sensitive information because traditional cell phones are quite insecure. Foreign adversaries and hackers can use cell site simulators and other devices to collect cell phone data in transit. These devices have also been used by Russia to send threatening text messages to soldiers in Ukraine, to block phone use in British prisons, to track gang members in Canada, and allegedly to eavesdrop on protesters in Chicago. And whether Signal can even be installed on a government phone varies agency by agency. And certainly the use of Signal here seems to indicate that everyone on this chat was probably using a personal cell phone. And using regular smartphones to convey sensitive information exposes that information to foreign adversaries and hackers. That's why during the March 25th hearing, Senator Mike Bennett had a fiery exchange with CIA Director Ratcliffe about the fact that one of the people in the Houthi PC small group Signal chat was in Moscow at the time the chat was occurring.
Is it appropriate? Did you know that the president's Middle East advisor was in Moscow on this thread while you were, as director of the CIA, participating in this thread? Were you aware of that? Are you aware of that today?
I'm not aware of that today.
This sloppiness, this incompetence, this disrespect for our intelligence agencies and the personnel who work for them is entirely unacceptable. It's an embarrassment.
Senator,
you need to do better. You need to do better.
But using Signal wasn't just a problem from a national security standpoint, but also a record-keeping standpoint, especially since Michael Waltz set some of the messages in the Signal group to disappear after 1 week, and some after 4. Under the Federal Records Act, government records have to be retained for specified periods of time. Records created by senior decision-making officials often have to be permanently retained. And this is because they have great historical value and shed light on the essential activities of the government. The Presidential Record Act also requires record retention and only allows for the destruction of records belonging to the president and his immediate staff, like the vice president or deputy chief of staff, who were included in the Signal chat with the express written permission of the National Archivist. But I guess since Marco Rubio is technically acting as the National Archivist after Trump sacked the previous archivist, this is all totally fine. But given the insanity of this entire situation, I really wanted to talk to an expert. So I reached out to Kel McClanahan from National Security Counselors once again to get a gut check here. Now, is it illegal to include a journalist in your war planning Signal discussions?
You could say that. There are, of course, exceptions to including a journalist in classified discussions, such as if they're embedded, for instance, in the field, they have to know where they're going that day. But when you're talking about something like a Signal chat that is done in the United States, talking about bombing somebody else, there is no room for error in this. There's no law that would authorize this in any kind of chat. The fact that it was on Signal raises a host of different arguments over record keeping.
Okay, what laws were likely broken when this information was disclosed to Jeffrey Goldberg? And do the people on the Signal chat have the authority to disclose that information?
Now, that being said, what liability does Waltz have gets complicated because there are two possible crimes in play here. The one is sharing information with Jeffrey Goldberg. And that, for most of the Espionage Act, requires that it be knowing and willful, meaning that you know you're doing it. You cannot be sharing it with someone that you think is supposed to be there. That defeats the purpose. However, 18 U.S.C. 793F talks about gross negligence, about allowing information, national defense information, to be given to somebody through gross negligence and just being really bad at your job. That is what Waltz was doing. He shared information through gross negligence with Jeffrey Goldberg, and he allowed that information to be shared with Jeffrey Goldberg. Now, that does not give everybody else a pass, because the other part of 793F is that once you learn the information has been spilled, you have to report it. So after the fact, when Jeffrey Goldberg contacted them and said, hey, I was in that room, was this a real thing? And were these real plans that I was hearing? Every single person in that chat had a duty to go and report, hey, I think I gave classified information to Jeffrey Goldberg, or even national defense information, which doesn't have to be classified. So they're on the hook for that. Now, the second crime that Waltz could have committed is 793D. And 793D is when an authorized holder of classified information or national defense information disseminates it generally to a place that was not supposed to get it, but also disseminates it through a means that's not supposed to get it. So if you imagine that there are two coworkers in a classified facility and they go down the street to a restaurant for lunch, they go to an Outback Steakhouse, and they decide to talk about work at the table, they are violating 793D if they talk about national defense information over the lunch table, even if nobody is around, because they don't know for sure that nobody is listening. They don't know that there isn't a CCTV camera that can be capturing their words. They don't know for sure that they weren't followed there by a reporter or a Russian spy trying to eavesdrop on them. And so they have put the information out there into the universe in a facility that it was not protected from. Signal is just such a facility. You cannot talk about classified information over unsecure lines. You can't talk about classified information on the phone, on the cell phone, even on an encrypted cell phone. You have to talk about it on special lines that are set up, for instance, in the embassies and in the house of the SecDef and the house of the Secretary of State and the house of the Director of the CIA.
Let's talk about Signal. To me, one of the scariest things about this is that no one on the Signal chat said, hey, we should move this discussion to a secure channel. It really seems like they use Signal all the time. Is the use of Signal itself a violation of any laws? And putting aside the issues with Signal, does any of this comply with federal records keeping requirements?
So the standard for deciding whether or not you had the requisite sort of mental reasoning to commit the crime in the Espionage Act is not mens rea. It is more of this, you should have known better idea. It's called scienter, but we won't go into that. The idea that they would have to have known better than to use Signal would be critical if any of them were actually being prosecuted. And the answer is, yes, they should have known better than to use Signal. In fact, just last month, an email went out to every person in the DoD saying, don't use Signal. Signal has vulnerabilities. It is probably the most secure thing that we on the outside can use, but it's not secure enough for war plans. And so they should have known better than to use Signal, because at least Pete Hegseth received an email saying that he should have known better.
We've talked previously about Hillary's emails. Can you give us a quick refresh of that situation and how it compares to this one?
So Hillary Clinton had a private email. It was called clintonemail.com domain. And when she was Secretary of State, she stored emails on these. She received emails at this domain. And it was in a private server that was in her house. I believe it was in the basement. There was some to-do about this. People were asking, but what about her emails? And they were all extremely polite and thoughtful, as one would expect. And there were hearings before Congress. There were hearings before the media. There were speeches given by people running against her for president about how she should be locked up. And as a result of this thoughtful inquiry into her email server, she was not elected president of the United States. So that was what happened when you had some emails that were not known to be classified at the time, but were still arguably sensitive, were found on a device that was outside of the government control. This is text messages that are known to be sensitive, if not outright classified. I guarantee you that if people filed a FOIA request for these records, they would be denied as classified. In fact, I have done so for one of my clients. And regardless of what the White House press secretary says, they were not the type of thing that you blast into the open. So, yeah, they're a little different. The key difference, though, between the two scenarios is that one was heavily investigated and interrogated, and the other will probably not be. That's probably the biggest difference.
Why do we have laws like the Espionage Act that protect government secrecy?
For all that there's a ton of information overclassified and kept secret. And pretty much anyone who knows anything about anything will tell you that. There are still some things that we all agree should be kept secret. And that is because when you're talking about warfighters, when you're talking about military plans, when you're talking about nuclear weapon designs, when you're talking about what computers we have bugged in the Kremlin and what ministers we have on our payroll in the Ministry of State Security in China, those things need to be kept secret, because if they get out, people die.
What's the point of federal records retention laws?
The Freedom of Information Act, while not a records preservation law, is illustrative in this because the Supreme Court has said that the point of it is so that the people can know what their government is up to. That is critical in a democratic form of government. In a democracy, you have to know what your leaders are doing in your name. The flip side of that is if they destroy the records of what they are doing in your name, you can never know about it.
So here's a scary thought. Does any of this matter if the Trump administration just decides not to prosecute anyone?
As a legal matter, no. It will have no substantial effect whatsoever because the executive branch can prosecute or not prosecute. They can choose not to prosecute someone who is buds with the president, and they can choose to prosecute someone who is buds with the other guy. As a practical matter, it will be much more difficult going forward for people on the Republican side to continue to say how much they value classified information.
Thanks, Cal. As always, you can support the good work that the National Security Counselors are doing, including filing FOIAs and representing government whistleblowers, by clicking on the link below. Now, all this raises incredibly troubling questions, like what other meetings have they had outside of secure channels? Are there other instances where non-cleared individuals have been invited to classified or national security conversations? In the March 25th congressional hearing, the Trump administration witnesses indicated that the National Security Council was looking into the matter, but it seemed unlikely that there will be any accountability. But hopefully Congress takes this issue up, as they promised in the hearing, and hopefully Kel gets access to a whole bunch of more messages and finds out if they were actually using their personal cell phones or not. If you ask President Trump, all he does is win, but his DOJ, not so much. It turns out that when you lay off the competent career staff and then fire all the ethical attorneys who refuse to do manifestly illegal and unethical stuff, you're not left with the best and brightest. And Trump's DOJ keeps stepping on rakes. Well, it's more like they step on a banana peel and then rakes, and then banana peels and rakes at the same time. Never has a topic been more appropriate for Liz Dye, our resident chaos lawyer.
Thanks, Devin. Attorney General Pam Bondi was sworn in on February 5th, and well, we're not saying it's been a shit show, but we're not saying it. Bondi's tenure as head of the Justice Department was marked by employee purges, a judicial contempt finding, missed deadlines, misfiled documents, and most of all, Fox News hits. Lots and lots of Fox hits.
DEA has seized over 21 million fentanyl pills. That's 21 million lives saved, in my opinion. We are going to prosecute you, and we are prosecuting you.
And okay, it's not unheard of for the AG to speak to the press, but Attorney General Bondi seems to be a lot more focused on selling the Trump administration's priorities on television than getting the law right. Here she is announcing that the DOJ filed charges against New York Governor Kathy Hochul and State Attorney General Letitia James.
We have filed charges against Kathy Hochul. We have filed charges against Letitia James and Mark Schroeder.
She did not file charges against Hochul and James. She filed a civil complaint because New York refused to let the federal government go trawling through its driver's license database in search of undocumented immigrants. That complaint makes the truly bizarre claim that the state of New York is actually discriminating against the federal government by refusing to hand over data on undocumented immigrants who get driver's licenses. That case has not yet been decided, but thanks to the 10th Amendment's anti-commandeering doctrine, the federal government cannot force states to expend resources to carry out federal law enforcement. That's why the Supreme Court put the kibosh on gun background checks when the Clinton administration ordered states to do them at point of sale. And okay, this Supreme Court has been pretty good at finding a way to give President Trump whatever he wants, but still, Bondi's announcement that she charged New York officials was utter nonsense, and that's not the only thing she's confused about. There's a lot. So maybe it's best to tackle this one regionally. Okay, since we're already in New York not charging the governor and the AG, let's talk about the criminal case against New York City Mayor Eric Adams. Adams was indicted in September of 2024 and charged with bribery and wire fraud. The case was set to go to trial in April, but in February, the government moved to dismiss the case. The New York Times published internal communication showing Emile Beauvais, the number 3 guy at the Justice Department, ordering the acting U.S. Attorney for the Southern District of New York, Danielle Sassoon, to temporarily uncharge Adams so the administration could leverage the politician to enact their immigration agenda. Remember, feds can't force New York to do its bidding, but if the mayor is worried that if he doesn't give the president what he wants, he'll get reindicted, you can get around that pesky 10th Amendment problem. Sassoon resigned rather than carry out that corrupt order, and her deputy, Hagan Scotton, refused to sign it either, writing in a mic drop letter, "I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion, but it was never going to be me." Beauvais, whose last gig was as Donald Trump's personal lawyer, reportedly locked a bunch of prosecutors in a room and threatened to fire them all if someone from SDNY didn't put their name on his facially corrupt dismissal motion. After a couple of hours, one of the more senior lawyers did it to spare his younger colleagues. But then the Trump administration trotted Adams out on Fox so that immigration czar Tom Homan could brag about the deal that would allow him to get up Adams' butt if he didn't cooperate on immigration, which did not make the thing reek less of corruption.
And we were able to get in the room and really articulate what are my powers, what are my authorities, and what are some of the things that we need to legislatively address that is preventing us from doing what we want to do.
Judge Dale Ho called it fundamentally incompatible with the basic premise of equal justice under the law to allow the government to threaten criminal prosecution as a means of controlling the leader of the biggest city in America. The judge dismissed the case against Adams with prejudice, meaning it cannot be refiled. The whole thing was an absolute black eye for the Justice Department, which lost several highly experienced prosecutors, including 3 who published a joint letter in April refusing to confess wrongdoing when there was none as a condition of getting their jobs back. And the DOJ wasn't done shedding lawyers either. New York's Metropolitan Transit Authority is in a legal battle with the Trump administration over congestion pricing in Manhattan. Basically, it was a pilot program approved under President Biden, but 5 minutes after being sworn in, Transportation Secretary Sean Duffy announced that he was terminating it. Then he headed over to Fox to explain that he was saving the world from the dangers of public transit.
If you want people to ride public transportation, Governor Hochul, then make public transportation beautiful. Make it safe. Felony crime on the subway is up 9% this year alone.
Duffy took it for granted that the Justice Department would back-formulate a rationale, and they have been doing their level best, but in an internal memo, they warned of considerable litigation risk because, 1, the law is not on the government's side, and 2, the plaintiffs here are likely to ask for and get internal Transportation Department communications and possibly a deposition of Secretary Duffy himself. Now, normally, we would never see a document like this because it is attorney-client privileged, but at 9 p.m. on April 11th, it appeared on the public docket. That was clearly an accident. The right document, which was another nasty letter from Duffy to Governor Hochul threatening to withhold all federal highway money, appeared moments later on the docket. And look, you can see how that kind of thing might happen. There have been mass layoffs, and the people left at DOJ are super overworked defending the administration in hundreds of lawsuits. But that did not stop Transportation Department spokeswoman Haley Dobbins attacking those lawyers publicly. She said, are SDNY lawyers on this case incompetent, or was this their attempt to resist? At the very least, it's legal malpractice. It's sad to see a premier legal organization continue to fall into such disgrace. And by the way, the Transportation Department said that it was sidelining the lawyers who drafted that memo to Duffy, but a month later, their names are still on court filings, maybe because there's no one left there to replace them with. Side note, Secretary Duffy got his start as a cast member on the 6th season of MTV's The Real World.
And all of a sudden I see Montana looking at me like she's gonna unzip her vest and show me her boobies.
He later starred on Road Rules All-Stars, which is how he's qualified to be Transportation Secretary, obviously. Meanwhile, AG Bondi's media habits continue to be a problem for her department. In the Luigi Mangione case, she put out a statement on April 1 saying that she directed federal prosecutors to seek the death penalty and calling the killing an act of political violence because Mangione targeted a healthcare executive. At that point, Mangione hadn't even been indicted federally, although he was facing state charges in New York. Mangione's lawyers accused Bondi of deliberately tainting the jury pool and violating the Justice Department's own rules on how and when to seek the death penalty. TLDR, it involves a deliberative process in which they consider all mitigating factors, not a press release by the Attorney General before the defendant has even been charged. Mangione moved to take the death penalty off the table because of Bondi's big mouth. As of this recording, that issue is still being briefed. And before we leave New York, let's talk about one more case of what appears to be spectacular overreach by Emile Beauvais. The New York Times has a wild story about Beauvais ordering prosecutors to seek a warrant for the membership list of the pro-Palestinian student group Columbia University Apartheid Divest. He planned to give that membership list to ICE so that any immigrants exercising their First Amendment rights could be deported. But to get a warrant, you have to demonstrate probable cause that you'll discover evidence of a crime, and protesting is not it, which is probably why nobody from SDNY would put their name on this warrant application. Pro tip. Always look at the signature block on the filings. If the case is filed in, say, New York, and the only lawyers willing to sign their names to it are working out of Main Justice in D.C., it's probably a sign that whatever's in the document is hinky. So here's the signature page from the motion to dismiss the case against Eric Adams. See how it's signed by 2 lawyers from the criminal division and Beauvais himself, but no one from New York? That's weird. And it's one of the reasons Magistrate Judge Sarah Netburn rejected the warrant application for information on the Columbia student protest group. Bovee then ordered the Justice Department to appeal to a U.S. District Court judge, which is, again, super weird. So then Judge John Keltel sent it back to the magistrate to reconsider, at which point Magistrate Netburn not only rejected the request for a search warrant, but she also ordered the government to abide by a special condition. Should prosecutors ever try to refile such an application before another federal judge, they had to include a transcript of the sealed discussions in her court. But Bovee wasn't done. He ordered FBI agents to suit up in flak jackets and go stand near protesters in a phalanx formation in a clear attempt to intimidate those protesters. The New York Times notes that the FBI agents did not make any such show of force, maybe because they didn't want to wind up being deposed in a civil rights suit if things went sideways. But Bovee looks like a paragon of competence compared to the guy they've got running the U.S. Attorney's office in D.C. Oh, Ed Martin. There is a reason we made a video calling him Trump's worst lawyer. Okay, let's see how many Ed Martin scandals we can get into the next 90 seconds. Number one, he started his tenure by firing a bunch of seasoned prosecutors who worked on the January 6 cases and demoting others to misdemeanor intake, work so far below their pay grade that it was clear he hoped they'd quit. He also said he was launching an investigation of lawyers who worked on those cases. He followed that up by trying to launch a criminal investigation into recipients of congressionally allocated climate funds. First, he hounded a seasoned prosecutor into resigning because she refused to sign a warrant to seize the money from Citibank, because there was no probable cause to think that the grant recipients had committed a crime. Then he tried and failed to get that warrant himself. See, Emile Beauvais, it happens to lots of guys. Martin tried and failed to get someone at Maine Justice to bite on his big plan to indict Senator Chuck Schumer and Representative Brad Garcia for saying that Democrats ought to toughen up and fight, and for calling Elon Musk a dick. He called that operation Whirlwind. He also sent nasty letters to Georgetown University Law Center for teaching and promoting DEI, 4 medical periodicals, including the Journal of the American Medical Association, the New England Journal of Medicine, Obstetrics and Gynecology, and Chest, which is published by the American College of Chest Physicians, Wikipedia for abusing its nonprofit status and corrupting the AI by allowing it to scrape woke copy, medical marijuana vendors, people who publish the names of the Doge Bros currently tearing down the federal government. Shh, don't tell him those kids were on TV the other day. Has he threatened us yet? We should check that one after we go off the air. Phew, I think we made it. Hi, this is Liz from the future. Liz from the past is pretty sure that Ed Martin does not have the votes to get confirmed in the Senate by May 20th when his interim appointment runs out. What she does not know is that Trump will replace Martin with Fox News commentator Jeanine Pirro. She goes by Judge Jeanine, although she hasn't been a judge since the early 1990s. She did, however, work as a prosecutor in New York, although not in the last 20 years. But she is very tight with the entire Trump clan, and she does have some familiarity with civil litigation since the things she said on air played a big role in the defamation litigation filed by both Fox and Smartmatic after the 2020 election. So good luck with that, America.
Now, if you ever find yourself needing a good lawyer, you probably don't want to talk to any of these people at the DOJ. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got a data breach letter saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team.
Also in D.C., the Justice Department has been trying without success to defend President Trump's attacks on major American law firms. Judge Beryl Howell was astonished at the quality of lawyering in that case, and not in a good way. During a hearing, she slammed Assistant U.S. Attorney Richard Lawson for coming unprepared to answer questions about the deals struck by other law firms to get out from under Trump's sanctions. She said, not even knowing if they're written down is a pretty basic piece of information. And again, AG Pam Bondi's antics were not helping. When Judge Howell issued a temporary restraining order, she instructed the DOJ to issue written instructions to all the federal agencies telling them not to carry out Trump's attack on the law firm Perkins Coie. Bondi did do that in a memo accusing an unelected district court judge of invading the policymaking and free speech prerogatives of the executive branch and blatantly overstepping the judicial power. It's hard to convey how inappropriate that is from any officer of the court, much less the Attorney General of the United States. Howell herself called it a temper tantrum worthy of a 3-year-old. In that same case, the Justice Department demanded that Judge Howell recuse herself because she adjudicated several issues involving, quote, disgraced former prosecutor Jack Smith. The very first sentence of that recusal motion reads, fair proceedings free from any suggestion of impartiality are essential to the integrity of our country's judiciary. I think they mean partiality, not impartiality, because impartiality is the good one. Judge Howell denied the motion in a scathing order accusing the government of deploying the rhetorical strategy of ad hominem attack designed to impugn the integrity of the federal judicial system and blame any loss on the decision maker rather than fallacies in the substantive legal arguments presented. She said the department was spewing talking points more appropriate from a member of Congress than a legal brief from the United States Department of Justice. But it's the immigration cases where the Justice Department's total inability to litigate like normal people has been most on display. On April 16th, Judge James Boasberg found probable cause to believe that the government committed criminal contempt of court. It is hard to convey just how weird that sentence is. Courts are usually totally deferential to the government, but during a hearing on March 15th, Judge Boasberg asked Assistant U.S. Attorney Drew Ensign directly if any planes full of prisoners being deported under the Alien Enemies Act were scheduled to take off or were already in the air. When Ensign could not answer, Judge Boasberg stopped the hearing and told him to go find out. He said, inform your clients of the order immediately and notify them that if class members were on a plane that is going to take off or is in the air, those people need to be returned to the United States. However that's accomplished, whether turning around a plane or not disembarking everyone on the plane, I leave to you. But this is something that you need to make sure is complied with immediately. Ensign said that he was unable to reach the Department of Homeland Security, and as a result, the plane that was already in the sky did not turn around. And in fact, 2 more planes took off after the court's order. Now, I'm not saying that the government is lying here, but that hearing was on a public line, and I know that because I was listening, and so was every other legal reporter in the country. So the claim that the government didn't know about that ruling in real time kind of seems like bullshit, which is why the government is going to find itself on the pointy end of a contempt ruling if it doesn't get bailed out by the D.C. Circuit or the Supreme Court. And as the Washington Post notes, Judge Boasberg is not the only judge appalled by the DOJ's shoddy work. In Virginia, Judge Leonie Brinkema called the evidence presented by ICE and the DOJ the sorriest statement I've ever seen and a terrible, terrible affidavit. She said, if this were before me in a criminal case, I'd throw you out of my chambers. I expect more from the government than this kind of very shoddy work. That was in the case of a couple whom the Justice Department accused of being high-ranking members of the Venezuelan gang Tren de Aragua based on more or less nothing, and arrested them 4 times in a row. So now 4 judges have ordered this couple released from ICE custody, with the last, Judge David Briones in Texas, making a judicial finding that these poor people are not gang members and ordering the DOJ to quit arresting them. He added that this court takes clear offense to respondents wasting judicial resources. The government's conduct in the case of Kilmar Abrego Garcia has been so outrageous that we made 2 videos about it already. But lest we forget, the original lawyer arguing in that case, Erez Ruveni, admitted in open court that the government deported that guy accidentally, and so did Robert Cerna, the ICE field office director, in an affidavit. But when the White House dug in and refused to bring him back, the Justice Department decided it would just unsay all that. So Ruveni was fired along with his supervisor, August Flencia. Pam Bondi said that Ruveni failed to zealously advocate on behalf of the United States, and any attorney who fails to live up to her standards will face consequences. So goodbye to another 2 DOJ lawyers with decades of experience. We could read judicial orders yelling at the Trump DOJ for another hour, but let's talk for a second about an issue that's not getting a lot of attention. In fact, the only way we know about it is from a series of TikToks by an attorney named Liz Oyer. Oyer was a former Justice Department lawyer who worked in the Office of Presidential Pardons. She says she was fired because she refused to recommend that Mel Gibson's gun rights be restored. The actor lost his right to own a gun in 2011 after pleading no contest to punching his girlfriend while she was holding their baby. But Gibson is a Trump supporter. And so the White House figured that was enough reason to make an exception to the law preventing domestic abusers from owning a firearm. When Oyer refused to write a memo endorsing it because the statutory guidelines do not extend to cases like Gibson's, she was fired. But don't worry, Attorney General Pam Bondi made it happen for Gibson anyway. Oyer was set to testify about all that before Congress when the Trump administration threatened to send federal marshals to remind her of her confidentiality obligations. Oyer testified anyway, and then she started making the TikToks about all the money we've lost in civil and criminal asset forfeitures thanks to Trump's dashed-off pardons.
Hey everybody, you've asked for more information about the $1 billion worth of pardons granted by President Trump, and I am here to provide that. I'm Liz Oyer, former pardon attorney for the Department of Justice.
Because if you just pardon people who are nice to you or who donate money to your campaign, then it means the money they were supposed to pay in restitution doesn't get collected. So, for instance, convicted fraudster Trevor Milton donated $1.7 million to Trump's campaign in 2024. Prosecutors argued that he should pay $680 million in restitution to his victims, but thanks to a pardon from Trump in March, now he never will.
They say it was very unfair, and they say the thing that he did wrong was he was one of the first people that supported a gentleman named Donald Trump for president. He supported Trump. He liked Trump. I didn't know him, but he liked him.
Milton's lawyers on that case, by the way, were Michael Mukasey, who has also represented Trump, and Brad Bondi, the Attorney General's brother, the one who should very definitely not be head of the D.C. bar. But don't worry, AG Bondi has only been in office for 3 months. Pretty soon she'll hit her stride and it will all come together. Oh my God.